Good afternoon.
Good afternoon, Madam Chair.
Today is Thursday, February 28th. We're going to hear, I think, 14 bills today, 94 witnesses. I tell you that because I'm going to ask that you're going to have a 2-minute timer. You'll see lights on the table as well as a timer on the clock. I ask you to please adhere to that, and I will ask you to stop at the end of your sentence if you keep talking, because it's a lot of people to try to get through and to be considerate of other people that are waiting to testify. So we appreciate your presence today. I have a bill order which may change depending on which senators are here and if they're in other committees or senators that we're waiting for from other committees. So it's a lot of moving parts. But we're going to start today with Senate Bill 784 if Senator Jackson's here. That's his first bill. And then 696 is Senator Jackson. 741, 662, 589, 782, 143, 732, 605, 415, 594, 571, 504, and 616. So that's the expected order. Did I see someone representing Senator Jackson here? Are you going to present the bill? That's great. Let me see, do you have a, you have the Commissioner of Financial Regulation with you, Commissioner Salazar. There we go. So we're going to start with Senate Bill 784. Thank you.
Oh, great. Good afternoon, Chair Bidle, Vice Chair Hayes, fellow members. Not fellow members, that was for Senator Jackson, my apologies. Members of the Senate Finance Committee. My name is Brian Powell. I'm Senator Jackson's Chief of Staff, and I'm here to present Senate Bill 784, Financial Institutions Consumer Credit Application of Licensing Requirements. SB 784 is a crucial piece of legislation that clarifies and corrects Maryland's consumer credit licensing law. It resolves significant market confusion stemming from last year's cross-filed bills, SB 1026 and HB 1516. When both those bills passed in 2025, HB 1516, which was signed second by the governor, became the controlling law, enacted as Chapter 119. The confusion arises because a provision was removed from the final version of HB 1516, but inadvertently remained in the text of SB 1026. This has led to a discrepancy in published law. One major publisher included the obsolete provision, while another published the correct version. To address this, the Office of Financial Regulation has already issued guidance confirming that Chapter 119, the language of HB 1516, is the correct and controlling law. SB 784, the bill before you today, simply updates the Maryland Code to reflect the final enacted language of Chapter 119, permanently removing the obsolete provision that has caused market uncertainty. This is not a policy change. It's a technical correction that ensures clarity, consistency, and compliance within our consumer credit industry. It's essential for the smooth operation of Maryland's financial markets, and we request a favorable report.
Thank you. Commissioner Salazar, I see you're going to be with us for a while today.
Yes, I am.
Do you have anything additional to add to Senate Bill 784?
I do not. He covered it well.
All right. Do we have any questions for our sponsor or Commissioner Salazar? Seeing no questions, that ends the hearing on Senate Bill 784.
Thank you.
Yeah, it's a good start to the day. Are you also presenting Senate Bill 696 for Senator Jackson? Okay, thank you. You did such a good job on the first one. Thank you.
And I apologize, Madam Chair. You said 696? 696. Perfect. Perfect. Good afternoon again, everyone. I'm here for Senator Jackson to present Senate Bill 696. Let's see. This bill was introduced in consultation with the Senate President's Office and in direct response to what we are seeing occurring at the federal level. President Trump's Project 2025 plan has caused massive gaps in regulations that protect Maryland consumers. Part of that plan aims to abolish the Consumer Financial Protection Bureau, CFPB, and transfer those consumer protection responsibilities and functions to other federal banking regulators. After the 2008 financial collapse, which led to millions of people losing their homes through foreclosures, the Consumer Financial Protection Bureau was created to regulate risky financial behaviors that created the crisis. The CFPB is responsible for implementing and enforcing a wide range of federal consumer protection laws, as well as collecting consumer complaints related to financial products and services. It is structured as an independent bureau within the Federal Reserve and is funded outside of the normal congressional appropriations process. It serves as a single independent agency that focuses on consumer protection and prioritizes transparency so that consumers of financial products can make informed financial decisions. The CFPB also ensures proper regulation of nationally chartered banks and handles consumer protection violations so that financial instruments like mortgages and other consumer loans are founded in secure underwriting processes, keeping financial institutions accountable. To date, CFPB has recovered over $21 billion for consumers who have been impacted by fraud and unfair trade practices. So far, the One Big Beautiful Bill Act has significantly reduced funding for CFPB, hindering its ability to regulate financial institutions, and it's very possible that this is just the first step before abolishment. Maryland's proud to have strong consumer protection practices through the Office of the Attorney General Consumer Protection Division and Office of Financial Regulation. Unfortunately, the state does have limited authority to regulate nationally chartered banks. That is why the senator is sponsoring SB 696, which serves as a potential solution to some of the harm that would follow the abolishment of CFPB. As currently written, SB 696 requires the Office of Financial Regulation to establish and maintain a database for consumer complaints that are filed against financial institutions for unfair, deceptive, or abusive practices. It requires the office to publish an analysis of those complaints quarterly to keep track of different types of complaints. In consultation with the Office of Financial Regulation, they have asked for a few amendments, which we have requested, but we do not have yet available. And perhaps you can speak to that a little bit more, but they would ensure the publication of all complaints, not just those dealing with unfair, deceptive, or abusive practices. They would simplify the personally identifiable information protection process, and they would change the implementation date. We have requested those, but like I said, we're still waiting on those to get a few things worked out. So if the CFPB's complaints database stops being operational or being updated, establishing a consumer complaints database for Maryland residents through our Office of Financial Regulation will ensure that financial institutions are held publicly accountable and will help identify financial practices that harm Maryland residents. We request a favorable report. Thank you.
Thank you. Commissioner Salazar?
Thank you, Chair Beidle, Vice Chair Hayes, and committee members. I do have some comments. Tony Salazar, Commissioner of Financial Regulation. So as you heard, the bill mandates the creation of an online interface providing access to aggregated and anonymized complaints. OFR supports the goal of enhancing public access to complaint data, and we currently publish complaint data each year in our publicly available annual report. However, developing a new web interface presents a significant challenge because OFR has no IT staff. That means that all the technical work and the project oversight has to fall on the Department of Labor's IT office or another vendor if they can't handle it in light of their commitments. So in either case, OFR has to pay for the cost of the project. Implementing the bill will also be labor intensive because in order to protect the consumer privacy of the complainants, OFR staff would need to carefully review all the complaints to ensure that the PII is removed before posting them. We receive over 1,000 complaints annually, and the PII scrubbing, which is highly demanding work, will consume extra hours. So if we're to protect the PII without reducing our existing consumer protection work, we'll need some additional staff. The bill also applies to complaints alleging unfair and abusive and deceptive trade practices, but the complaints that come into us typically don't use that language. So we believe, as Brian mentioned, that those concerns can be alleviated through some amendments that ensure the publication of all the complaints, simplify the PII protection process, and establish a little more realistic date, which I understand they can put in the uncodified language. And then lastly, we're also asking to amend the bill to enshrine protections from the Equal Credit Opportunity Act, which have been changed at the federal level and follow with the Senate President's approach. So because the Senate Bill 696 enhances consumer access to complaint data, we believe that's a goal that can be accomplished with some modifications, and we request a favorable committee report on the bill with the proposed amendments. And I welcome any questions.
Thank you, Commissioner. So what you just suggested, does that reduce the fiscal note? I mean, reduce, you were saying you would need extra staff and,
You'd have to, yes, that was the intent, was to reduce them. It's not going to eliminate it, because if we're to do an online database, we have no IT staff, so and we're a fee for service, so we do it at the Department of Labor, or we pay outside.
Okay.
And that's just the way it is.
we have an issue this year with big physical notes. Thank you. We have two more people favorable, Robin McKinney and Jennifer Bevan-Dangle. Thank you.
Madam Chair, Mr. Vice Chair, members of the committee, I'm Robin McKinney with the Cash Campaign of Maryland. We help low-income people with their finances. It's really important that when people have a problem with their financial institution, they know where to report it. So with that, I urge a favorable report. Me too.
Madam Chair, members of the committee, my name is Jennifer Bevan-Dangle. I'm the Deputy Director of Economic Action Maryland Fund. We are one of those big dorks that uses the CFPB complaint database frequently, and we have been in a semi-state of panic at the thought that we might lose an incredible resource. The opportunity to create one at the state level would give a lot of comfort to us and to your consumers and constituents, who also, I am sure, spend countless hours in these databases. But these are an incredibly valuable consumer advocacy tool. They help flag systemic issues across the industry. And while we appreciate that we have a lot of this data in annual reports, the fact that those are not searchable really minimizes the utility of them. So for those and many more reasons I will not belabor here, we urge a favorable report.
Thank you. Any questions for this panel? I don't see any questions. Thank you very much. And then we have Evan Richards from the Maryland Bankers Association. He's favorable with amendment. Evan?
Thank you, Madam Chair, members of the committee. For the record, my name is Evan Richards. I'm the head of government community relations for the Maryland Bankers Association. You have my written testimony, so I won't belabor the points. There are two key points that we would like to raise here. One, if you were to check the annual reports for the Office of Financial Regulation for the past 3 years, the top complaint category within their jurisdiction, is in the mortgage space. And if you were to check the CFPB complaint portal for the top complaint category since its inception in 2011, it's credit reporting agencies. So the First Amendment that we'd like to see to the bill actually would expand the scope of the OFR's complaint portal to include all regulated entities through the Office of Financial Regulation to increase transparency across the entire Maryland financial services marketplace. And then finally, we do understand the fear of the CFPB complaint portal shutting down. We do believe, however, that if you have multiple complaint portals that folks are being sent to, it could create confusion not only for financial institutions and regulators, but consumers. We want to make sure that their complaints are being directed to the right place, and that way they're able to address in a timely fashion. So the second thing that we'd like to see is some contingency language that would implement this database upon the cessation of the CFPB database, and some technical language that would ensure that this database operates in a very similar manner to the CFPB database, to ensure that it doesn't just become a message board for complaints, but financial institutions and other regulated entities actually have the chance to respond before complaints are published, so that way we know that the correct regulator is solving the right problems. With that, I'd urge a favorable with amendments report. Thank you.
Thank you, Evan. Did you submit your amendment request in writing?
No, but I can.
Will you do that, please?
Yes, absolutely.
Thank you very much. Any questions for Evan? Okay, that ends the hearing on Senate Bill 696. Thank you.
Next, we'll hear Senate Bill 741, Financial Institutions and Activities, Virtual Currency Kiosk Alternatives. We'll hear from Chair Beidel, as well as Sarah Wesrick and Antonio Salazar.
Thank you. Thank you, Mr. Vice Chair and members of the Finance Committee. Thank you for hearing Senate Bill 741. This is a real easy bill. We passed a bill last year that said kiosks that are using virtual currency cannot also advertise ATM. And the biggest offender of the currency kiosk owned an they own ATM, and they also do virtual currency. So they continued to confuse people with an ATM machine, and people continued to be scammed. So this just says that it expands the definition of virtual currency kiosk operator and clarifies the term virtual currency service, as well as clearly states that the machines do not provide the same service as an ATM. It's that simple. I respectfully request a favorable report on Senate Bill 741. Thank you.
Good afternoon, Chair Vidal, and thank you for bringing this bill. Good afternoon, Vice Chair Hayes and members of the committee. Thank you for the opportunity to testify in support of SB 741, which strengthens Maryland's oversight of virtual currency kiosks. My name is Sarah Westrick. I'm the Advocacy Director for AARP Maryland, representing our 850,000 members in the state. We are deeply concerned about the growing risk posed by cryptocurrency kiosks, particularly for older adults. We appreciate the work done last year to regulate virtual currency kiosks and support this bill, which seeks to tighten key definitions. The kiosk industry has expanded rapidly, but many operators claim the new law doesn't apply to them. Senate Bill 741 closes that loophole by ensuring that both machine owners and the software operators behind them are regulated, so companies cannot evade responsibility through technicalities. SB 741 ensures kiosks are used only for virtual currency services and cannot function as unregulated ATMs, which often misleads consumers. The need for this bill is urgent. Across the country, the data show extreme fraud rates tied to these kiosks. In Washington, D.C., 93% of deposits into Athena Bitcoin kiosks were connected to scams targeting vulnerable and elderly residents. In Iowa, investigations found 98% of Bitcoin Depot transactions and 95% of CoinFlip transactions were tied to scams, contributing to over $20 million in losses, much of it affecting older adults. These are not isolated cases. They reflect a systemic pattern of operators profiting from transactions overwhelmingly driven by fraud. Given the overwhelming evidence of high fraud rates and consumer harm, Senate Bill 741 is a much-needed reform. AARP Maryland respectfully urges a favorable report. Thank you.
Vice Chair Hayes, thank you. Tony Salazar, Commissioner of Financial Regulation. Chair Beidel, thank you for bringing the bill. Appreciate it. It is needed. I'd urge support of the bill. Let me just bring a couple of points to the committee's floor. This bill went into effect last year, regulating these ATMs. OFR has been actively implementing the bill. We have 650 kiosks that have been registered so far. We're working diligently to ensure all the relevant entities comply with the existing requirements. We've also been reaching out to states' attorneys to make sure that they're aware of the requirements and we can follow up with the fraud. We've been working on the licensing requirements as well. And so the clarifications in SB 741 strengthen our office's ability to ensure the responsible use of these virtual currency kiosks. And more importantly, they are going to be an important step in helping Maryland residents safeguard from any potential fraud and abuse. So because of that, and it clarifies the language, as was pointed out, to avoid this loophole or claimed loophole, it doesn't have any fiscal impact, and we urge the committee to issue a favorable report. I'm happy to answer any questions.
Thank you so very much. Are there any questions for this panel? Seeing none, thank you so very much. This ends the bill hearing on Senate Bill 741. Next, we're going to hear Senate Bill 662, Financial Institutions Payment Stable Services, and we'll turn it from Senator Kramer and his panel. Back again, Tony Salazar, Michael Sprouse, Shafat Baglagon, I think. And we're going to turn it back over to Madam Chair.
Good afternoon, Madam Chair, Mr. Vice Chair. Ben Kramer here introducing Senate Bill 662. Colleagues, this bill authorizes the Maryland Department of Financial Regulation to establish regulations governing the transaction of stablecoins in our state. This is a timely, prudent, and forward-looking measure that positions Maryland to protect consumers while remaining competitive in a rapidly evolving financial marketplace. Stablecoin is a type of digital asset designed to maintain a stable value by being pegged to a reserve asset, most commonly the US dollar. Unlike cryptocurrencies such as Bitcoin, whose values fluctuate significantly, stablecoins are intended to maintain a one-to-one value with a reference currency and are typically backed by cash or cash equivalent reserves. Because of this stability, they are increasingly used for payments, settlement, remittances, and as a bridge between traditional finance and blockchain-based systems. Stablecoins are no longer theoretical. They are actively used by business, consumers, fintech firms, and financial institutions. But with innovation comes operational risk, liquidity risk, reserve transparency concerns, cybersecurity vulnerabilities, and the potential for fraud if not properly overseen. That is precisely why Senate Bill 662 matters. The federal government is actively developing a national framework for digital assets and stablecoins. As part of that process, states are being given a limited window of opportunity to establish regulatory regimes that meet baseline federal standards and preserve a meaningful role for state oversight. If Maryland does not act during this window, we risk ceding regulatory authority entirely to the federal government and losing our ability to shape how this market operates within our own state borders. This bill is not about overregulation, it is about authorization. It allows our own financial regulator, the Maryland Department of Financial Regulation, to develop thoughtful, transparent, and balanced rules tailored to our state's needs. It ensures clear consumer protections, reserve and disclosure standards, anti-money laundering and cybersecurity safeguards, and operational requirements for companies transacting in stablecoin. By providing regulatory clarity, Maryland will become more attractive to responsible fintech companies and innovators. Businesses seek predictable, well-defined regulatory environments. If we establish a clear framework, Maryland can compete with states that are already moving aggressively in this space. Failing to act would put us at a competitive disadvantage. States that adopt clear, stablecoin regulatory structures will attract capital, talent, and technological innovation. Those that do not will see companies organize elsewhere. In short, Senate Bill 662 defines and recognizes stablecoin as a growing financial instrument, protects Maryland consumers and businesses, preserves state authority during a limited federal window, and positions Maryland as competitive and forward-looking in digital finance. With that, I will turn it over to the panel, Madam Chair, and I will ask the committee not to ask me a single question about stablecoin. And with that, thank you.
Thank you, Senator Kramer. That was a great introduction to Senate Bill 662. Chair Beidel, Vice Chair Hayes, committee members, Tony Salazar, Commissioner of Financial Regulation, here with Deputy Commissioner Sprouse, who can answer questions, is willing to do that, Assistant Commissioner Balogun as well. The bill deals with stable coins, as we said, and that's a form of digital assets that has just become the subject of federal authorizing legislation. So through this bill, as the senator said, Maryland has the opportunity to bring the use of that innovative payment system to our state. It's legislation that's crucial for us to establish a framework. The recently enacted Genius Act created the federal framework, and now that act includes a pathway for the states to establish and supervise their own system. Maryland currently lacks that specific mechanism to charter institutions that wish to issue these stablecoins or to serve as their servicers. So that bill would designate OFR as the stablecoin regulator for the state and then create an appropriate charter and legal framework. This proactive approach allows Maryland to adapt to the evolving financial services ecosystem. We believe it'll foster innovation, and our bill here has consumer protection provisions. Under the Genius Act, as the senator mentioned, states can only charter and supervise stablecoin issuers if they receive approval of a newly created stablecoin certification review committee by mid-2027. Hence, the enactment of this bill in this legislative session will allow OFR to establish the necessary framework to submit that application in a timely manner. The bill should have a limited fiscal impact as we anticipate a multi-year implementation. It is an authorizing bill, and to the extent industry gets involved, they'll be subject to assessments to cover its costs. Thank you, Senator Kramer, for your partnership on this legislation, and I request a favorable report by the Committee on Senate Bill 662. I'll turn it over to Assistant Commissioner Balogun for a short statement as well.
Thank you, Commissioner. Good afternoon, Chair Beidel, Vice Chair Hayes, and committee members. Thank you for having us here today. My name is Sharifa Balogun, and I am the Assistant Commissioner for Innovation at the Office of Financial Regulation. I am here today to testify in support of Senate Bill 662. In my role, I oversee the supervision of money transmission businesses. I am also responsible for assessing financial innovations that promote a safe, inclusive, and forward-looking financial services environment in Maryland. I believe that passing this legislation to enable the creation of a Maryland-based stablecoin ecosystem meets those goals. Building upon the Commissioner's remarks, I want to emphasize that several states, including New York, Wyoming, and Nebraska, have already enacted digital currency legislation that addresses stablecoins. Other states, like Connecticut, are adapting their existing statutory language for servicing entities. Maryland should not sit still. After reviewing digital currency charters from other states such as New York, Wyoming, and Nebraska, Senate Bill 662 incorporated the ability to obtain a charter to issue stablecoin or provide stablecoin payment servicing into Maryland's existing non-depository structure that focuses on providing a framework that supports how the innovation can operate in a safe and sound manner. It features prudential and financial conditions that are designed to provide a high level of stability and also provides consumer protections for this new payment mechanism. Establishing a stablecoin regulatory framework in Maryland offers several key competitive advantages, particularly as other states have already legislated on digital assets or created stablecoins. These advantages include attracting responsible financial innovation, promoting economic development and workforce expansion, and also positioning Maryland as an influential leader in national policy discussions. With that, I respectfully request a favorable report by the Committee on Senate Bill 662. I am happy to answer any questions.
Thank you, Madam Chair, and thank you, Senator Kramer. And like you requested, I will bypass you with this question. Yes, Commissioner. So I was under the impression, constitutionally, the federal government does all the money stuff and all those currencies. And so why are we getting into this, basically, as a state? And when it was mentioned earlier that the federal government really passed rules around this space.
Sure. Well, stable coins, so they're not money in and of themselves. They're a payment mechanism. So, I mean, you could look at it simply as a stored value card, right? We have authorizations for how stored value cards are used. They're regulated by our office. This would just allow simpler payments electronically. And the stable coins are now backed by, as the senator mentioned, either cash or liquid assets. So it's a payment mechanism. It's not a thing of value, currency.
Yeah. So with a lot of states coming up with different rules, Where does this fall under the Uniform Commercial Code and basically a uniform way of doing things throughout the states?
So the Genius Act established certain standards that all the states have to meet. So that's where you're getting your uniformity. In order to be able to have a state regime, all the states have to take their proposed systems to this federal committee, which then approves them. So that'll form the baseline. Now, some states may want to have additional consumer protections. Some states may want to have additional protection on what the assets are that back these things, but we'll all be meeting the same standards. It's not a UCC issue, though.
Okay, great. Thanks for your
Thanks,
answer.
Senator.
Thank you, Senator. Thank you, Madam Chair.
Thank you, Senator. And I don't see any other questions. We do have one virtual witness, and we'll see if there's any questions after that. So you have Jenny Chirago virtually. He's in. You can begin your testimony. Thank you. Can you hear me? I don't think you can hear me.
Apologies. Sorry, it took a second. My name is Evgeny Shrego. I'm Senior Director for Regulatory Policy at the Conference of State Bank Supervisors. CSBS supports state regulators in advancing the system of state financial supervision. I appreciate the opportunity to come before you today to testify on Senate Bill 662, the Maryland Stablecoin Act. State regulatory regimes have been fostering important digital asset innovations for more than a decade. They've helped spark market competition, product development, and experimentation, all while helping to protect consumers. When Congress passed the Genius Act to create a nationwide framework for regulating payment stablecoins, it created a regime that recognized this history and respected the role of states. This bill, if passed, would be among the first pieces of state legislation to establish a state regulatory framework for approving and regulating payment stablecoin issuers since the Genius Act was passed. As Tony mentioned, state payment stablecoin regulators must seek certification from Treasury that their state level regime is quote unquote substantially similar to the federal regulatory framework. CSBS interprets this provision to mean that states' requirements meet or exceed the requirements set forth in Section 4A of the Genius Act, which contains a variety of prudential rules. And we have encouraged the United States Treasury Department to adopt this interpretation in its forthcoming implementing regulations. We believe that the Maryland Stablecoin Act would meet the certification criteria with its provisions, and by granting the commissioner the authority to adopt regulations that facilitate certification of the office as a state payment stablecoin regulator. The regulations would include capital, liquidity, and risk management requirements, redemption policies, specific guidelines for authorizing incidental or digital asset service provider activities, and prohibitions on paying interest or yield. Any consumer protection laws or rules applicable to Maryland licensed issuers would also apply to other state and federally licensed issuers operating in Maryland. CSBS stands ready to continue advocating on behalf of the state system and supporting states in their development of state regulatory regimes that preserve safety and soundness and consumer protection while advancing responsible innovation. Thank you for your time and happy to answer any questions.
Thank you. Do you have any questions for this witness? Seeing no questions, that ends the hearing on Senate Bill 662. Now we're going to go to Senate Bill 589. So Commissioner Salazar, I think you're done with us for the day, aren't you?
Yes, I am. Thank you, Madam Chair. Appreciate it.
Thank you for being here. Thank you for your work. So this is Senator Kramer, business regulation on collection agency licensure exemption for property managers. Senator, you have Aaron Greenfeld, Robert Enton, and Brian Enlu from AOBA for your panel.
Yes, ma'am. Thank you. Oh, and Sarah Peters, who has my back. And I don't see Bob Evans.
I think he's stuck up.
He'll hear about this.
I have one more person up there than I called, so,
Yeah, sure. Madam Chair, it's Sandy Paik.
okay, thank you.
Sorry.
Thank you, Madam Chair. Good afternoon again, colleagues. Ben Kramer here to introduce Senate Bill 589. And colleagues, I want to preface my introduction of this bill by saying, in my 20-year career here in the legislature, much of it has been spent in working important consumer protection initiatives for the residents of this state. And today, I'm actually going to have many of those individuals who were partners with me in my efforts to ensure the very best in consumer protection here that are going to be opposing the bill that I am about to introduce. But I want to share with you that I also believe not only in consumer protection, but in fairness, equity, and rational thought. And with that, colleagues, I will share with you that Senate Bill 589 addresses a question that has recently created uncertainty in Maryland housing law, and that is whether residential property managers must be licensed as debt collection agencies under Maryland law simply because they request or receive rent on behalf of a property owner. For decades, Maryland has reasonably understood a debt collector to be an entity whose primary business is collecting delinquent consumer debt, often debt that has been purchased at a discount, or they're collecting on behalf of another for a fee or a percentage. That is the model that I proffer to you is contemplated under the Maryland Collection Agency Licensing Act, referred to as MCALA, which is codified in Business Regulation Article. Property managers are fundamentally different. A property manager's primary business is the management and operation of residential property. They ensure snow removal and maintenance of common areas. They coordinate repairs and habitability compliance. They respond to tenant concerns. They oversee landscaping, safety, and building systems. And the request for rent when due or past due is incidental. And colleagues, please listen to that word very closely because it's going to come up in a very important court case that I will reference shortly. It is incidental to enforcing an existing lease contract. It is not third-party debt buying. It is not contingent fee-based debt recovery. It is not the independent business of consumer debt collection. When a property manager files a failure to pay rent action under Maryland Real Property Article, they are not collecting a debt. They are invoking a statutory summary ejectment process to recover possession of property for breach of a lease. If a court later enters a money judgment, collection of that judgment is a separate legal act, and at that stage, the owner may pursue collection directly or hire a licensed third-party collection agency who unquestionably must be licensed under Title VII as debt collectors. The confusion before us stems largely from a January 2025 letter of advice issued by the Office of the Attorney General opining that property managers fall within the definition of debt collectors. A letter of advice, however, is not binding legal authority. It does not carry the force of law as a formal opinion might, unless it is followed up by adoption by statute or it's validated by Maryland courts. There is also a 1980 opinion issued by then Attorney General Stephen Sachs suggesting that certain property managers might qualify as collection agencies. But for more than 40 years following that opinion, Maryland did not enforce a licensing regime against property managers for simply collecting rent incidental to property management. The recent shift in the enforcement posture has created significant regulatory uncertainty without any change in statutory language. Most importantly, colleagues, we now have judicial guidance on this matter, and I will ask you to please look on your desks, because every one of you has the opinion from the circuit court on this issue, and I want you to please take a look at it so you understand this isn't coming from Ben Kramer. This is coming from the circuit court here in Maryland. In Smith v. Bizzuto Management Company, decided just this past December 2025, the circuit court squarely addressed this issue. And the court held that, quote, colleagues, no Maryland case supports the position that a non-owner property manager who collects rent from tenants is directly or indirectly in the business of debt collection, unquote. The court further explained that the proper inquiry is whether consumer debt collection is the primary purpose of the business or merely, quote unquote, incidental to its work. Because Bizzuto's primary function was full service property management, not debt collection, the court concluded it was not required to obtain a collection agency license. That is incredibly important, colleagues, because this is the first circuit court case on this matter, and it was absolutely on point and found that property managers are, in fact, not debt collectors if what they're doing is incidental to their work as property managers. The bill before you simply codifies that common sense distinction, and I will also share with you, colleagues, I am very familiar with the judge who came to that conclusion in that case. And her reputation on the bench is impeccable. She is one of the hardest working judges on our court, and I can assure you that in the findings and in her conclusion, she studied this issue extensively before issuing the order that I just discussed now. What is important, colleagues, is that this bill does not diminish tenant protections in any way, shape, or form. Maryland already maintains an extensive statutory framework protecting tenants from abusive or illegal practices, and I fully support that. The Maryland Consumer Debt Collection Act protects our tenants. It prohibits threats, harassment, disclosure of information, and other abusive practices. We also have the Maryland Consumer Protection Act, which prohibits unfair, abusive, deceptive trade practices in consumer transactions, including landlord-tenant matters. The real property article strictly regulates residential lease provisions and prohibits certain unlawful acts. Real property article also governs security deposits and imposes penalties for non-compliance. It further governs summary ejectment and requires judicial oversight before repossession. Local landlord-tenant codes and licensing regimes are throughout our state, and they further and strongly provide compliance and inspection requirements for landlords. Federal law, including the Fair Debt Collection Practices Act, continues to apply where its definitions are triggered. Tenants are not unprotected. To the contrary, they are protected by overlapping state, federal, local enforcement mechanisms, as well as the courts. Senate Bill 589 simply prevents regulatory overreach, requiring property managers to obtain a debt collection license through the nationwide multi-state licensing system is ludicrous. It is a system designed primarily for mortgage loan originators. It imposes significant burdens unrelated to their core business. Applicants must submit extensive personal identifying information, employment histories, business plans, organizational charts, and obtain a costly surety bond. It remains unclear whether separate licenses would be required for affiliates and subsidiaries within property management groups. These requirements are intrusive, costly, and misaligned with the function of property management and goes directly against this session's common theme, affordability and housing affordability. This will unquestionably add costs. Moreover, the recent enforcement posture has not arisen from standalone allegations of operating without a collection license. Rather, the licensing claim has been layered on to broader landlord-tenant disputes, suggesting it is an ancillary enforcement tool rather than addressing a core consumer harm. The General Assembly or the courts should determine the scope of licensure in Maryland, not an advisory letter. Senate Bill 589 clarifies that a person or entity whose primary business is property management and who collects rent incidental to managing property under an existing lease is not a debt collection agency solely for that reason. It preserves the requirement that true third-party debt collectors be licensed. It preserves all existing tenant protections. It aligns statute and long-standing industry practice and recent judicial guidance, and it provides regulatory certainty in the housing marketplace. This bill restores clarity, it respects the separation of powers, and maintains strong tenant protections, which we must do, while preventing unnecessary and burdensome regulations of property managers. Colleagues, this bill would make it a challenge for our property managers to do exactly what we want them to do. When a tenant has missed a rent payment or a rent payment is coming due, we want the property manager to pick up the phone or send an email or a text message and say, hey, just want to let you know, we have not received your rent payment yet. So just in case it was mailed and it didn't get to us, let us know. We'll watch for it. If it's an oversight, come on in and get caught up. That's what we want them to do, and that's exactly what happened during COVID when hundreds, if not thousands of tenants reached out to their property managers and said, hey, I'm, struggling at the moment, and accommodations were made. We don't want the answer to be, property manager, don't bother communicating with tenants, just go straight to court and file to get that property back. That's the last thing we want. And that's what is going to happen if we keep pushing this issue as, sorry, you're a debt collector for even picking up the phone and letting a tenant know their rent check is missing. And so, colleagues, I will again reference the fact that as the court pointed out, there are no court cases on point that have said these people are debt collectors. But now the court also found they are not. And I think our Commissioner of Financial Regulation, who I'm very fond of, our Attorney General, who I'm very fond of, should respect this court case that came out in December, and they have it on appeal. It's on appeal. But my thought, Madam Chair, members of this committee, all actions should be stayed pending the outcome of that court case, because right now this is what should be controlling. A circuit court in this state that said you're not debt collectors. And with that, I thank you very much, Madam Chair, members of the committee. It's an interesting topic, and I will turn it over to the panel.
Thank you, Senator. Who would like to start on the panel?
I'll go first, Madam Chair.
Okay.
Good afternoon, members of the committee. Brian Anley with the Apartment and Office Building Association of Metro Washington. AOBA represents 122 property management companies in Montgomery and Prince George's County. I won't repeat a lot of the points that the senator already made. He covered those. I do want to briefly touch on some of the opposition testimony that you're likely to hear. First, while there is no statewide licensing requirement for property management companies, those companies do, in most counties and most municipalities in the state, have to have rental housing license. We estimate that about 90% of the multifamily market in the state is covered by a county or municipal rental housing license. And it's not true that those licenses only deal with the habitability of the property. The state's two biggest counties, Montgomery and Prince George's, recently expanded their consumer protection codes to include rental housing, and the courts have consistently held that if those licenses are canceled, the property manager and landlord cannot collect rent from the tenant. Second, there's an existing exemption for real estate brokers, but this exemption does not automatically exempt a property management company with a broker from the requirement. The Department of Labor's position is that property management companies that employ brokers must still be licensed if they collect debt, aka rent. And third, many of the examples that you will hear about deceptive trade practices, as you heard from the senator, are already covered in other Maryland statutes. And then lastly, getting licensed is a lengthy and cumbersome process. You have a letter from Grady Management, and AOBA company that's been trying to get licensed for the last 6 months and has not been able to, in part because of the MLS system that Senator Kramer mentioned, among other things. And so for these reasons, we urge a favorable report. Apologies.
Thank you. Aaron, you want to go next?
Yes, thank you, Madam Chair, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association in strong support of Senate Bill 589. A lot of my points have already been covered. I just want to mention one piece with respect to the application of obtaining a debt collector's license. It's not an easy process, as the senator said. You do need to submit a resume, passport, a business plan, your driver's license, and a whole other series of things. As Mr. Anley referenced, one of our members submitted a letter that's taken them since September to obtain a license, and they still haven't received a license. What's so important about the application process is it asks you, how long have you been partaking in this conduct? How long have you been doing this? If you, amidst all this confusion of whether a property manager has to be licensed or not, if a property manager realizes, okay, now I guess I should get licensed based on the letter of advice from the AG's office, and they go and apply, and they realize they've been doing this for 40 years, they're now exposed to enforcement by the Attorney General's office or the Office of Financial Regulation or plaintiffs' attorneys, which is what's happened in the Bizzuto case that Senator Kramer referenced. So for all those reasons and many more, we respectfully request a favorable report on this bill.
Thank you. And finally, Sandy.
Thank you, Madam Chair and committee members, for this opportunity to share my support for Senate Bill 589. I'm the general counsel of Tower Companies. I've practiced in affordable housing, community development, and housing finance for more than 20 years. I have served as in-house counsel for 3 different property management companies in Montgomery County, Maryland. Over half of my career has been in financial services, so I'm very familiar with the environment. I've worked with low-income housing tax credit investors and lenders, with DC's Green Bank, and I've also spent some time in Freddie Mac's multifamily law department, closing transactions in the neighborhood of over $2 billion in all. Property managers really should not be treated like the financial services industry. I'm very familiar with both of these industries. Leases require tenants to pay rent for the current month. So on March 1st, they would be paying rent for March. This is really not about collecting past due rents. Frankly, if property managers spent most of their time collecting past due rents, it's kind of a sign of a business that's not operating successfully. It's really challenging to maintain and operate a rental property if you're expending your scarce resources on collecting past due rent. If we were to do so, our lenders would actually view us as being in distress. That would be because it would be a business reality if that's what you're spending all of your resources doing. We've seen property management companies and affordable housing providers close their doors in the wake of the COVID moratoriums because of this economic truth. There are already extensive federal, state, and local regulatory regimes that govern rental housing. Applying a licensure regime that's designed for financial services is really just not an appropriate or sound policy choice. And I hope that we can do better in this state and focus on good housing policy. Thank you.
Thank you. I see a question, Senator Guile.
Yeah, thank you, Madam Chair. I was just looking at this very well-written court opinion by, seems to be a very competent judge. But I did have a quick question. So is there contention that property managers should be considered debt collectors because they're collecting rent or because they're collecting late rent? Because I was just looking at this opinion, and it says that at least that the plaintiffs in that case, their contention was that Bozzuto has no legal rights to collect rent or to obtain or enforce judgments for rent, presumably because they do not have this debt. So is it rent or is it the late rent?
No, it is the current rent, the rent that is due. So it's not post rent. And it's important to mention that this bill is narrowly tailored so that it only covers the lease enforcement. So if in the event that a unit becomes vacated and that person who has vacated the unit owes money, then we would need a debt collector's license. So the bill is very tailored to current, but it is to current rent due.
When the property manager is the agent for those that are entering into a contract and they're upholding, I guess, collecting the money based on a contractual agreement between the parties.
That's right, and they may even be parties to the lease. Correct.
Right. Okay. All right, thank you, Madam Chair.
Thank you. I don't see any other questions for this panel. Thank you for your testimony. We have one more favorable, and that's Barry Glassman. Barry, you want to come up?
Did you say Barry Glassman?
Yes.
I'm not on this bill. Oh.
Okay, well, we'll figure out which bill you're supposed to be on, Barry. Thank you. All right.
Never mind.
We have some unfavorables. Kathleen Highland, Kira Wilpone, Albert Turner, Scott Borson, and Lisa Serro.
Thank you, Chair Bidle, members of the committee. My name, for the record, is Kat Highland, and I'm the Deputy Commissioner of the Office of Financial Regulation, Maryland State Consumer Financial Protection Agency. OFR respectfully opposes Senate Bill 589. This issue is not new. Maryland law has long required entities that collect consumer claims for another to be licensed as collection agencies unless a specific exemption applies. That includes property management companies, who I may refer to as PMCs, and collecting residential rent and utilities on behalf of landlords. Statewide, we currently license approximately 1,048 collection agencies as of last year's data. We know that of those, roughly 70 are property management companies, and the number has gone up as we've received more applications. This demonstrates that licensure in this space is neither novel nor unworkable. The State Collection Agency Licensing Board has consistently licensed property management-related entities and issued guidance addressing rental-related collection practices, including fee practices and utility submetering. This activity is already well within the board's regulatory framework, and by law, only the state may license collection agencies. After the AG responded to an industry inquiry last year, OFR has focused on compliance by providing questions to answers, step-by-step licensing instructions, detailed FAQs, a training for the industry, and designated a senior licensing contact and offering predetermination advice when possible. We have not pursued enforcement actions since questions have arisen. Oversight remains important for this industry for reasons that I'm sure you'll hear about from other members of the panel, and licensure is not arduous, requires a surety bond and the list of information, which we're always happy to work on at OFR. Finally, last year, the General Assembly created the Maryland Licensing Work Group. The work group reviewed the licensing issue and reached a consensus that it is premature to carve out exceptions while the group is pending, which it is through July. Those who spoke raised objections to the exemption, and no members spoke out in support of this bill. Also, as a point, we have looked into data issues, and we have not found an application from the entities complaining they cannot get licensed to date. Thank you.
Good afternoon, Madam Chair, Vice Chair, and members of the committee. For the record, I'm Kira Wilpone-Wellborn. I'm the Housing Unit Chief with the Consumer Protection Division of the Office of the Attorney General. The Consumer Protection Division mediates and investigates complaints from Maryland consumers regarding unfair, abusive, and deceptive trade practices and seeks to remediate violations of the Act through enforcement actions, including actions against property managers for illegal debt collection activities. Over 1/3 of Marylanders are renters paying significant portions of their income to rent and utilities. These payments mostly go not to the owner of the property, but to third-party property management companies. This is true both for large apartment complexes and smaller scattered site rental properties. Under the current law, these third-party property management companies are required to obtain a collection agency license before collecting Marylanders' money, and that's whether or not the money is past due. As the Office of the Attorney General explained in a 1980 Attorney General opinion, and which was reaffirmed by the appellate court in Williams v. Erit, all rent collectors must be licensed as collection agencies. This oversight of property managers is deeply important both to protect Marylanders before any money is collected by ensuring the property manager is fit to do business, and then to afford opportunities for complaints and accountability when illegal activity occurs. Indeed, in the past 5 years, the Consumer Protection Division has entered into 3 final orders with property managers for violations of the CPA, including collecting rent and other fees without a collection agency license. These final orders address unlawful activity by property managers throughout Maryland, including in Montgomery County, Prince George's County, Baltimore City, and Baltimore County. The division's most recent final order resulted in over $11.2 million in restitution to consumers impacted by their landlord's unlawful debt collection activity, accountability that would be threatened with the passage of Senate Bill 589. For these reasons, the division respectfully requests the committee issue an unfavorable report. Thank you very much.
So,
yes. Good afternoon, Chair Beidel, Vice Chair Hayes, and members of the committee. My name is Lisa Sorrow. I am the Director of Litigation and Advocacy at Community Legal Services. I'm also a commissioner on the Maryland Consumer Protection Commission, which is an advisory board of 9 commissioners who are appointed by the governor. CLS assists thousands of Maryland renter households in litigation in landlord-tenant matters. You have written testimony from both the commission and CLS in your materials. Roughly 1/3 of Maryland households are renters. That's around 760,000 households. In many states, residential property managers are required to have either a real estate broker's license or an actual property management license. Maryland has neither such requirement. As you've heard, the only requirement for licensing statewide licensing is this MCALA license. It's important to keep in mind that debt collection activity by property managers is not limited to filing failure to pay rent cases in court. And speaking of those cases, yes, what is sought in a failure to pay rent case is possession. However, what that judgment is used for is to collect rent. Of the more than 320,000 failure to pay rent cases filed in fiscal year 2025, only 5% resulted in the transfer of possession. The rest were collection of debt. In Maryland, the property managers can engage in all of the debt collection activity necessary to obtain rent without a real estate broker's license, without a property management license, and they can go to court and represent their clients as non-lawyers without the professional and ethical rules governing the practice of law. For these reasons, we hope that you will not eliminate this one licensing requirement. Thank you.
Thank you, Chair, Senate, members of the Senate Finance Committee. My name is Albert Turner. I am a staff attorney with the Public Justice Center. We provide legal services for over 800 tenants in Baltimore City and throughout the state of Maryland. I'll be brief. You have our written statement. I want to hit 2 points. I want to correct the record that proponents of the bill have stated that they are only looking to get possession of the property. Adding to Ms. Sorrell's point, if you file a failure to pay rent case against a tenant and you personally serve them, you can get a money judgment in that failure to pay rent case, meaning that not only are you able to get possession of the property, but even if you do get possession of the property, you already have a money judgment. That, in effect, is debt collection. So I want to make sure that that point is very clear. Failure to pay rent is not just about possession. If you personally serve that person, you can get a money judgment in that court. And the second thing I'll add, I know many property managers in the city of Baltimore and the state of Maryland. I'm sure you have all gotten calls from your constituents. Property managers do everything but, they don't do anything but collect the rent, right? They don't fix the heat, they don't fix the plumbing, there are rodents all over the place, there are insects. The only thing they do is, first of the month, where's our money? That is generally the structure of how property management happens. I don't know any property management company that would stay in business if they stopped collecting the rent but did everything else. And for those reasons, we ask for an unfavorable report. Thank you.
Good afternoon, Chair, Vice Chair, and members of the committee. My name's Scott Borson. I'm an attorney here in Maryland. I represent consumers on a regular basis. I just want to clear up a couple things along their point that the failure to pay rent is not for collection of debt. That exact issue is in front of the Court of Appeals, or it's now the Appellate Court of Maryland, that held that it is debt collection. So if we're going to look to court cases, that 2022 case specifically addressed that argument and said, no, you're collecting rent. The other thing is, if you take a look at the exemptions that exist, there's 10 exemptions that currently exist. 9 of them are for things like, because there was a mention that debt collection always is talking about just debt collection agencies, but if you look at the exemptions, it's banks, trust companies, savings and loans, and mortgage companies. So clearly, the thought was that it was not limited to what they described as just a collection agency. The other important thing about the exemptions is all of those 9 are already licensed in another way. None of these exemptions apply to someone who's unlicensed. What this is proposing is an exemption for someone who is not licensed in any other way. I know we keep hearing about, well, there's all these different landlords. That affects the landlord. It does not affect the property manager. In addition, if we talk about the Smith versus Bizzuto case, which I'm the attorney for Ms. Smith on, I can tell you it is on appeal, but more importantly, it also conflicts with the decision, the Williams versus E-Writ. Just in a simple way, Williams versus E-Writ looked at this statute and said it's not ambiguous. It applies to anybody who collects rent. The Smith decision says it is ambiguous. So just as a matter of legal procedure, the higher court wins.
Senator Kramer?
Thank you, Madam Chair. Very quickly, Ms. Wellborn?
Yep, Wilpone Wellborn, yes.
Okay, thank you. And to the gentleman's commentary who just spoke, you indicated that the Office of the Attorney General is relying on this E-writ case as guidance in this matter. I would point to, contrary to the assertions of the gentleman who just spoke, that in this court finding from Judge McGuckian in the Bizzuto case, Judge McGuckian offered the following in response to the commentary we just heard. In Williams v. E-writ, the defendant was a third party engaged to file rent actions on behalf of the property manager, and the question was whether E-writ filings, not the property manager, was a debt collector. In Williams, the defendant's only business, E-writ, was purchasing defaulted consumer debt and collecting it through litigation. As such, neither case is instructive, and I have the court that you referred to and what they had to say. So let's take a quick look at that, because you're relying on that in the Attorney General's office, not the on-point finding of the court in the Bizzuto case. You're reaching out to this E-writ case that the court in the Bizzuto case said it's not applicable. And yet you're overlooking the court's finding there and still relying on it. And so I am reading what the court had to say in that case. It refers to Morgan Properties apparently hired E-writ to file the failure to pay rent actions. As such, E-writ was engaged in the business of collecting rents owed to others. And accordingly, it is our plain reading of the MCALA that E-writ is a collection agency. And I don't think anyone's taking issue with that. The court found that this is a company that does third-party debt collection. They're not a property manager. The court points out they're not a property manager. They are a debt collector, and yes, they should have been licensed. Do you think perhaps that's why Judge McGuckian came to the conclusion that that case that you both rely on is not instructive in coming to the conclusion that she did? Would you be willing to proffer that perhaps that's why Judge McGuckian came to that conclusion? The E-writ case was a debt collector that failed to have a license, not a property manager.
So I can't explain the judge's opinion and reasoning in that matter. What I can tell you is since 1980, the Attorney General's office has indicated through public opinions that all rent collectors must be licensed as collection agencies. That, and the quote that in the E-writ decision is, all rent collectors must be licensed as collection agencies. Property managers are collecting rent. Rent is a consumer claim under the Maryland Collection Agency Licensing Act. The fact that you are collecting that money requires a license or other exemption.
And evidently, the circuit court disagrees with the Attorney General's office, and I would proffer to you that at the court's decision is what should be, in fact, followed in this case, not just the opinion of the Attorney General. It's the court's decision that should now be followed. But thank you for that. And real fast, Ms. Highland,
Yes.
you shared with us that you're with the Office of the Commissioner of Financial Regulation. Let me ask you this. Do you feel that it is pressing at the moment that you keep enforcing this issue, which has created some chaos in the industry, pending the final outcome of this Bizzuto case as it works its way through? And the reason I ask you that is that I reached out to your office and asked, how many complaints has your office received on this matter that it's so critically important that rather than just waiting to let this play out, the office is going to pursue this? And the answer I got back is, as far as complaints go, the OFR received 4 complaints.
This year.
4 complaints against property managers in the past 6 months. Would it not be prudent to perhaps stay enforcement actions pending the outcome of this case, since we now have an on-point circuit court finding saying they are not, in fact, property managers are not debt collectors?
Thank you for your question.
Yes, ma'am.
I think it is significant that we have 4 complaints in the past 6 months. We are a small office with limited resources, as the commissioner has often testified. We, as I testified, have not taken enforcement actions at this time. We are following up on complaints in the normal course of our process. And we do not contend that this is a new issue. We are treating the property management companies who do collection activities the same as we do all unlicensed collection agencies in Maryland. And I could never, as a licensed attorney in Maryland, take the guidance of a circuit court decision against the law of the land of this state, because it is not binding on anything, including the decisions in that own circuit court. Thank you.
I think we'll disagree on that. Thank you very much, Madam Chair.
Thank you. Senator Guile.
Yeah, thank you, Madam Chair. Just to follow up on that a little bit. Ms. Wilpone Wellborn from the Office of the Attorney General, I mean, you state in here that this has been the law for 45 years, but really you're backdating it to whenever this Office of the Attorney General opinion happened in 1980, true?
Correct. It's a public opinion interpreting the Collection Agency Licensing Act. And then, if I may,
no, you can't.
I apologize.
And it sounds like there was, at least from what I can glean, that there wasn't necessarily enforcement until at some point within the last few years. Has there been enforcement during those 45 years of this issue?
The Consumer Protection Division has done extensive enforcement within the landlord-tenant space, including within...
But on this issue, as far as license for a debt collection license for property managers?
For property managers and other collection agencies that are not unlicensed. So, for example, I mean...
But property managers, I'm asking
property managers, both property managers for apartment complexes and property managers for homeowners associations and condominiums.
Okay.
We have had a consistent interpretation of the Collection Agency Licensing Act and have engaged in an extensive enforcement in this space.
Because it just looks to me, when I'm looking at the letter that you submitted, that there was a letter in 1980 interpreting the applicability of this law to property managers, and then it looks like you started enforcing, recently. That's at least my perspective. And, also to follow up with Senator Kramer's point, I mean, you can look at the titles here of these cases, Williams versus E-Right filings. E-Right filings or E-Writ filings, that's not, E-Writ filings it's not a property management company. Anybody can tell that what they do is not property management. They're not, fixing leaking toilets. They're not, in people's homes, managing the property of what we would normally think a property manager would do. Same thing here. The other defendant looks to be LVNV Funding LLC. I mean, same thing. I mean, I can just tell by looking at the name that they're not in the business of property managing. It looks to me like they're in the business of debt collecting.
They're in the business of collecting consumer money. So I want to be very clear.
Yeah.
The Collection Agency Licensing Act, we've been colloquially talking about this as debt collection activity.
Right.
But what it is, it's the collection of consumer money. It's the collection of a consumer claim. A consumer claim is any amount of money that's used for personal household purposes.
Yeah.
So rent is a consumer claim. It's being used for personal household purposes. And so E-Writ which, yes, was a filer, not a property manager, and was filing failure to pay rent actions on behalf of owners.
It's ERIT, right? Yeah.
ERIT, yes. Was seeking the collection of consumer money. Property managers and the enforcement actions that I've been a part of, which I've highlighted in my testimony, these property management companies have contracts with the owners to collect consumer rent, to collect consumer money. And in fact, many of these property management agreements tie the compensation of the property management company to the amounts that they collect in rent. And so there is a vested interest in the property management companies to collect as much rent as possible because then they get paid more. And this creates a very deep concern for us as an enforcement agency of Maryland consumers is if you have entities that are not fit to do business collecting substantial amounts of consumer monies.
Collecting rent. But that's fine. I understand. But isn't it, it's fair to say, though, I mean, the landlord-tenant industry is a pretty highly regulated industry as it is. And you're adding another requirement on here that interpreting rent as debt, presumably, or consumer debt, and consequently, they have to get a license on top of everything else that they're doing in a highly regulated industry.
So I will say that
I just don't understand. I guess what I just don't understand is why.
Because there are no other statewide licensing requirements for property management companies. If we remove this requirement, as the Senate bill proposes, what will occur is a patchwork of state or of the county and municipal laws that apply to those landlord-tenant interactions, but there is no statewide licensing requirement. As a result, a consumer in St. Mary's County can have very different experiences with the collection of their rent from their property manager versus a consumer in Wacomico County or Montgomery County, Baltimore City. And what this does is actually creates a framework in which bad actors can proliferate because there is not a statewide licensing requirement to ensure that they have met the minimum standards of collection at the front end before they do business with Maryland consumers, and then have an avenue for accountability at the back end. So this is why we're deeply concerned with this bill.
Just one last question, Madam Chair. Are there other states that require property management companies to hold a debt collector license, to your knowledge? Go ahead. What other states?
Yes,
specifically this?
So they consider them collection agencies, and so there are 19 states that do not require licensure of collection agencies. All states to consider the issue consider rent collection to be a collection activity, and 50 minus 19, sorry, lawyer, don't require, or do require a licensure of property management companies because they're doing collection activities.
Because they do that as part of their role of being a property manager.
So this puts us in the minority were this law to pass.
Okay, I'd be interested in seeing those states. All right, thank you. Thank you, Madam Chair.
Thank you. I have a question. I think this is going to go to Ms. Highland. We've heard in earlier testimony that it's very difficult for property managers to get this license. It's a difficult process, and sometimes people are waiting more than 6 months. Do you issue the license, or is that in a different department?
Yes, it's under our department.
Why is it taking so long, and why is it so difficult?
I respectfully don't have any data on that, and the company that submitted the letter has not submitted a collection agency application.
Do you mind getting a list for me of who's waiting for approval now and how long they've been waiting?
We can certainly get that.
Okay, I'd appreciate
We are
that.
not aware of any, and I did go through the current list of licensees and the pending applications.
Thank you. Thank you. Senator Washington, you have a question?
Thank you, Madam Chair. You actually asked my question for me. I was going to ask the same question about just how long does it take? What's the process? What are the requirements? I heard that there's a fee and you got to provide an ID and some other things. What is, you're going to give us back the information about holding up the process and what's going on, the data behind that, right?
Sure. We're not aware of any holdups in the process, and we did designate a senior contact to escalate any concerns that the industry had from people applying for licensure. We have received none.
Yeah, got it. And the issue, you may mention during your line of questions about with Senator Gao, just about the property. If we remove this, there won't be any protections, or there won't be a program to implement this law, or there won't be a law to have these protections. what would happen if we remove this? What's the worst case scenario?
That there wouldn't be any state oversight of this subset of an industry doing collection agency work. We don't even know, and no one has offered the exact number of property management companies who would be seeking licensure in Maryland. No written testimony, and there have been proffers to the office that caused us to staff up and put resources together in preparation for assistance. But to date, there has been no actual evidence offered of the unlicensed entities who are seeking licensure.
And what's the fee associated with the licensure?
So it has a couple of different fees, ranging from $350 to an annual assessment. The total cost is around $800.
$800.
And that's just as of the assessment last year, so it could fluctuate slightly.
And that's for each property management company or each property?
Each property management company, full stop. So my understanding is that they manage, dozens to thousands of units in the state.
Got it. Okay. I'll be interested in
And
seeing
that's
that.
all we have data on, the units and the apartment buildings, not the total number of property managers who are being considered in this. And that's what the Maryland Licensing Work Group would love to know more about.
Got it. Thank you.
Senator Kramer, you have a question?
Thank you, Madam Chair. A quick follow-up to both of the senators that you just heard from. And I think you just maybe stated it. How many property managers are unlicensed at the moment?
I wish I had the answer to that question, and thank you for the question, because I think it brings light to the unregulated nature of this industry. We cannot determine that without information from the proponents of this bill.
50, 100, 1,000, 1,500, 2,000? And the
Senator-
reason I ask is both your office as well as the Office of the Attorney General have routinely stated to me personally how desperately short you all are of people to enforce our existing laws in the state. And let's just say there's 1,500 property managers that are unlicensed right now, and your office has had a total of, and I understand, you professed concern about the 4 complaints you received. I didn't hear you say what the resolution was, but if there's hundreds, perhaps even thousands out there, and you've received 4 complaints, evidently this really is not problematic, and yet you're telling us, because I hear repeatedly, you don't have the personnel to enforce what we've got on the books right now, but you're saying, yeah, throw this at us and we're fine.
Senator, I don't want there to be any misunderstandings. It's not that we don't have personnel to enforce, although I would be remiss if I didn't say, because especially since my boss is right behind me, that we could always use more money in our budget for enforcement and for resources. We can certainly take additional actions. We have not at this time, because we understand that the industry had some questions and we provided training and compliance information first. We could take action on those things, but doesn't 4 also suggest that maybe there aren't many property managers in addition to the 67 we currently license who are seeking to be exempt from the licensing requirement? I wish I had that data.
Thank you. No data. Thank you.
Thank you, Senator. I see no other questions for this panel, and that ends the hearing for Senate Bill 589. We're now going to go to Senator Jackson, Senate Bill 782, Telecommunications Infrastructure Protections. Senator Jackson, you have Rob Garagiola and Jeremy Crandall as your panel. Here's Rob. There's Jeremy.
Good afternoon. Good afternoon, Chair Bidel, Vice Chair Hayes, fellow members of the Senate Finance Committee. For the record, I am Senator Carl Jackson here to present Senate Bill 782, Telecommunications Infrastructure Protections. In recent years, there has been a significant uptick in the theft of engineering equipment, as well as the destruction of telecommunications and broadband assets. Perpetrators steal batteries and power cables from wireless towers and small cell sites, cut communication and fiber optic lines, and willfully and intentionally destroy wireless infrastructure. The impacts of these incidents are significant. Not only can communications be disrupted for the general population, but these incidents can also affect public safety when 911 and other emergency systems are impacted. SB 782 helps Maryland address this problem by ensuring that state law includes and protects telecommunications equipment in existing criminal and scrap metal statutes. We are still working with the scrap metal industry to ensure that this bill accomplishes this goal without being burdensome on scrap metal dealers. So I do believe that some amendments will be forthcoming, but as currently written, SB 782 does two things. Firstly, the bill adds telecommunication infrastructure and equipment to the state's existing criminal code governing vandalism of gas, water, and electrical equipment. Secondly, the bill ensures all the various rules and regulations required of scrap metal dealers apply to telecom equipment as they do now to other types of materials. This bill falls in line with what is now a nationwide effort to strengthen state laws governing telecommunications equipment, with similar laws now existing in 13 states, in places as diverse as California and Alabama. SB 782 seeks similar protections in Maryland. For these reasons, I respectfully request a favorable report, and I will continue to work with all interested parties to find a solution that accomplishes these goals. Thank you.
Thank you, Madam Chair. Members of the committee, Rob Garagiola with Compass, here on behalf of CTIA. I want to thank Senator Jackson for sponsoring this legislation. Look, there is a problem that we're trying to fix here nationally and in Maryland. There's a high prevalence of telecom and broadband equipment theft, and we're talking thousands, well over 10,000 incidents a year that are occurring nationally. And in Maryland, there are a number of articles that I just found earlier today referencing this that you can Google yourself. So a problem does exist. The goal of the bill is to essentially draft telecom into Maryland's existing statutory construct, and that's what essentially has been done with the draft of the legislation. Since the bill has been introduced, we have been meeting with the scrap metal processors, as Senator Jackson referenced, and begin a dialogue about potential amendments to address their concerns. The bill, as it's drafted, does put requirements on processors as well as other junk dealers, in part because such requirements exist, for other types of thefts. And number two, the idea is if you have bad actors stealing such equipment, like has been done with the current statutory construct in Maryland, that's the market. You're looking, if you can address the market that these products are going to, that's going to disincentivize those that are stealing these products. So we're going to continue that conversation. We're working on some amendments. Would certainly urge a favorable report with impending amendments. And with that, I'd like to turn it over to Jeremy Crandall with CTIA.
Thanks, Rob. Good afternoon. My name is Jeremy Crandall. I am speaking on behalf of CTIA. We are the National Wireless Industry Trade Association. Our members include AT&T, Verizon, T-Mobile, American Tower, a range of other wireless industry stakeholders. I want to be additive to what Rob and the bill sponsor said. I'm just going to share a couple of points. I will reiterate what Rob said. This is absolutely a serious problem that's happening right now to our critical telecommunications infrastructure. When someone makes a 911 call, when they're getting on that telehealth appointment or that work Zoom appointment, they want to make sure that they have a secure and reliable connection. And so this bill ultimately is designed to ensure that that's happening. I'm just going to share 3 quick points. Rob alluded to the data. We are working hard to quantify how serious of a problem this is. Looking at the last year that we do have numbers, 16,000 incidences were reported across the country. Some of these incidences number in the millions to tens of millions of dollars, both from a lost equipment standpoint, but really I want to get at the economic loss that is created when a telecommunications network goes down. I'll share just a couple other points and then open it up to questions. Each of our members have robust network security teams. These are customarily personnel who used to work in law enforcement and now work closely with local, state, and law enforcement as well. And this particular policy that is before you related to scrap metal is something that they have identified that can help make a dent in the problem. And I'm happy to talk a little bit more about that. And then finally, the sponsor did mention that this is active in other states as well. At this point, there are half the states in the union, red and blue states and purple as well, have taken similar action to address this issue, and we'd like to see Maryland do that as well. So I'll stop there, Madam Chair.
Thank you. Do I have any questions for this panel? I don't see any questions. Thank you very much.
Thank
That
you.
ends the hearing on Senate Bill 782. And now we will go to Senate Bill 143, Public Works Contracts, Apprenticeships Requirements. And I think a representative for Senator Benson's office may be here. Omar? Thank you. And Rico is also with you. Rico from the Local 24. He's going to come up. That's your panel. Thank you very much.
Good afternoon, Madam Chair and Vice Chair and esteemed members of Finance Committee. My name is Omar. I'm the Legislative Director for Senator Benson office. The bill strengthens Maryland workforce development pipeline by ensuring that public dollar invested in public works project also invested directly in Maryland workers. As we continue to build roads, schools, and infrastructure across our state, we must also build career paths that allow Marylanders to access skilled family-supporting jobs in the trade. Senate Bill 143 alters apprenticeship requirement for public works contract by requiring certain contractors and subcontractors who employ 4 or more individuals on the covered project to employ the number of qualified apprentices or journey workers necessary to meet an applicable percentage of total labor hours on the project. Beginning January 1st, 2027, that applicable percentage will be 20%, and the Secretary of Labor will annually establish the applicable percentage for subsequent years. Importantly, this bill shifts the focus from allowing payment in lieu of participation to emphasizing actual utilization of qualified apprentices and journey workers on job site. This ensures that apprenticeship programs are not merely supported in theory but strengthened in practice through real training, opportunities, and direct workforce experience. The bill also enhances transparency and accountability by requiring contractors and subcontractors to provide written verification before commencing works and to submit monthly report and detailing the total number of apprentices and journey workers and the total labor hours worked. The Department of Labor will maintain and publish aggregated data on its website, promoting public transparency and strengthening oversight. Additionally, Senate Bill 143 allows the Secretary to waive the requirement under specific circumstances when contractors can demonstrate that they requested qualified apprentices from all applicable apprenticeship training programs but were unable to secure placement. This ensures fairness while maintaining the integrity of the apprenticeship goal. This legislation also clarifies that this apprenticeship requirement apply to the University System of Maryland and Baltimore City Community College, ensuring consistency across state-supported public works projects. By prioritizing workforce participation on publicly funded projects, Senate Bill 143 promotes economic mobility, strengthen Maryland's skilled labor force and ensure that taxpayer investment deliver both infrastructure and opportunity. For this reason, Senator respectfully urge a favorable report on Senate Bill 143. Thank you for your consideration.
Thank you, Omar. Rico, you want to testify?
Madam Chair, Mr. Vice Chair, committee members, thank you for giving me the time to come here and speak to you today. For the record, my name is Rico Albuquerque. I'm with IBW Local 24, and we represent more than 3,000 electrical workers from Frederick to Ocean City. I want to take a little bit of time today to speak to you about what apprenticeship is, what it's meant for my life. I came to the electrical industry in my mid-20s with few marketable skills and even fewer career prospects. And my IBW apprenticeship gave me everything that I needed to know. When I came into the trade, I didn't know how to use power tools. I didn't know how to change, oil in my vehicle. I was not a handy person. I was not very mechanically inclined. But my apprenticeship gave me all the skills that I needed in order to have a successful long-term trade in the electrical industry. And that's what apprenticeships do, especially when they're done the right way. Register with the state. They match you with a job. They have on-the-job training so that when you graduate, I have a skilled credential. And so in a world where apprenticeship and apprentice is a very sexy topic and a buzzword, and we want to have thousands of high school graduates complete high school with an apprenticeship certification or some type of industry credential, I believe that it's important to find ways to make sure that these folks have a career and have an industry and have a place in the workforce. We feel like SB 143 does that, and so that's why we urge a favorable report from this committee. Looking forward to taking any questions. Thank you very much.
Thank you, Rico. I don't see any questions for this panel. Thank you for your testimony. We have some favorable with amendments. Sean Malone, Sarah Sample, and Michael Adams. Michael, you want to start, please?
I'll actually defer to Mr. Malone because I think he was going to give an overview, if that's okay. Thank you.
It's so nice being the old guy at the table. On behalf of the Mayor Minority Contracts Association and ABC, my name is Sean Malone. We're testifying in support of this bill with amendments. We worked very hard with the House sponsor on this bill to try to, in some ways, streamline it, and in other ways, coordinate it with the original apprentice training fund that was established by MMCA, Associated Builders, Contractors, and the building trades. That was a bill that required that for contractors working on public works projects, that they would, if they're not paying into an apprentice fund, 25 cents on every hour goes to the state apprentice fund. That fund has helped build programs in Baltimore City. It's built programs in Prince George's County and in Western Maryland as well. So what we've asked is that, and we worked to sponsor in this bill, is that because our current pipeline can't support 20% on all public works projects with in-state apprentices, we've asked that one of two things happens. Either people bring their apprentices to the job, which is an advantage of the contractor because work is performed at a lower rate, or for the percentage that they can't meet, that they pay 25 cents an hour into the fund, so that if we are unable to meet that 20%, the Apprentice Training Fund continues to receive funds to develop the pipeline. It's a pretty common sense approach to building the apprentice pipeline in Maryland and continuing some of the good work that's been done since 2012 when this fund was originally started. It also negates the need for a certification process that you've checked with several apprentice programs to be able to bring apprentices on the job. Either you bring them on or you don't. And if you don't, then you have to make up the difference with the contribution to the Apprentice Training Fund. So with that, we would urge favorable support of the bill.
Thank you, Madam Chair, members of the committee. Michael Adams, on behalf of Associated Builders and Contractors. I wanted to walk the committee through some of the more specific amendments that ABC would like to see in the bill and have also been discussed at length with the House sponsor, Chair Wells. First and foremost, on page 10 9, lines 1 through 8, and then lines 24 through 31. Currently, the language as it's in the bill is taking away the provisions which allow funding for ABC's apprenticeship programs. There's a 20-cent per labor hour charge if you don't bring apprentices onto a job site. Currently, that money is directly funded into ABC's apprenticeship programs, both in West Baltimore and in Beltsville. So we want to preserve that language first and foremost. Also, as Mr. Malone alluded to, the bill as currently constructed has a waiver ability if you are unable to find apprentices for a job. You can basically waive out of the program. We don't want that waiver program. We want either apprentices on the job or to be able to pay that 20-cent per labor hour charge. Or if you're able to bring some percentage of the requirement, then you get credit for that requirement, and it's counted pro rata against the charges that are made. Additionally, we would like to remove, so on page 7, line 15, removing 4 more individuals as a minimum requirement for the businesses that applies to. Currently, the law applies it to every contractor on a job. We believe that should continue. It should continue to apply to every contractor who is on a Maryland Public Works project. We also wanted to include language, as the bill states, for journey workers. The title says apprentices and journey workers, but the definition does not include journey workers. We believe journey workers in those first sort of 3 years of their vocation should be allowed to participate in this program and will have many substantial benefits for those new workers on the job. Thank you.
Thank you to the chair, members of the committee for having me. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support with amendment Senate Bill 143. We agree that apprenticeship is a proven pathway to workforce development. We are really big supporters of that, and when it comes to the 20% mandate in the bill, we're absolutely fine with that. The concern that was brought up by some of our members is this flexibility that the department has in terms of resetting or sort of potentially increasing that percentage annually. And we're concerned that depending on how the 20% is going, and I think you just heard that there are some concerns about it, we're worried that it could get set too high for certain jurisdictions, and then they're in a situation where they're losing bidders, they're losing competition, and they're potentially having their costs go up. So that amendment would really just remove that language, that they would be adjusting it annually. And so we're happy to work with the sponsor on that language. Thank you.
Thank you. Have you submitted your amendments to the House, and have they been accepted?
So we have had meetings with Chair Wells. Chair Wells has indicated that she is on board with most, if not all, I don't want to speak for her, of the amendments. The language itself has not been drafted, but we're working with her office to get that done. It should be done promptly.
I think we'll probably wait for that draft to come over.
Thank you.
Do I have any other questions for this panel? Thank you very much for your testimony. Next, we have Elijah Clark coming to present a bill for Senator Mary Washington. And there is no panel.
Good afternoon, Chair Beidel, Vice Chair Hayes, and members of the committee. For the record, my name is Elijah Clark. I'm Senator Mary Washington's Social Policy and Constituent Services Assistant, and I'm here to present Senate Bill 732, which calls for Baltimore City to have its own distinct approach to managing its share of the Community Reinvestment and Repair Fund. Since distributions began in Q3 of 2023, Baltimore City has received $9.2 million in CRRF funds, representing about 30% of all statewide distributions. That share reflects a difficult reality. Baltimore City residents were charged with cannabis possession at rates higher than anywhere else in the state between 2002 and 2022. The CRRF exists precisely because of the history, and our communities deserve to see that investment land where it was intended. What we are seeing instead gives us pause. Roughly $5 million of those funds More than half of what Baltimore City has received to date was directed to an existing city agency with an established budget rather than distributed through a community-driven process. We understand the pressures that drive such decisions, and we're not here to assign blame. But we do think it points to a structural gap that this bill can help close. SB 732 redirects Baltimore City's quarterly CRRF allocations from the standard county distribution channel to the Baltimore City Comptroller, who will establish a dedicated special account, administer the funds independently, and distribute them in accordance with the same statutory requirements that govern the fund everywhere elsewhere in the state. The City Comptroller is an independently elected office with the fiduciary capacity and the institutional independence to manage these funds at arm's length from the annual budget process. That independence matters here. The Baltimore City administration has raised some concerns about this bill's compatibility with the city charter, and we want to take some time to address those concerns directly. The city argues that routing funds through the comptroller conflicts with the charter's assignment for financial duties. But Article 5, Section 3 of that same charter explicitly authorizes the legislature to assign the comptroller additional duties not inconsistent with the office as prescribed by law. That's precisely what SB 732 does. This is not a workaround. It is exactly the mechanism the charter provides for. The city also points to Article 1, Section 20 of the charter. The provision city voters ratified to establish a continuing, non-lapsing community reinvestment and reparations fund. What this shows is that Baltimore's own voters understood these dollars needed to be protected from the general budget process. But Section 20 does not designate a fiscal agent. It does not establish a distribution mechanism, and it does not create a pathway to get money to community-based organizations. SB 732 does not conflict with what voters created. It completes it. Finally, the city argues that funds must flow through the Director of Finance under the charter's general revenue provisions. But that provision was written to govern the city's general revenue collection. CRRF funds are not general revenues owed to the city. They are a specific state remedial allocation created by this legislature, restricted by statute, and intended for a specific purpose in specific communities. The General Assembly has both the authority and the responsibility to determine how those dollars move. The CRRF was designed with a clear purpose: to direct resources back into the communities most harmed by decades of disproportionate cannabis enforcement. That purpose is only meaningful if the structure around the fund actually ensures the money gets there. Right now, for Baltimore City, that structure doesn't fully exist. There is no dedicated account and no designated fiscal agent anchored in local law. SB 732 provides that structure and creates accountability and transparency. We respectfully ask for a favorable report. Thank you.
Thank you. Do I have any questions for Elijah on this bill? Seeing no questions, thank you for your testimony. We do have one unfavorable from Nina Themelis from the Mayor's Office of Government Relations.
All right. Good afternoon, Chair Beidel, Vice Chair Hayes, members of the committee. Nina Themelis, Director of Government Affairs for Mayor Scott in Baltimore City, here to testify in opposition to Senate Bill 732. As it was discussed, the fund was originally established as a part of the Cannabis Reform Act of 2023 to provide funding to local jurisdictions to address the disproportionate impact of enforcement of cannabis laws on communities across the state. The process that is outlined in Senate Bill 732 directly conflicts with the city's charter and foundational structure in a number of ways. The comptroller is not a separate entity from the Mayor and City Council of Baltimore, and so is not an appropriate direct recipient of state funds. The comptroller's assigned duties in the city charter do not encompass receiving funds on behalf of the city, and nor does his office have the staff to receive and then disperse those funds. Money received by the city is typically appropriated through the annual budget process as outlined in our city charter. I do want to make one correction to the testimony before me in that the city had allocated money to an agency for general funds for use that are other than what is outlined in the state law. The city council passed, as required in the original Cannabis Reform Act, local legislation outlining the disbursement of funds that are received from the state. And in that local law, we stood up a commission to determine the uses of those funds and also identified the Office of Equity and Civil Rights as the staffing for that commission. So the funds were allocated as a part of the fiscal 26 budget to pull it out of that separate segmented account where all funds are held separate from all other funds from the city, so that we would be ready to disperse, because we can only allocate during our fiscal budget, our annual budget cycle. We cannot disperse separately unless we were to pass a supplemental appropriation. So those funds were transferred so that they could be dispersed when grantees were determined. So as is stated in our written testimony, the bill conflicts directly with the charter. We already have the processes in place. The fund is already separate from everything else. We hope that you vote this bill unfavorable.
Nina, thank you. I don't see any questions for you. Thank you for your presentation. That ends the hearing on Senate Bill 732. And we're now going to hear from Senator Mary Washington's Chief of Staff, Kara Madison, on Senate Bill 605, Public Service Commission, Broadband and Voice over Internet. Kara, would you like to bring up your panel?
Yes, please.
Jimmy Tarlow, Jeff Jenkins, Anne-Marie Proctor, and Human Hadyadi, I think.
Okay. Good afternoon, Chair Beidel, Vice Chair Hayes, and members of this committee. For the record, I am not Senator Mary Washington. I am Kara Madison, her Chief of Staff, and I'm here to present Senate Bill 605, the Broadband Accountability and Affordability Act, on her behalf. Broadband is no longer a luxury. It is essential infrastructure as critical to daily life as electricity or running water. And yet, unlike nearly every other form of essential utility, broadband service in Maryland operates today with virtually no state oversight. SB 605 authorizes the Public Service Commission to oversee the quality, reliability, and resilience of broadband and VoIP services. It requires providers to report outages, maintain their networks to a baseline standard, and submit data on service availability, pricing, and deployment. When the Commission finds that a provider's service is unreliable or inadequate, it has the authority to require corrective action. Maryland has clear legal authority to act here. The D.C. Circuit's decision in Mozilla versus the FCC confirmed that the FCC's decision to step back from broadband oversight does not prevent states from filling that gap. A legal analysis prepared for the Communication Workers of America reached the same conclusion, finding that legislation such as Senate Bill 605 is well positioned to withstand any preemption challenge. We anticipate some will argue that this bill imposes heavy-handed utility regulation on a sector that has thrived under a light touch, and that broadband's interstate nature puts it beyond Maryland's reach. We respectfully disagree on both counts. SB 605 is not about traditional utility regulation. We're not setting rates or dictating network architecture. We're asking for transparency, baseline reliability, and accountability when service fails. That is responsible governance, not heavy-handed regulation. Other states have moved forward with broadband oversight without driving providers away. What they have seen is better service and more public trust. Maryland should be in that company. Maryland has made historic investments in broadband deployment. This bill ensures that those investments are paired with the accountability that Marylanders deserve. Thank you for your time and consideration. We respectfully urge a favorable report.
Okay, who's next?
Chair Beidel, Vice Chair Hayes, and members of the committee. My name is Human Hedayati with Communications Workers of America, requesting a favorable report on SB 605. CWA is the nation's largest labor union representing telecommunications workers, including many here in Maryland. Over past several decades, regulations at both state and federal level has significantly reduced oversight of telecommunications providers. As a result, consumers often lack meaningful protections, and internet service providers face limited accountability to their subscribers and communities that they serve. The effort to regulate broadband at the federal level has hit a wall as Sixth Circuit Court of Appeals overturned Biden administration's net neutrality Title II common carrier classification, and the Trump FCC refused to defend those rules and has since moved to delete them. We believe that broadband is a mature, dominant telecommunication service. Voice over Internet Protocol, or VoIP has replaced traditional copper-based plain old telephone service. According to most recent FCC data, only about 15% of Maryland's wireline subscribers remain connected to the PSC-regulated switched access line. That's about 114,000 regulated lines compared to 643,000 unregulated interconnected VoIP lines, and an additional more than 7 million wireless voice subscription lines. As telecommunication providers accelerate their retirement of their legacy copper networks, Maryland faces a growing regulatory gap. And while we hope the federal government will move and reassert its oversight authority, they're living a void here. And in this environment, I think Maryland needs to establish the protections to protect consumers. I'll be happy to answer any questions.
Next.
Chair Beidel, Vice Chair Hayes, and members of the Senate Finance Committee, it's a pleasure to be back here with so many of my friends and former colleagues. Today I am testifying as a 30-year-old, I wish I was that, a retiree with 30 years with the Communication Workers of America. We realize that Senate Bill 605 is a big bill and new to the committee, but let me take the big picture. HB 605 seeks to modernize the state code and keep up with the changing times and legal landscape. 20 years ago, the PSC regulated all the old telephone lines. Since then, 85% of the people who had landlines have switched to fiber and cable and make phone calls through voice over Internet protocol. Up until the last couple of years, VoIP was regulated by the FCC, preempting state regulation. This all changed in the last couple of years when court rulings came down that said the FCC cannot regulate the Internet and VoIP. This is why this bill is being introduced in 2026, not in 2023 or 2024. The PSC on their own website says that VoIP is regulated by the FCC. This is just not true. The feds cannot regulate VoIP and broadband, so it now falls on the state to be the watchdog for Maryland's telephone customers. The California PUC is now regulating VoIP and telephone broadband, and this kind of bill has been introduced in 4 states, and more states will be doing this. The Public Service Commission should be watching on the phone lines, and the General Assembly should update the code so they can do that. 2 things. One, there was a $1 million fiscal note on this. The drafter just gave some amendments that basically wiped away all the fiscal costs. We wish we would always do that. But basically, like all PSC, it takes the cost and goes to the providers. So there's no fiscal note on that. And 3, there's issues about legality. Let me just finish. Delegate Foley has a legal opinion that basically says this would stand up in court, and we'll have Senator Washington's office send you the legal opinion from the Attorney General. Thank you.
Thank you. Who's next?
Good afternoon, everyone. My name is Amory Proctor. I'm with CWA Local 2108. As a Maryland-based cable splicing technician and local union officer for nearly 40 years, representing hundreds of technicians, I have witnessed a significant shift in how the telecommunications industry responds to major service disruptions. When hurricane-strength derricos struck Maryland in past years, technicians from across the state were mobilized immediately to restore service. At that time, regulated telecommunications providers were required to meet specific service restoration standards. Unfortunately, those obligations do not apply in the same way to broadband-based services today. During the devastating 2017 and 2019 California wildfires, sparked by power lines and responsible for widespread destruction and loss of life, CWA technicians reported widespread wireless system failures. Power outages, fire damage, and network congestion disrupted communications overnight while many residents were asleep. Traditional copper landline customers often continued receiving alerts due to the centralized backup power, while many VoIP and wireless customers lost service. In many areas, internet access was unavailable when it was needed most. Competition has not solved these problems or closed the digital divide. Decades of state and federal deregulation have left policymakers and the public with limited tools to hold broadband and wireless providers accountable for outages, unreliable service, and poorly maintained infrastructure. When internet or phone service fails, does not deliver advertised speeds, or otherwise falls short, consumers have little meaningful recourse. For these reasons, the legislature should establish Public Service Commission oversight of broadband providers to restore accountability and ensure a watchdog over network resiliency, public safety, and consumer protection. PSC oversight is essential to guarantee reliable communications during emergencies, including access to 911 and public safety answering points, as well as state and local emergency information websites. The Commission should also establish clear backup power requirements for VoIP and wireless networks. Fiber, coaxial, and wireless systems all depend on consistent power. Without adequate backup power in the network and at customer premises, these services will fail. Like water and electricity, broadband has become essential to daily life. It is time to restore meaningful oversight and ensure Maryland residents receive the reliable communication services they deserve. Thank you for your time.
More.
Hello, my name is Jeffrey Jenkins. I'm a retired Verizon service cable splicer technician. I've 25 years with Verizon service. I've performed installation, maintenance on coax cable, copper cable, and fiber optic networks. I have 3 types of cables with me today. The traditional copper wiring used to regulate copper lines, the coax cable used by cable providers, and fiber used in the fiber network. When used for voice services, they all perform the same final function, connecting 2 people at the end of the line. But if they don't do this, but they do this via different technology. This is important because copper wires is subject to the state's PSC oversight. If you face repeated outages and your provider is not responding to your concerns, you can file a complaint with the PSC to investigate. But if your voice service is via voice over IP, the PSC does not have any authority to investigate the complaints with the PSC. This is not the case when responding to fiber tickets. During my career, I was frequently heard from supervisors that we need to respond to outage cases and tickets because the company needs to comply with the PSC service quality standards. Repair tickets were prioritized when the customer has filed a complaint with the PSC. This is not the case when responding to fiber tickets. CWA are the most highly trained and experienced workforce in the broadband industry with deep knowledge of deployment, maintenance, and customer support. We know. All right, thank you for your time.
Do I have any questions for this panel? Senator Lamb.
I don't know if you saw me.
Thank you, Madam Chair. Thank you to the panel for bringing this forward. You know, I was looking through some of the testimony. There's a lot of oppositional testimony. I wanted to get your sense of some of this, that, you know, the CTIA, for example, I think this is the Consumer Technology Folks of America, that they had brought up that, you know, one, they're mentioning a whole bunch of things about wireless. This is really focused on just broadband, right? This is broadband and VoIP, right? This is not, you know, they're giving a whole bunch of statistics about just wireless services. That's not falling under this, right? Or how does that, you know, can you clarify that?
It could. It depends on how you get your broadband technology.
That's true, yes. I guess more and more folks are getting broadband via like 5G or, you know, okay. Gotcha.
Yeah, I'm sorry.
The other thing they contend is that, you know, they don't want to have a whole patchwork of different state laws that are applying. But to clarify, the federal government has decided that they has abdicated their responsibility in this area, right? That they are deferring to states to regulate broadband and VoIP services.
Yes, that's correct. In other words, they basically, court decision had to do with net neutrality. There was another court decision, basically was ruled that the FCC cannot regulate internet or broadband anymore.
Right.
And to answer, if I can, to your first question, when you use wireless service to make phone calls, people use wireless service to call 911, wireless service to, go to their local police department's website or social network account to get emergency information. So in that sense, wireless is involved.
Right. Okay, that's helpful. And so basically the argument that industry is making is that they don't want to be regulated. They're not regulated at the federal level, and without this bill, they would not be regulated at the state level. They would just be unregulated.
Yes.
Completely. But, the reason that we have the PSC and their oversight and regulatory authority over a lot of essential utilities is that these are essential, right? And should the case I think can be made, and I think all of you are making this case, that when it comes to broadband, when it comes to VoIP, there's very little folks using traditional landlines these days. The internet and the necessity of having reliable internet in places like Baltimore City all the way out to Kent County, which is referenced here, where internet reliability has been a problem, is something that the PSC, as a regulator, if they had jurisdiction over this, could really help with.
I think if you have a complaint because your phone outage or no one's fixing your phone, right now you have no one to call.
Right.
In other words, it used to be you call the Public Service Commission, they'll say, we can't.
If you had a landline problem, for example, you could call the PSC.
They used to, well, if you had an old copper line, but now people have landlines and they go through VoIP. If you call about a complaint, they will say they now say you refer to the federal FCC, but that can't be done either. So there's no one to call.
Mm-hmm. So it's almost like this is just a modernization act, right? That technology has changed over time, right? Very, very few people using, I guess, landlines that are copper lines, not landlines that are VoIP lines. Technology's changed. And so as part of that change now, the purview of the PSC and the purview of the federal government or the FCC, I guess, has not included this. At the state level, we can still do something about that by ensuring that our residents, that Marylanders do have someone to turn to if they have a problem with reliability, responsiveness, costs, those types of things, by regulating this industry, which is providing an essential utility to many of our residents.
Yes.
Okay, thank you.
Senator Reedy?
Thank you very much. I wonder if I could ask, and I don't know who it's best addressed to. It might be for our good friend, former Delegate Tarlow, but the PSC has a letter of info in the file. I'm assuming you've all seen it. And there's concerns about the preemption clause, but you just talked about how I think the questioning was about how broadband is essentially not regulated. So I'm confused why. Can you square that?
Will we have
what do you think they're referring to?
I think they're a little outdated, that letter, that basically the feds used to be preempt the states, but now they can't do it. And we have a legal opinion, again, which the senator will share, basically from the Attorney General's office. It says that this basically will not have any, this will stand up in court. It is not being preempted anymore.
Are other, and if someone testified this, I apologize if I missed it. It's been a long few days here, but are other states taking this step?
So California has the Public Utility Commission has already not only done it, they have a whole bunch of regulations already in place.
Is that gone, and that hasn't been taken to court or anything, correct?
No.
Okay.
No, it was actually.
No, California, it hasn't been, they haven't faced litigation, and during those, California Public Utility Commission hearings, and in the rulemaking process, the industry raised a lot of concerns about preemption at the federal level, the same concerns that you see in the letters submitted to this committee. But after CPUC finalized a lot of those rules, it's been like 2 or 3 years since the earliest ones, and so far there hasn't been any lawsuits by providers saying that the laws are preempted.
Okay, 2 more questions. One would be, how will doing this bring down the price / make broadband and these services more available to the underserved communities you're talking about? Because I got a county that's had challenges with getting it in some parts of our county, so I definitely think it's a great goal. How will this help? How will this bill help?
Well, in fact, we're not allowed to talk about rates. I mean, we're allowed to talk about it, but the federal government has said tied any rate process, that would be, they'll actually cut out funding. So specifically, this bill does not talk about any kind of rate setting because the current president and the administration has said any attempt by states to do rate cutting will actually basically jeopardize the BEAD funding. So this bill only talks about resiliency, customer, kind of how many times, how long it takes to get a phone fixed, safety and things like that, but it stays away from any kind of rate cutting.
And I know it's entitled Broadband and Voice over Internet Protocol Service. That's the bill. Would this, if passed, would this bill allow people to complain to the PSC that they feel that their internet provider is slowing their internet down, or is that part of this as well?
I mean, the bill is kind of broad, so the PSC, has discretion to, within the requirements to adopt rules that would be applying in Maryland. But if I'm not sure like what you're saying exactly would fit in there, but let's say a broadband provider that faces outages, a lot of outages, and their internet service providers, does not respond, technician visits are not happening, getting scheduled and not happening. At least it provides a venue for for customers to go and complain to a state agency.
And there's also one more thing. There's a whole process for them doing regulations and having hearings. So this just authorizes them the ability to do these kinds of regulations. So if there's a regulation, doesn't necessarily mean it will take effect. So the bill itself is broad, but basically authorize them to come up with regulation.
And the bill is probably not specific about this, but some of the opposition to this is the concern of dampening economic development, which is more general. But the one specific point I thought was brought up that was good was that I thought should be addressed and give you an opportunity to. Most of these providers are a lot of these bigger companies are doing things across state lines. So they're developing in multiple states, they're running platforms in multiple states. We wouldn't have, our PSC would not have the ability to penalize a company in another state, or would they?
They can, penalize a company that operates in Maryland and provides services in Maryland. The Maryland PSC cannot, fine a company for what they're doing in a neighboring state, if that's what you're referring to.
A lot of times this stuff is I'm thinking also about how the energy grid works. That the PSC only has control over, they have control over what happens in Maryland, but oftentimes the energy grid is connected. Obviously, it's connected. Yeah. So some of this is true of internet and broadband. Last question, and thank you, Madam Chair, for the indulgence. The fiscal note's like $1 million on this thing. So, and a lot of times I know about death by fiscal note, believe me. I definitely know about death by fiscal note. I know sometimes it's not fair. But it does seem, it checks out to me that there would be some significant administrative and cost to setting all of this up. So what would you say to respond?
I think you must have missed what I had said, that there's basically an amendment to the bill that was left out. Basically, all the other PSC utilities pass on to the providers, and that is the same thing. So in other words, if there's everything the PSC does basically gets passed on to the providers.
And that will, the problem we've got is, the problem we've got is that just gets passed on to ratepayers. But all right. Thank you, Madam Chair.
I was finishing that sentence for you. I don't see any other questions for this panel. Thank you very much for your testimony. We're now going to have the unfavorables, Rob Garagiola, Jeremy Crandall, and Megan Stokes.
Would you like me to start, Madam Chair? Okay, thank you. Madam Chair and members of the committee, Rob Garagiola with Compass on behalf of CTIA and respectfully opposing and seeking unfavorable for Senate Bill 605. I did reach out to the sponsor a few days ago to let her know our position on this. But at the same time, this legislation is not necessary. It is preempted by federal law, and there will be cost to implement it. Basically, the 3 points I want to focus on is that the market is working. Look, the telecom market was deregulated in the 1990s during the Clinton administration, and since then there's been a lot of investment and a lot of change. I mean, we've gone from 2G, 3G, 4G, 5G, and soon we're going to be embarking on 6G. The market is working. There's been over $10 billion invested in Maryland, and unlike other challenges the state is grappling with, like higher energy costs, food costs, and other necessities, wireless services are actually decreasing in costs, and they have been year over year because of competition with better service and innovation. On the preemption point, it is likely preempted by the FCC, and there's various court decisions that assert that and have historically looked at this and barred states from imposing state-level utility oversight for these interstate services. My understanding is that the California law that was referenced earlier is not like the bill that's being proposed today. It is very different, and no state has done something like this legislation is seeking to do. And then finally, on the cost aspect, I want to thank Senator Reedy for raising that. The fiscal note does illustrate that there's $1 million plus price tag. That cost doesn't, I mean, if you want to offset it on various carriers, that cost is going to get passed through. So there is going to be cost. It's $1 million fiscal note. Again, would respectfully urge an unfavorable, and we'll turn it over to Jeremy Crandall with CTIA.
Thanks, Rob. To repeat for the record, my name is Jeremy Crandall here on behalf of CTIA. We are the Wireless Industry Trade Association, again, in opposition to Senate Bill 605. Our opposition is really focused on two key questions. What does the current environment look for consumers, and where is that environment headed in the future? On the previous panel, there was, importantly, a lot of focus on consumers. And Rob shared some key numbers on prices. Wireless is down 44% over 10 years, 24% over 5 years, 5% in the last 18 months. Let's talk about service, because that was another element that was mentioned. In the last year that we have data, Americans use 132 trillion megabytes of data. That sounds like a lot. That is the largest single year increase ever. And think about how fast our wireless devices are today. Sorry, Rob. And finally, on competition, there's been a lot of talk about competition as well. Right now, if you are a consumer, you could not be in a better position. If you do not like the service or the affordability of the plan that you have, you can very quickly go to another provider. This is a consumer-friendly environment, and it exists because wireless is regulated at the federal level. Let me repeat that. Wireless is regulated at the federal level. And for that reason, first of all, that promotes competition and innovation, but it is why we are very concerned about this bill, and we're proud of our record on this issue. I do want to touch on a couple other items. We have looked at services that are governed by utility-style rate regulation and ones that are not like wireless. When you look at things like electricity and water, rates go up. Wireless, again, is down. And then finally, we have touched on the legal components as well. Rob touched on the Federal Communications Act clearly preempting state regulation. That is touched on in the fiscal note. But I do want to share one more thing, because BEAD did come up, and I'm happy to address this in the Q&A. We do feel strongly that there is a significant BEAD risk with this bill as well that I'm happy to speak to in the question and answer. Thank you, Madam Chair.
Megan.
Good afternoon, Madam Chair and members of the committee. My name is Megan Stokes. I'm representing the Computer and Communications Industry Association, also known as CCIA. We represent a broad range of technology firms invested in expanding broadband access. While we share the committee's goal of ensuring affordable, reliable internet for all Marylanders, we must oppose Senate Bill 605 unless amended due to its unworkable application to satellite broadband. Under federal law, the FCC has exclusive jurisdiction over satellite-based services and spectrum. By attempting to regulate these interstate services at the state level, Senate Bill 605 is going to be considered legally flawed from the start. Maryland simply does not have that authority to regulate assets that operate in orbit. California's PUC oversight, which was mentioned earlier, does not apply to satellite technologies due to the FCC's exclusive jurisdiction. Second, the bill ignores some of the realities of satellite technology. Requirements for backup power infrastructure audits are designed for terrestrial wireline networks. You cannot audit a satellite in space. And customer-side terminals operate differently than underground fiber. Satellite services rely on a customer's own terminal and power source. We urge the committee to amend Senate Bill 605 to exclude satellite-based services to avoid these legal and technical conflicts. Thank you.
Thank you. Senator Reedy.
Maybe I ask you this question because I actually am trying to learn about this more because I was looking at the testimony from the PSC about not violating the supremacy clause, which we've been doing a little bit of experimenting with that in this General Assembly session on some other issues. But the statement of the proponents was that the federal government doesn't regulate this area or is not regulating it. Can you say they do. So is it that they can, but they're choosing not to do any regulation? Is that, or is it that they are regulating and it was kind of not, you would disagree with that assertion, or can you just help me with that?
So I would disagree with that assertion, but let me clarify a couple of things. So first of all, again, CTIA represents the wireless industry.
Understood.
And I really want to emphasize that, Senator, because wireless occupies a distinct space in federal law, the Federal Communications Act. And again, specific to wireless, that is where Section 332 of the Federal Communications Act, Senator, I'm happy to follow up with you, but it says explicitly, no state or local government shall have any authority to regulate the entry or the rates charged by any commercial mobile service or private mobile service. Now that also, I will note, applies to mobile broadband as well. Now, I did hear in the dialogue before that there was a comment that the federal government has abdicated oversight of broadband. Respectfully to the committee, it's a little more complicated than that, in that there was a court decision related to federal regulation of broadband, but what they were saying is that the FCC needs congressional authority to regulate broadband. I think that's an important distinction here, rather than just saying that they abdicated that responsibility.
So they're waiting, they need Congress to give them specificity, or they need Congress to give them the authority?
I would say the latter, but what I really want to make an important distinction on, Senator, is that second part is about broadband. That first part is about wireless. Now, those are, you could kind of think of it as those are two separate circles of a Venn diagram. At times, those Venn diagrams come together,
because
but they are
wireless is used for broadband, wireless.
There's wireless broadband.
Yeah,
there's wireless broadband,
right.
and there's wireless as your cell phone. But what is really important here, and I don't want it to be...
So like a T-Mobile hotspot is a wireless broadband setup.
So I can't speak to the hotspot. What I can speak to, I've never...
Maybe I used the wrong word.
Respectfully, Senator, I've never had that question before. What I can speak to is what was alluded to on the previous panel, that there is your cell phone, your wireless provider that you utilize your cell phone for, but there is also fixed wireless access that, in Senator Lamb, I think you referred to this in your comments, that people now have wireless internet in their home.
That's what I was meaning.
Yes.
Like
So that's how
has a product, others have a product. Yeah. Right.
That's how I would speak to those sort of two circles of the Venn diagram. But again, I do have to go back to that wireless component. Federal law is very clear.
And perhaps Congress should act to make a little more clarity about this Venn area, but to say that they're not regulating is not really.
Okay. I will defer to brighter minds on that one, sir.
I understand. I'm not. And by the way, just for the record, I'm not endorsing any particular products. Thank you, Madam Chair.
Thank you. Senator Mounts.
Thank you, Madam Chair. Just quickly, Jeremy, you were mentioning BEAD funding, and broadband deployment I represent a rural part of Maryland, and broadband deployment was something that was almost laughed at when I first got into the General Assembly. Along came COVID, all of a sudden, it became a reality. And we still, even though there's these maps and things that show that the broadband has been deployed, BEAD funding is a very important issue for rural, for every area. You were talking about BEAD funding, and you said in the Q&A you'd have a little more to add. I'd like to give you that opportunity.
Thank you, Senator. And I will say as well, there's another bill that is on the agenda today that this topic may come up as well. So you may hear me talk about this again, Senator. Specific to the bill before you, over the last 9 months, the current administration has issued approximately 3 to 4 updated FAQs and notices, essentially regulatory guidance for states as every state implements its BEAD program. In one of those guidances, they say a state must commit that it will not enforce any law, regulation, or other enforceable obligation that regulates the rates, terms, and conditions of broadband internet service. Now, I heard the previous panel speak about rates, but this guidance before us goes beyond just rates, sir.
Thank you.
Senator Ellis?
Yeah, thank you, Madam Chair. Ms. Stokes,
Yes.
good to listen to you. Love this technical stuff. It brings me back to my early Air Force days where I really did a lot of work in this area. And so I heard you say something, Ms. Stokes. Did I hear you correctly that you cannot audit satellites in space?
So if you're looking at the language around the PSC, so it's PSC in this bill, it's PUC out in California, so I'm getting those acronyms correct.
Could you tell us the acronyms? Because people listening from home, so.
Sorry, just making sure I'm trying to help out with the folks following along. The things that are in the bill, and I don't have it in front of me because, of course, I like to never be prepared, and it caused my boss to cringe. Some of the concerns are talking about submitting information, the data that's going to be collected and reported, correct? Talk about the backup plans that need to be set up, the system for assessing the adequacy, all this stuff. It's one of those where the commission's going to have to determine that the practices, facilities, or services of the providers are correct or unjust or unreasonable.
Right.
So you're asking the PSC to then have the authority to look at something that is specifically carved out under federal law 47 U.S.C. section 303, giving the FCC exclusive jurisdiction over satellite spectrum and service.
Yeah. So all that to say, I did hear you correctly. Words.
Yes. Sorry. Yes. For those following along.
Okay. Yeah. So I'm also a CPA, and I know people who do exactly what you said they don't do, and some of the terminologies is called like geospatial auditing, which is a systematic, standards-based process of evaluating the performance, quality, and compliance of geospatial information systems, and more broadly, use of spatial data and analytics to enhance audit procedures. It leverages location intelligence, mapping, and spatial analytics to verify physical, environmental, or infrastructure-related information, often used to detect fraud, ensure compliance with Geospatial Data Act, and improve decision-making. So I'm not sure if we're talking about different things right here, but it seems like we are kind of like not on track. So follow with me later if basically, our understanding of the issues are not aligned, if you could.
Understood.
Yeah. I know it's technical, but I don't want to take up more time with my colleagues. I want to get mad at me. Madam Chair, thank you so much.
Thank you, Senator. I don't see any further questions. That ends the hearing on this bill. And I'm going to do Senate Bill 415.
All right, next we will hear Senate Bill 415, Business Regulation Maryland Franchise Registration Disclosure Law Alterations, and we will hear from our chair, the Honorable Senator Bidle.
Thank you, Mr. Vice Chair and members of the Senate Finance Committee. Thank you for the opportunity to present Senate Bill 415. This is the Franchise Reform Act. I'm actually working with the Chair of Environment and Transportation, Delegate Corman. He's already had his hearing and made some amendments which we've accepted. So the bill has changed a little bit, but we'll have a reprint for you. Maryland is one of 13 states considered a franchise registration state, indicating the highest level of scrutiny for franchisors seeking to franchise in the state. State oversight is important to protect franchises from being taken advantage of, but it must be balanced against our economic development goals. And as we choose to increase business and improve our economic status, I guess, we need to do a little more to help Maryland franchisors. So, like other states, we require approval of the federal franchise disclosure form. Franchisors must pay a $500 filing fee and submit additional information to the state for further approval, and they must renew annually. The purpose of the annual state review is to protect franchisees. However, the process is burdensome. Senate Bill 415 would codify the Maryland Franchise Disclosure Document Renewal Fast Track Review pilot program put in place last year by the Securities Commissioner. The program expedites the review of the franchise registration renewal if the franchisor provides certain information no later than 30 days after the end of the registrant's fiscal year. The bill clarifies that Maryland franchisees may join associations of franchisees and provides legal protection for doing so. Second, it alters the statute of limitations on certain claims from 3 years after the grant of the franchise to 4 after the grant of the franchise, or 2 years after the date the franchise open to the public, whichever is earlier. And third, the bill requires the Securities Division establish a standard for the review and adoption and approval of incomplete franchise disclosure documents and allows them to use technologies to do so. The bill also requires reports to evaluate the effectiveness of the Fast Track program. The goal of these reports is to ensure that the committee can evaluate the program, make further improvements to the franchise process if needed. This is the first step in a large goal of fully overhauling and reforming the franchise process in Maryland. Ultimately, the goal is to implement a process that rivals our neighbors in efficiency and allows for more Marylanders to pursue business ownership through franchising. The Franchise Reform Act will support business ownership in Maryland by providing protections to franchisees and promote economic prosperity and growth. We're working on several amendments, as I said, to the bill, and I respectfully request a favorable report on Senate Bill 415 with amendments. I can see there's a lot of interest in this technical bill.
Are there any questions of Madam Chair?
Thank you.
Oh, thank you. Seeing none, this ends the bill hearing on Senate Bill 415. Next, Madam Chair, you leave it? You have one more? Another big one? Good afternoon. Next, we will hear Senate Bill 594, Cannabis Advertising Alterations. We will hear from Chair Beidel as the sponsor of the bill, and we're going to call up our panel that includes Ashley Bagwell, Joe Bryce, Lindsay Foscolo, and Taylor Green. Keep in mind that the sponsor of the bill has as much time as she needs. All other panelists should pay attention to the timer. It is not a suggestion. When the light goes off red, we hope that you would conclude your testimony. Thank you so much, Madam Chair. You should proceed when you're ready.
Thank you, Mr. Vice Chair, again, and members of the Finance Committee. Thank you for the opportunity to present Senate Bill 594, Cannabis Advertising Alterations. Senate Bill 594 endeavors to balance public health safeguards while acknowledging the struggles both newly awarded social equity licenses and operating cannabis licenses have in competing in a market saturated by unlicensed and illegal sales of intoxicating THC products, whether hemp or cannabis derived. So the unlicensed businesses do not follow the restrictions on advertising, do not charge or remit the higher cannabis sales and use tax that are available or that are required in our state, and may be more likely to target and self-intoxicating THC products to minors. So we have brand new businesses coming into Maryland with all the new social equity licenses, but they can't advertise. So Senate Bill 594 balances these policy interests through the careful alteration of existing restrictions on advertising for cannabis licenses in the state. The bill defines several terms, including therapeutic or medical claim, to provide clarity for cannabis licensees and consumers on what types of medical claims must be supported with scientific evidence. Senate Bill 594 expands the amount of signage that a licensed standard dispensary is authorized to display on the exterior of the business, while also carefully limiting the area of the individual signs and total area of all signs collectively. Currently, a cannabis license may only place an exterior sign on the premises of the business for the limited purposes of identifying the business to the public. Under the bill, a licensed standard dispensary may also place exterior signage within the size limits established to, among other things, identify a business as a cannabis trusted source, identify a special ownership designation like veteran-owned or women-owned, and provide public health resources that can be used if adverse cannabis event occurs, such as the contact information for the Maryland Poison Center. Senate Bill 594 also creates predictability in advertising for cannabis licensees and ensures that the audience composition for cannabis advertisement meets the requirements that at least 85% of the audience must be over the age of 21. Establishing a statutory method for determining whether an advertisement or proposed advertisement meets the audience composition threshold and requires that the Cannabis Administration establish regulations by January 1, 2027, identifying at least one alternative method of determining audience composition. News media articles, interviews, and other editorial content over which a licensee has no control from the application of the advertising restrictions are excluded from the requirements. I respectfully request a favorable report to Senate Bill 594.
Who's going to go first, Ashley or Joe?
I will.
Go ahead.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, Madam Chairman, for your leadership on this and so many other things over the years. I think we have to recognize that this advertising statute goes back 10 or 12 years at the beginning of the medical program. And at the time, we were talking about a closed system, essentially, a medical program specifically for patients. There were signs in the medians of your neighborhood saying, call this doctor, and people were very upset about it. And it was a new program. The changes that are being asked for here are very modest. I don't think it's too much to ask that you can put a QR code or a website on your window for people to find you if they walk by and are curious. There are still very strong child protections, both in the advertising area and in the packaging and label standards, which are even more stringent than the advertising. So we're not seeking to advertise towards children, but the notion of indirectly is very hard for licensees to comply with and for the Cannabis Administration to regulate. And so we're really seeking some clarity that will hopefully make for a more even enforcement of these things. More and more, as these businesses are in your communities, they're being asked to sponsor community events, 5K runs, other things as a good business partner in the community. 21-year and over events, the 85% limit. If you're going to a beer fest, you shouldn't have to do research and data on who's going to show up. You should be able to rely on the nature of the event and the promoters of the events. So with that, Mr. Chairman, I'm happy to answer any questions.
Good afternoon, Madam Chair, Mr. Vice Chair, and members of the committee. I'm Ashley Bagwell here this afternoon on behalf of the Maryland Dispensary Association in support of Senate Bill 594. Maryland has some of the strictest advertising laws in the country when it comes to cannabis. To us, this bill doesn't weaken these laws, but rather it provides some specificity and some clarity to the law so that dispensaries and other licensees can resume limited advertising that they've done for quite some time with no issue until recently. I think one of the best examples that illustrates why Senate Bill 594 is important is what is happening with business signage. Dispensaries are allowed to have a sign, but as the chair said, it has to be for the limited purpose of identifying the business. What this means now is that cannabis dispensaries can't have a sign that says woman-owned business or black-owned business, and lest anybody think that this is something that we are just assuming might happen. It has happened. A woman-owned business was fined for having a sign that indicated such and was required to take that sign down. I also want to talk or just touch briefly on the appealing to children language. As Mr. Bryce said, and I want to be very clear, we do not advocate advertising to children. Again, at the risk of sounding like a broken record, I think what we're looking for is specificity and clarity in the law, because what this has turned into is appealing to children is a very broad, very nebulous statement that can appeal to most anything. At the end of last year, for instance, a number of licensees received official notice suggesting that they not decorate for the holidays because this might be deemed appealing to children. So licensees really at this point just have a hard time knowing what they can do and what they can't do. They want to follow the law, and so what we're seeking is clarity and specificity, and that's why we support Senate Bill 594. Thank you.
Chair Beidel, members of the committee, my name is Lindsay Foscolo. I'm an owner-operator of a women-owned dispensary in my hometown, a business I built with my mother. My perspective is shaped by a decade of hands-on experience in Maryland, from helping write our application in 2015 to managing our operations and compliance to date. I've seen this industry evolve from a blueprint into a reality. Advertising restrictions fuel a culture of secrecy that treats cannabis like a scary and intimidating substance rather than an approachable, regulated consumer product. The public then relies on Cheech and Chong stereotypes or reefer madness tropes as their primary source of education. Those exaggerated films are not the reality of cannabis, yet they remain the public's main reference point, as they do not realize trained agents exist to guide them on products based on their goals and preferences. This secrecy prevents us from replacing fear with facts. Because we cannot effectively identify ourselves, Marylanders are left in a state of confusion. I've had neighbors tell me there are dozens of dispensaries in Worcester County. In reality, there are only 2 of us. The rest are unlicensed. The narrative around cannabis must shift from secrecy to one of visible legitimacy. Dispensaries need to be accessible landmarks so the public know where to go for a trusted, verified experience, rather than relying on the informational void of the internet. Before 2023, I could engage with my community at events and answer questions in neutral spaces, which made information easily accessible. When we are forced to remain hidden, it creates a barrier to professional guidance. Stigma thrives in the dark, and for many, that stigma translates into a sense of personal shame. I have met individuals struggling with insomnia or pain, but were too afraid of the stigma to enter my store. I've had patients tell me they cannot tell others how they feel better with cannabis in fear of judgment. No one should feel bad about feeling better. This bill is a step towards ensuring the public is educated rather than kept in the dark. Thank you for your time.
Good afternoon. My name is Taylor Green, and I'm here as the Vice President of the Maryland Coalition for Cannabis Equity. We are a new trade group. Basically, our members are social equity licensees. Right now, we have about 15 founding members, and then we also have a broader audience with the rest of the SELs, that's what we call them, social equity licensees. There's about 60 of them that we are in constant contact with. We basically started the Maryland Coalition for Cannabis Equity due to the fact that we weren't being heard. We found that this was really needed this upcoming session, so we got together to make it happen. With that in mind, I would say that our ultimate goal is to basically get clarity and also work with legislators to make sure that we can successfully open and also to make sure that we can have successful businesses. With that said, if the committee will allow, I would very much appreciate it if you could see the amount of social equity licensees that are standing in the room. If they could just wave it, that would be appropriate. Awesome. So many of us have showed up today just to make sure that our voices are heard. And with that in mind, it's important that we essentially work together to make sure that any type of bills that are submitted to become law are providing operational clarity and then also allowing us to function. This is very important for us, and we hope that we could work together in the future. And with that said, we would ask for a favorable report on this bill. Thank you.
Thank you for your testimony. Are there any questions for this panel? I do have one question, Taylor. I know myself and other members of the Legislative Black Caucus of Maryland in advocating for social equity and more opportunities for people of color to have ownership. I think part of the thinking behind that, in addition to what Joe spoke to earlier, was to give an opportunity for more social equity licenses to come on board before like advertising was just out and open. So I'm curious to know, how has these current restrictions impacted specifically social equity licenses?
Yeah, so I would say that these current restrictions have impacted social equity licenses basically because we can't even let ourselves be known. It's very hard for me to walk around with a shirt with my micro dispensary's name on it. We've heard horror stories about people who had employees walk to go get lunch and potentially they've been fined, or people have seen a poster or something through a glass where it was at an inappropriate place and they've gotten a fine. So we've been really cautious about how we've been navigating in this space. I think the other thing as well is that we want to to be involved in the community, but we can't even really let ourselves be known at community events either. We can't have our names, or we have to double check some things in terms of like audience, where it deals with like indirect advertising. And the compliance burden of that is major for us because we don't have necessarily the financial means to constantly have compliance personnel or attorneys on staff with us to make sure that we're actually hitting all the points that's needed in the restrictive legislation. So it's been very hard for us overall just to even get our names out there. And I would say that for most social equity licensees as well, it becomes a point of, even if we post on social media and we say it's 21 plus only that can view this content and somebody else reposts it, we run the risk as well of basically being fined. So it's very difficult just to get out there just generally. And I foresee, because the current legacy operators that are currently open, they're having problems. So we're definitely going to have problems as well.
No, that's interesting and very helpful because it sounds like something that was meant to help you has provided some burdens in activity. Lindsay, you have mentioned something about since 2023. Did the advertising restrictions, is that when they first went into effect? I guess prior to that, did you all have an opportunity to advertise more?
I had significantly more abilities to interact, advertise, and really be present in my community. I have been able to give health presentations where I had a little over 100 attendees. Now something like that likely would not be possible unless I had someone carding at the door and ensuring that the advertisement was not seen improperly. We had flyers posted up. I mean, even at community events, he had referenced a beer event. There is a jazz, wine, and food festival in downtown Berlin. Right before adult use went legal, we made sure we participated at the end of June. And the conversations I had were so incredibly helpful because people wanted good answers to questions that they weren't sure about. We even had a fake cannabis plant on our booth, and people were coming up and being like, oh, wow, what strain is this? It doesn't have much of an aroma. The public genuinely did not know it was fake. So just putting it even to there, they don't know what product options are available to them. And that's where we can bridge that gap. But it has to be in neutral places.
Thank you. Question, Senator Lamb.
Thank you, Vice Chair. I guess to anyone on the panel, I was just looking through the bill folder on this. There's a lot of unfavorable from folks in the medical, public health community. Just kind of wanted to get your response to that.
Sure. Thank you, Senator Lamb. I think we from the beginning of the formation of the program have been supportive of the advisory councils and as Lindsay talked about, the public education and health impacts, and we want all that to be out there. I understand that. I don't really honestly see much in this bill that increases exposure to children particularly, and on the adult side, it facilitates a better conversation. I know one of the letters referred to sales going up fivefold from July to December. That was a mistaken read of the data. That was a cumulative number, so it looked like it was 5 times. In fact, the sales have been basically flat for the last 6 months, around $80 million. So we're not looking for mass increases in the type of advertising we can do or who we can do it to. It's really how and where, and can we have some certainty so that we don't run afoul of what the Cannabis Administration feels they need to enforce.
Right. So a question here then about there's the Maryland Cannabis Administration, right? And would they have? Is it that they're interpreting some of the existing statute just too stringently that's impacting some of these businesses negatively? is there any latitude that they could have in how they're interpreting the existing statute to give a little more flexibility here?
So in fairness to MCA, I think that they are implementing what the law says. And in doing that, you have to make an interpretation about what it says. And they are seeking clarity as well, which is what we want. Nobody wants a call or a fine or anything like that. We just want to know what the rules are. And so we really approached this whole thing as trying to provide clarity so that there were not those miscommunications. And you know, again, to them, the program's maturing. They have time to do different things than they did when they were opening up the program. And they're, in fairness, they're enforcing the way that they read the law.
So I guess your, interpretation of their interpretation is that the existing statute does not give much flexibility for more interpretation there, and that is negatively impacting these businesses. They are boxed in.
Correct.
From being able to give some additional flexibility so these businesses can do some more reasonable things.
And I think the examples that the panelists brought up, you know, that clearly isn't what was intended by anybody, that you can't have a string of lights on your building. You know, and you can go to other places, liquor stores, restaurants. Santa Claus could be handing out candy canes, and that's okay. But the simple notion of decorating for the holidays is not in and of itself attractive to children. And the same with the signs, and it's not unreasonable to have a QR code or a web address or a phone number. And those are the types of things that people are tripping up over, and we just want it more clear.
Or even an example might be, you know, if you have a business in a strip mall and there may be certain designated parking spaces, you know, would they have a problem putting up a sign?
They're tucked back away behind somewhere.
Right.
You can't say
around the
this
corner
way.
here,
Correct.
come around the corner to come into our door.
Correct.
Or even if they had designated parking spaces that say, you know, these 4 spots are for, you know, dispensary X.
Right.
That could run afoul of the law.
I don't know that it
potentially.
has, but again, if you interpret it strictly, you're, to the extent you're going off your premises, if you're in a strip mall, for example, it's not your property necessarily.
These spaces are designated could run afoul of like an advertising. Yeah. Okay.
I wouldn't be surprised if that happened, but I don't know that it's happened.
Right.
But those are the types of situations that we're running into.
Yeah, I don't think that was the intention, obviously. Okay, thank you.
Senator Miles.
Thank you, Mr. Chair. Joe, I was looking at the bill folder also online, and I didn't see testimony from MACO or MML. And, if this were to go into law, are we going to then be dealing with localities trying to pass ordinances on regulating, advertising and things like that? And how does that work with what's in this bill?
Well, I think I'll defer to Ms. Bagwell, but no, they still have to comply with all the local zonings. Their signs have to comply with local ordinances and local zonings. These aren't billboards. These aren't, eyesores. It's nothing of that nature, which is why I think they're not here.
Yeah, just to reiterate something that was said earlier, these are minimal changes. I don't think we see this as a wholesale overhaul of advertising laws. I think, just as Senator Lamb was saying, we're looking for more clarity and more specificity so people don't run afoul of what I think was originally intended in the first place.
It's funny because I was reading the bill, and then it talked about boards, like the boards you put out front. And my hometown, small town, St. Michael's, I mean, it was like thermonuclear war over where you could put your sandwich board.
Right.
And, and I don't
But the locality would still have the ability to regulate that. If it's not allowed based on where you are or what their rules are, this doesn't preempt that.
Okay, thank you.
All right. One other question, and there was some testimony that was submitted by the regulator MCA with 4 various amendments. I know we will probably hear from them in a moment, but wanted to give this the appropriate person on this panel an opportunity to address some of the concerns and amendments that's raised, see if you had a chance to review them and what is.
So from what I know of the amendments, Mr. Chair, I think to us, the definition of, there needs to be a definition of therapeutical or medical claim. Again, because is happy a medical claim? Is sleepy a medical claim? And so we do want some certainty there. The second one was,
Retain or attractive to and youth protected.
yeah, so again, I think we've discussed the problems with attractive to and indirect. I think they're just problems and will continue to cause problems, and eliminating that gives a more clear direction of, is this something that uniquely would apply to children? I think the third one that I'm aware of deals with the advertisements and the in the media. So if you're the subject of a newspaper article or a feature on the news, we would suggest in that area that you clarify that it's paid commercial advertising. So if somebody comes and writes an article about you and you're in your Joe's T-shirt and your picture's in the paper, that's not advertising. That's being the subject of a media inquiry. So clarify that it has to be paid and the business intended to pay for it as advertising. I don't know if there's the fourth one. I don't know.
No, I think that was it. Maybe I said 4 and it was really 3. So I'm good. Thank you. Are there any additional questions for this panel? Thank you so very much.
Thank you.
Thank you.
Next, we will hear another group of favorable testimony from Obi Chinamir, Mark Brody, Barry Glassman.
Good. Awesome. Well, thank you, Mr. Chair, for the opportunity to speak, and thank you to Madam Chair for our opportunity to work on this bill. We understand that the industry is at an inflection point, right? It's growing, it's modernizing, and we just want to make sure that the statute modernizes as well. This is Obi Chinamir on behalf of Curio Wellness, by the way. We had a situation similar, that we have a mural in our Timonium location, and we were also cited for that. And it's not enticing. The idea is that we're not looking to attract children. It is simply a large facade that we wanted to beautify the community by painting. So, at the end of the day, I think the conversation around this, as you've heard a lot, so I won't take up too much time, is that, A, this state regulates industries all the time and finds ways to both allow people to promote their businesses while also making sure they protect the citizens that they want to protect. And second, like you mentioned, during the medical market, there were laws that allowed us to do certain things. And we're just looking for an opportunity to be able to continue to grow, allowing other people who are entering the market to grow, and then at the same time, make sure that the adults who want to actually partake in this get the opportunity to do it as well. So that's it. Thank you guys for the time. Appreciate it.
Thank you, Mr. Chairman, members of the committee. Barry Glassman on behalf of Nature's Care and Wellness in Cecil County, one of the first solely owned Maryland medical dispensaries and then recreational. We support Senate Bill 594. It does add some clarity to what is the most regulated legal product that we have dealt with in the Maryland marketplace. You go into a facility, you get your product behind a locked door. And so it is the most regulated and secure area as compared to many other activities you do in Maryland, whether it's a winery, a brewery, or a liquor store. We would say that in addition to these steps, the administration really needs to begin to look at a plan to progressively update the advertising code for cannabis. We have several social equity licenses, micro dispensaries, new facilities coming online, and you're setting them up to fail if they are not able to grow a customer base. Fortunately, a lot of the medical dispensaries, when we switched over, had customer bases so they could expand and grow. But these new folks do not have that base to grow their business, and you're going to set them up to fail. The data shows that sales have been flat, if not reduced, since the increase to 12% on the tax. And so I think it's important that the administration going forward look at directional signage, basic information that allows customers to safely find and their dispensary in their neighborhood going forward. Then the state will succeed and everyone will succeed. Thank you, Mr. Chairman.
Thank you, Vice Chair, Chair, members of the committee. I'm with the Maryland Coalition for Cannabis Equity. My colleague Taylor, I think, really hit on a lot of the important points. I just wanted to first off say thank you all. This is the right thing to do, what you did for our class of licenses. We represent those individuals here to try to mitigate the impacts of the war on drugs when the prohibitions on cannabis were around. I'm from West Baltimore myself, and there were a lot of things that happened that should not happen, and this new regime is going to help right some of those wrongs. So we are here, and we are understanding that we have to be competitive, we have to be strategic, but we just don't want the state or the regulations to make it harder on us, as the gentleman just said, as we're coming online. So if the goal is to diversify, to increase the industry, to remove the illicit market, that's what we're here to do, and we're excited about the opportunity, and thank you. But just don't make it harder than it already is on us, is all we ask, and just consider what the impacts might be to just our group of licenses as you look at policy. So thank you.
Thank you. Are there any questions of this panel? Seeing none, thank you all so very much. Next, we're going to hear from a panel of favorable with amendments, starting with Justin Garcia, Selena Raleigh, and what? Okay. Maybe not. Maybe that's a mistake. All right. Justin, you may proceed soon as you're ready.
Thank you, Mr. Vice Chair. Good afternoon. Thank you to the Chair and the Vice Chair, members of the Senate Finance Committee for the opportunity to be here today. My name is Justin Garcia. I serve as Chair on the Maryland Advisory Board on Medical and Adult Use Cannabis. Our board was appointed to provide recommendations regarding the rules and regulations of Maryland's cannabis industry. In my day job, I serve as Chief Marketing Officer for SunMed Growers, a local family-owned cannabis company right here in Maryland, and one of the original licensees from the medical cannabis program. I'm here today to provide favorable testimony with amendment for SB 594. We as a board believe this bill will help cannabis licensees and the industry as a whole by addressing what currently feels like overly constrained public-facing communications. The operational and conditional licensees that we have heard from have expressed the lack of clarity and, frankly, a fear of repercussion around routine, responsible engagement with adult consumers and patients. We cannot hope to grow an industry, one that was voted on by members in this chamber and 2/3 of Marylanders, that cannot be talked about in a public forum or with signage as simple as open. More than a business concern, the rigidity around current cannabis advertising regulations limits consumer education and the growth of the medical cannabis program, a program we're seeing a steady decline in registration year over year. Public education cannot be carried out by government and public health agencies alone, and where there is a lack of information, a vacuum is formed and filled with unregulated actors and intoxicating hemp, an issue that we perceive to be a grave threat to youth and consumer safety. SB 594 moves us in the right direction, replacing prescriptive standards with clear guardrails while still effectively protecting our youth. The amendments we would advocate for are to remove the prescriptive checklists for signage and instead move back to the rules, ones that were referenced earlier in testimony, that were effective during the medical cannabis program. No youth targeting imagery, no false misleading claims, no obscene content. This bill takes significant strides, and we appreciate the time to be here today. Thank you.
Good afternoon, everyone. My name is Selena Raleigh. I'm the Deputy Chief of Legislative Affairs at the Maryland Cannabis Administration. On behalf of the MCA, I want to begin by thanking Chair Beidel for her continued leadership on cannabis policy and for her thoughtful work to clarify and strengthen Maryland's advertising framework. We're grateful for your partnership and for the flexibility this bill provides the administration in enforcing advertising standards in a modern marketplace. The MCA supports SB 594 with 3 targeted amendments, which are detailed in our written testimony, but I will briefly summarize for the committee today. First, we recommend striking the proposed statutory definition of therapeutic or medical claims. Since July of 2023, there have been no issued violations in this area and no formal concerns from industry regarding MCA's current guidance on this matter. Codifying a narrow definition could limit flexibility for both MCA and licensees, especially as we anticipate potential federal rescheduling and evolving science. We believe this issue is best addressed through regulations that MCA is prepared to develop in collaboration with industry and our partners in the state. Second, we recommend retaining the phrase "or is attractive to" on page 2, line 25, in the youth advertising protections to preserve Maryland's strong public health safeguards. Removing this phrase could weaken protections by allowing advertising that may not explicitly target minors, but is still clearly appealing to them. And third, we recommend clarifying the editorial exception by adding "commissioned by or" on page 5, line 7, to close a potential loophole and ensure that paid-for articles and other media cannot be disguised as journalism while still protecting legitimate news reporting. With these amendments, the administration supports the bill's broader goals, and we respectfully ask the committee to adopt our amendments and issue a favorable report. We direct you to our written testimony for detailed language and rationale, and we appreciate the committee's continued partnership in ensuring that Maryland's cannabis market remains safe, equitable, and protective of public health. Thank you, and I'm happy to answer any questions.
Thank you. Are there any questions? Senator Lamb.
Thank you, Vice Chair. I just wanted to follow up on Ms. Raleigh and your testimony from the Cannabis Administration here. You had suggested that via an amendment removing the therapeutic definition, I guess that's currently in the bill, right? You know, I guess some thought here of that, like, you know, the therapeutic definition is important, right? There are a lot of wild claims being made by, you know, probably less scrupulous producers and whatnot about like what cannabis can actually do. So, you know, it sounded like from your testimony that the preference of the administration is to address this via regs, I guess. Is that your preference?
Yeah, the preference is to address through regs because this issue hasn't really come up in terms of violations. The administration thinks it would be prudent to take this to the regulatory process where we can open the conversation up for public comment, work with industry and key stakeholders to actually develop a definition that works for both industry while still protecting the public health interest.
Okay. So your commitment is, because I think it is important to have some guidance here because some of the health claims are pretty out there when it comes to some of the products that are, you know, less scrupulous producers are making some of these claims that there are these certain health benefits, which are really probably, you know, a little bit of a hyperbole. So the commitment from the administration, from MCA, is to look into this and address this via forthcoming regs. Your preference is to have that flexibility to make those adjustments via regs, not in statute here.
Yeah, exactly.
Okay. But the commitment is there to try to address this.
Yes, the agency is committed to addressing this.
Okay. Thank you.
Are there any additional questions of this panel? Seeing none, thank you all so very much. Lastly, we will hear some unfavorable testimony from Stephen McKitchney, George Townsend. Unfavorable testimony. Stephen, are you here? All right, there you guys go. Thank you all so very much. You all may begin when you're ready.
Mr. Vice Chair, Committee, my name is Stephen McKechnie. I'm here on behalf of the Public Health Law Clinic for the University of Maryland Carey School of Law, and I'm here today in opposition of Senate Bill 594 because it unnecessarily risks Maryland's minors and consumers. It risks Maryland's minors by repealing current advertising restrictions and allowing the implicit targeting of minors and usage of elements which can be found attractive to minors in their advertising. Now, cannabis usage with adolescents has been found linked to conditions such as anxiety, depression, neurocognitive decline in adulthood, and worsened academic success. Additionally, studies have shown that exposure to cannabis advertisements increases the likelihood to use cannabis. Now, Maryland recognized this in 2023 and put protections in place in areas such as advertising, packaging, and labeling, which all function to reduce the appeal of cannabis to those under the age of 21. This bill would undo that work. Currently, Maryland sits among 27 other states who have provisions prohibiting the indirect targeting of minors from cannabis advertisements. This bill also risks Maryland's consumers by limiting the definition of therapeutic or medical claim to only explicit claims, thus allowing implicit claims to be made without reliable evidence. As the FTC agrees, medical benefits should only be asserted when it is accompanied by evidence. Studies have shown that when implicit therapeutic or medical claims can be made without reliable evidence, they can be false or misleading. And consumers may be relying on these cannabis advertisements over evidence-based treatments recommended by their healthcare professionals, which, if these claims were unfounded, could lead to worsened health conditions. Currently, 11 other states require all kinds of therapeutic or medical claims to be accompanied by evidence, while 16 states outright ban such claims regardless of the presence of evidence. Senate Bill 594 would remove Maryland from the majority of states who recognize the importance of protecting minors from unnecessary cannabis exposure, and from the majority who understand that we should protect our consumers from unfounded claims. Thank you.
Mr. Vice Chair, committee members, good afternoon. My name is George Townsend, and I'm an attorney at the Legal Resource Center for Public Health Policy. I'm here today testifying in opposition to Senate Bill 594. The Legal Resource Center has concerns about a handful of specific elements of this bill, specifically the aspects that would remove language related to the indirect targeting of underage individuals, the language that would remove the prohibition against appealing to minors, and the what we see as a narrowed definition of therapeutic and medical claims. Maryland's advertising laws, as they currently exist, reflect a balance. On one hand, making sure that adult cannabis consumers can learn about and acquire cannabis products, while on the other hand, protecting underage individuals from the harms of cannabis advertising exposure. These harms are not merely theoretical. There are scientific studies that have shown that exposure to cannabis advertising during adolescence leads to an increase in underage cannabis use and the incidence of cannabis use disorder. Since recreational cannabis can only be sold to adults over 21, it is obvious that direct targeting of minors is and should be prohibited. But indirect marketing needs to also be limited. The language in Maryland's cannabis advertising laws that prohibit indirect targeting of underage individuals places a burden squarely on cannabis businesses to ensure that their advertisements are directed at adults, and to take reasonable care to ensure that they are not harming minors. Removing this language would give advertisers plausible deniability to ignore the impact of their advertisements on children, so long as they can claim they were not directly targeting those individuals. Next, Maryland requires that a cannabis ad that contains a medical or therapeutic claim be subject to two additional requirements. First, there has to be evidence of that health claim, and secondly, it has to be accompanied by a disclosure of side effects. We're concerned that the use of the word explicitly in the definition of a claim would allow advertisers to rely on vague or ambiguous language. For these reasons, we respectfully request an unfavorable report, and we're happy to answer any questions you have.
Indeed, thank you so much for your testimony. Are there any questions for this panel? Senator Ellis.
Thank you, Mr. Chair, and thank you for your testimony, gentlemen. I appreciate it. Mr. McKechnie?
Yes.
So you were at, what's your organization you're with?
The Public Health Law Clinic at the University of Maryland Carey School of Law.
Okay. So a lot of times individuals come to testify when they're part of organizations like that. They're like, well, I'm not staying in the position of this organization, but you didn't say that. So is this basically the position of your law clinic, basically official position?
Yes.
Okay, that's the record, okay. And the University of Maryland Carey School of Law?
Yes.
Okay. What type of research did your law clinic do in this area to really present your facts?
Well, Senator, as it pertained to the statutory language, well, we'll start with the indirect targeting. For the statutory language, we went through the states with comprehensive cannabis programs, and we read their language through their advertising statutes for, do they have indirect targeting language?
I'm sorry, could you pull the mic a little closer?
Do they have indirect targeting language? Do they have language which relates to appealing / being attractive to minors? And what we had found was that of the 27 states specifically, 22 of them were using language which related to appealing or being attractive to minors, while 19 of them used language which was reflective of an indirect targeting standard, such as likely to appeal or indirect targeting towards minors, and that 14 of them even used the combined language between the two. So this is what kind of built our background research for how many states understand this importance of protecting the indirect targeting for minors.
Okay.
And then as it pertained to therapeutic or medical claims, we followed a similar track of reading through other states and how they are explaining therapeutic or medical claims, and do they require the accompanying of evidence.
Okay. So, like, what kind of hours did y'all put into coming up with all the research and members of your team to come up with this testimony? Roughly, you know.
I would say over 30 hours.
Over 30 hours, okay. So of all the states that you did your research, which ones most accurately reflect your position in this testimony? And how many are in that category?
As a senator, I don't have the specific states that have the identical language.
generally.
We did have, for the indirect targeting, the 14 states which shared both mentioning an prohibiting indirect targeting and prohibiting being appealing or attractive to minors. And additionally, with the therapeutic or medical claims, there were 11 states which had a very similar statute for requiring evidence as it pertained to making a therapeutic or medical claim, even if it's implicit. And
Current Maryland law closely reflected those states that you
yes,
quoted, and around 14.
Yes, 14 for both the appealing / attractive and indirect.
So the way the law was crafted, and I had the privilege of voting on those, was aimed to really protect minors. And those are strong laws that in your research that the original law, but this law now will weaken those standards, what you're saying.
Yes, this law would take Maryland out of the 27 states who have either appeal or indirect as that majority group out of the 41, I believe, that have those types of laws. And then for the therapeutic or medical claims, it would take them out of the group of 11 states who have that standard.
And basically, your research law can support us keeping the original provisions of the law to protect minors.
Yes, Senator, that's correct.
Okay. And did you do any research to say which communities of, say, minors, children, will be most harmed when we loosen up the rules?
No, Senator, we did not specifically look into which areas throughout the state might face those harms. There was some preliminary research done on lower income neighborhoods with high retail activity, but we...
Preliminary research?
Yeah.
So you can't state what preliminary findings you have?
I could find those findings and bring them to you when I have them.
Do you have those findings?
I don't have them specifically, no, but I do think they would be enlightening if we had them.
Yeah, it should be enlightening because when you look at tobacco use and alcohol, the targeted communities are Black communities. And our state data agency have data that states that when it comes to tobacco and alcohol. So reach out to our data agency to get that data, right? And if you could, get back to us before we vote on this bill. Because I want us to make a decision for the children of Maryland, to protect all children. And let me say that as we drive through communities in the state of Maryland, even fast food restaurants in affluent areas, they don't have really flamboyant signage. They're kind of hidden, if you can find them in affluent areas. And that's fast foods. Local zoning protect the affluent communities, the majority white communities, from the dangers of fast food. You know, all the high sodium, high fat, ultra processed stuff that is decimating the Black communities throughout Maryland and the nation. And then if you go towards, look at the liquor stores, you drive through less affluent areas throughout Maryland. You see the liquor stores, all their ads with skimpily dressed women, which attracts boys. And basically, when they can, they will go and buy. And our state data agency have that data, which I had access to early on. And so I'm very concerned about liberalizing this law, which will target my community and my children and my grandchildren. And I don't care about the profit of anybody selling any kind of marijuana. I care about protecting my children and grandchildren and children in my community. So I appreciate your research. And I hope that you can get that data back to me before we vote on this, to put it on the record that liberalizing this law will cause damage like tobacco sales and alcohol sales to the Black community more than any other community. And we as a body, as we pass bills to improve Black health, we cannot pass bills to liberalize, which cause additional damage to my community. And so I would look forward to get that data from you. And thank you for your research. And thank you for the energy you put into this. And thank you for being here.
Thank you, Senator.
You're welcome.
Isn't that so? Thank you, Senator. Appreciate it. Are there any additional questions? Senator Lamb.
Vice Chair, I just had one follow-up question from what Senator Ellis was saying. I mean, you bring up a lot of points. Have you had any communication or conversation with the Maryland Cannabis Administration? Any outreach to them about these issues? What have you heard back? What's, where has that gone?
I can't say. I believe my office did make an initial reach out for comments on it and did not have much engagement specifically on this bill with the MCA.
So you didn't hear back?
Correct.
Okay. I mean, for the folks from the MCA, would encourage you to try to have that conversation. That'd be helpful.
Thank you.
Thank you.
Senator Kramer.
Thank you, Mr. Chair. Gentleman, question. We heard from the proponents that there's some concern about using two terms that this bill would strike from existing law with regard to advertising for cannabis products, I think particularly, where it indicates that the advertising may not directly, and what's stricken from this is, or indirectly, target individuals under the age of 21, and then continues with targets or is attractive to, which is what is stricken, minors, including a cartoon character, mascot, etc. Do you have thoughts as to, share with me whether you see that as being ambiguous, and is it something that makes it difficult for, people in the industry to figure out what it is they should or should not doing? And is there anything comparable in other states to this same language, and they're evidently working with it?
I appreciate the question. I think we don't see it as an ambiguous standard or a vague standard that is difficult to match. It is certainly a very protective standard, but as has been pointed out, it's important that there be a protective, strong standard because the interest of the state of Maryland is significant. We need to protect the health of our youth, of our underage people. And I know Stephen spoke to in his testimony about the other states that use similar language, and he can certainly speak to that as well. But something that I think is important to remember here is that the market for recreational cannabis products is adults. And cannabis companies are allowed to direct their advertising at that audience, at adults. The portions of the bill you're referring to would allow them to target underage individuals who are not capable of going to that store and buying those products, who are not the customer base that they are necessarily looking to expand or shouldn't be looking to expand their business into. And that's why we see that, what we see as the importance of that language, why we think it's an essential standard, even if it does make it a little bit, if it requires some more thought, some more consideration on how the companies design their advertising. Because again, we're not disputing the right or the need of these businesses to advertise to adults.
Got it. Okay. Thank you, Mr. Chair.
Chair Bidle.
Thank you, Mr. Vice Chair. So, gentlemen, thank you for your testimony. I have some direct questions for the gentleman from the Cary School of Law. We took out the word indirectly. So we leave the language directly target individuals under the age of 21 and targets minors, including a cartoon character, mascot, or other depiction that's commonly used. So those words are all left in. So do you think a store putting Christmas decorations inside their store so that when a youth walks by, they see Christmas decorations, do you think that attracts them to cannabis? I have another one for you. Do you think because the cannabis store paints a pretty mural on the side of the building, not depicting cannabis, that attracts children to that store?
Senator, I thank you for your question.
Let me give you a third one. I have a very generous donor who significantly endorsed a golf tournament, $25,000, where the people purchasing the foursomes had to pay $2,500 for a foursome. He couldn't advertise. He could not put his logo in because there might be children under 21 there. Now, how many children do you think bought a $2,500 foursome? That's what we're getting to in this bill. Don't you agree?
Well, Senator, thank you for your question. First of all, I would love to be able to spend $2,500.
You have to have the microphone closer, sir.
I would love a $2,500 golf course round. That sounds like a lot of fun. However, when it comes to the gray area of what falls under the purview of indirect targeting, I think that what the MCA had suggested is a great idea to be able to work those situations out where if they are willing to create a list of including but potentially not limited to these potential things, then that might help to create more clarity in the issue of people putting up normal Christmas lights and it causing some infractions with the law and similarly with the murals.
Well, I think if the MCA was responsive, that might be very helpful. But at this point, we have a number of inspectors that are kind of going off the grid, and there's nothing being done to draw back those kinds of fines that are happening. So it's been a very difficult situation. But thank you for your testimony.
Thank you.
Any additional questions of this panel? Seeing none, this ends the in-person testimony for Senate Bill 594. We do have two virtual witnesses, and we're going to start with Vanessa. Vanessa, you may proceed and come off of mute. Vanessa, are you able to hear us? You're still on mute. We're ready for your testimony.
Sorry, if it's me, if it's Venus.
Yes.
Okay, perfect.
Venus.
Sorry, thank you. About,
Yes.
sorry about that. And dear Chair Bidle and members of the committee, my name is Venus Hemachandra, and I have been in the Maryland cannabis industry since 2017. I previously held a medical cannabis dispensary license, and I am now in the process of opening a new social equity dispensary in Parkville in Baltimore County. I also serve as the current president of the Maryland Dispensary Association. I strongly support these proposed advertising alterations. Licensed dispensaries already operate under extremely restrictive advertising rules and are effectively limited to a single exterior sign. This impacts social equity operators in particular because as new businesses, we can't use basic directional signage to let people, or even open signs, to let folks know that we exist. Dispensaries will be located, so my dispensary will be located in a shopping plaza with multiple other businesses. Without reasonable wayfinding tools, customers and patients may not be able to find us. When licensed dispensaries cannot clearly communicate that we are state licensed facilities, we cannot distinguish ourselves from illicit storefronts which carry non-compliant, untested products. One of our members, as Ashley mentioned, had gotten fined for a women-owned sign at her dispensary. This is not about promotion. It's about access and visibility for licensed, regulated minority and women-owned businesses. I also support defining therapeutic and medical claims. Members are actually currently being cited for standard effect-based language on age-gated websites, such as help promote stress relief, or effects may include relaxation, hunger, or happiness. The product description should be allowed to include general effect-based information so consumers can make informed choices. Clear definitions will ensure consistent enforcement while prohibiting improper medical claims. Maryland licensees want to comply. We simply need clear, fair standards to compete in a regulated marketplace. I respectfully urge your support on SB 594. Thank you.
Excellent, thank you. Are there any questions for Venus? Sorry about that. Thank you so much for your testimony. Lastly, we will hear from Jamie Elwood. Jamie, you may proceed.
Hello, Madam Chair and members of the committee. Thank you for having me today. My name is Jamie Elwood. I serve on the leadership team of Trilogy Wellness of Maryland, an independent dispensary, and have worked as an executive and marketing executive in Maryland and national advertising for over 25 years. I'm also a mother of 3 teenagers that I've been raising while working in this industry, and I strongly support responsible regulation that protects youth and our consumers. I support Senate Bill 594 because it brings the needed clarity to cannabis advertising and compliance. However, I respectfully urge refinement so that we have a consistent, fair, and workable implementation. So I don't repeat a lot that has already been said. I'd like to make 2 distinct points. First, regarding digital advertising audience composition, our company is using industry standard 21+ targeting tools that are nationally accredited. These platforms rely on anonymized aggregated data and comply with privacy laws. However, raw data is being requested from the MCA in order to satisfy compliance standards, and that basically creates an impossible compliance standard. I'd also like to address the medical and therapeutic claims. We fully support prohibitions on claiming products cure or treat diseases. However, there is a clear distinction between impermissible disease claims and permissible descriptions of expected product effects. Adult consumers, especially medical patients, need accurate information about cannabinoid content, terpene profiles, and anticipated product effects in order to make informed decisions around products. Clear guidance distinguishing education from prohibited claims would better serve public safety. I respectfully urge support of Senate Bill 594 and consideration of these clarifying amendments. Thank you.
Are there any questions, Senator Ellis?
Thank you, Mr. Vice Chair. Ms. Elwood, Arthur Ellis here. So what is Trilogy Wellness of Maryland? That's the organization that's put down on you represent.
We are a independent operating dispensary in Ellicott City, Maryland.
Ellicott City, okay. And so you're saying that you tried to get data from the Maryland Cannabis Administration and you couldn't?
So what we have been doing is following the policy where we submit for pre-authorization of any type of advertising targeting, campaign we want to do. So for example, if we wanted to do a digital advertising campaign, there's a process. The advertisers that we are trying to work with nationally accredited data providers, such as like a Nielsen, to be able to say that this particular advertisement will target 21 and over. But that is not being accepted by the MCA because they want raw data, which privacy laws prohibit. So we as advertisers do not have access to that data. Therefore, we have not been able to pursue any type of advertising, even though we can demonstrate that we can target 21+. So that is not only the situation for us as operators that have been in the business, since the inception of the program, but also for any social equity dispensary coming online that wants to promote their business.
Yeah, thank you. So what type of raw data does the Cannabis Administration need? When you say raw data?
Meaning they've been, so, Nielsen or Epsilon, these data aggregators, they aggregate and target based on data that, is behind a firewall, basically, so privacy. They're asking for the actual, names and phone numbers and proof that these people are 21, and that's just not something, we can provide that from our own database for people who have actually come into our dispensary, but there's no way to, to run an advertisement with a WBAL here on TV locally or any type of digital platform where they're actually going to provide their true consumer data. And that's what's being requested of us.
Okay, thank you for the answer. And being in Ellicott City, are you subject to county zoning laws also?
Yes. So there are other regulations, around signage and that type of thing.
I'm sorry,
that we
there are
also
other
have to-
what? There are
I'm
other
sorry?
what? You said there are other,
So I'm saying that, yes, in Howard County, we're subject to other certain regulations around signage and things of that nature, if that's what you're asking.
yes, And so in addition to Maryland Cannabis Administration, you have also Howard County coming in and imposing local signage zoning laws.
That's correct.
Yeah, okay. Do you find there's a conflict between the two, or it's basically it's piling on, additional different rules?
No, I think the county would actually allow us to have a lot more signage than we are, allowed to per the current cannabis rules.
Okay, great. Well, thank you for your answer, and thank you, Madam Chair.
Thank you.
Mr. Chairman.
Thank you, Senator Ellis. Are there any additional questions? Seeing none, this ends the testimony on Senate Bill 594 and the hearing today. I'm going to turn it back over to Madam Chair.
Thank you. Next, we're going to hear Senate Bill 571, Commercial Law Broadband Access, Low-Income Consumer Programs. And Senator Ellis, you have Joseph Mink, Jennifer Bevan Dangle, Gretchen LeGrande on your panel, and then one virtual panel member that we'll get to after that.
Yes, sure. Madam Chair, Vice Chair, members of the committee, this is a much easier bill. It'll be a quicker bill than the previous one. Good afternoon, Senator Arthur Ellis, District 28, Charles County. I'm here to present Senate Bill 0571, which requires each of the broadband providers serving 10,000 or more customers to establish a low-income consumer program. The bill establishes eligibility, criteria, program requirements, minimum broadband internet speeds, and filing requirements. Establishing a low-income consumer program creates accessible broadband access for low-income consumers and prohibits discrimination and abusive trade practices outlined in the Maryland Consumer Protection Act. Program eligibility cannot require consumers to enroll in an automatic payment plan. Therefore, customers of the program can purchase a standalone broadband service or broadband service bundled with a phone or cable television service. What's the impact of this bill? So here in Annapolis, I've been here 8 years, and one thing I've noticed, the poor people, the children, never have lobbyists pushing their interests. Never, ever, ever. But the folks who make money off the laws we pass, they have high-paid lobbyists, multiple lobbyists pushing for these issues. And when these issues come before us in Annapolis, we hear from the rich people. And so many times they come in saying, hey, it's be bad. Helping poor people is bad. Looking out for children when it comes to other stuff is bad. Looking out for all these people who cannot afford the lobbyists. And with this bill, the money people come say, hey, no, we can't do this. We can't look out for poor people. We can't give them low-cost broadband access. It'll mess up our bottom line. So guess what? The poor continue to be poor. They cannot educate their children with internet access for them to do their schoolwork. And when we have these snowstorms that shut down the schools for 2 weeks, they can't do their schoolwork because they don't have internet access. So we as a state, because they are poor people, we keep them in the bondage of poverty. Because as a state, we're like, hey, we just listen to the rich people and the people with big money to present their case. I've seen this time and time again. This bill is a simple bill, Bill 0571, to look out for the poor people, the lesser of these, where Jesus tells us, always look out for the least of these. I will bless you when you look out for the least of these. My people, people who can't hire the folks to walk around in their $1,000 suits and their loafers and to influence these legislation. My good Lord has sent me here to speak up for the poor people and to present these bills and to present these issues to say, yes, yes, let's look out for the lesser of these so all these poor people can have an opportunity for their children to be affluent, to get an education, to have internet access to do their homework, to have internet access to look for a job, to have internet access to make a doctor's appointment. And that's what this bill does. And colleagues, I hope and pray, I do a lot of praying around here to my Lord and Savior Jesus Christ for success in looking out for poor people and to positive favorable report on Senate Bill 571. Thank you for your consideration.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Jennifer Bevan Dangle. I'm the Deputy Director of Economic Action Maryland Fund. It's probably appropriate for me to go next as we will put some data behind what the sponsor was speaking to in terms of who benefits and who needs this legislation. We all are well aware that broadband access is no longer sort of a trivial nice to have. It is essential. My husband teaches in Anne Arundel County, and so they've had plenty of virtual school days already. And as the senator pointed out, those kids are expected to be online, even if the teachers maybe wish they weren't. But it goes beyond that. It follows you all through your life. Economic Action Maryland Fund has a direct outreach, direct service program that works with seniors. One of the most common problems that they face is getting online, navigating these online portals, doing the work to fill out forms. And we're all very well aware that the recent federal changes in Medicaid and SNAP enrollment are going to require twice annual reapplications, and making sure that people have access to broadband to complete those applications to keep them enrolled. This has certainly gone far beyond just school and jobs. It's gone into staying in line for federal assistance, staying in line for very critical and urgently needed benefits, which I know this committee hears plenty about. But just to put some data behind that, last year into the start of this year, Economic Action Maryland Fund conducted a study of about 500 of our clients and supporters, people across Maryland, and we found that 25% of those who took this survey, just 25% of just 500 Marylanders, said that broadband access specifically was going to be a barrier for them to completing these Medicaid renewals. So this is very real. The data is there to show that broadband access is incredibly critical for so many reasons across our community, and so we urge a favorable report.
I am. Madam Chair, Vice Chair, members of the committee, thank you for the opportunity to testify today. My name is Gretchen LeGrand. I'm a Senior Program Officer at the Robert W. Deutsch Foundation. The foundation has been heavily involved in digital equity efforts in Baltimore City since the 90s. I think everyone agrees, even our friends at the ISPs agree that everybody should have access to high-quality, affordable internet. So I'm going to just focus on today a few points of clarification and how this bill relates to the federal BEAD program and provider participation. First, SB 571 is fully consistent with Maryland's approved BEAD plan and with the most current NTIA guidance. Under federal statute, BEAD-funded providers are already required to offer at least one low-cost broadband service option for eligible households. Maryland's BEAD proposal, approved by NTIA, explicitly certifies that requirement. This bill extends that to all providers in the state, not just the ones that are receiving BEAD funds. This bill does not set prices or regulate rates. In fact, it does the opposite. It creates a process for defining affordability that must comply with federal law and receive NTIA approval. Any affordability standard developed under this bill must meet federal requirements. If NTIA were to determine that a definition is inconsistent, it simply would not be approved. The federal backstop is written directly into the bill. Second, this legislation does not threaten provider participation. Maryland already requires BEAD subgrantees to offer low-cost options. Many already do, and the bill applies only to large providers with over 20,000 subscribers. There's another concern that this impacts providers leaving the state. New York passed a similar affordability bill, and people will tell you that AT&T pulled out of the state. AT&T suspended one service in their state. They are still, AT&T is still a large presence in New York in terms of mobile and cellular. So just wanted to address that. Thank you. I urge a favorable report.
And finally, Joseph.
Hello, thank you, Madam Chair, Vice Chair, esteemed members of the committee. My name is Joseph Mank. I'm a resident of District 28, which is Arthur Ellis's district. So I'm here to put a human face on this bill. And just to state, when I was younger, I grew up lower middle class. And I know that was a while back, and for a lot of us, school supplies, things that were essential, pens, folders, paper, dividers, those simple things that a lot of families were able to have. When I grew up, those things were scarce. And as a 7 or 8 or 9-year-old, 10-year-old, the anxiety and the things that those things create in your developmental learning years is important. Now we're turning into the other quarter of the 21st century. Those things are now broadband. Those are now computers. Those are tablets, cell phones. And a lot of times the school systems will provide those things to the students. But if they get home and they don't have the internet to connect those things to, they're not able to do that virtual learning. They're not able to dial into the local library's website and get those free books and audiobooks and those resources that our taxpayers, that you folks as legislators provide for us. So I urge a favorable on this bill for the human beings and the lower middle class folks in our communities, things that we take for granted, that we could pick up our phones and we got these great speeds and access to all this data. These children sometimes don't have those things, and unfortunately because of their family circumstances. And those things are outside, I can relate to this, that's outside of their control, their children. Once again, Joseph Mank, District 28, thank you.
Let's hear from our virtual witness, and then we'll ask questions of your panel. So it's Mitsuko Herrera. Unmute and present your testimony, please. Thank you.
Yes, ma'am. My name is Mitsuko Herrera. I am with the Montgomery County Department of Technology and Enterprise Business Solution, TEBS. TEBS supports SB 571. 4 quick points. SB 571 was written to comply with BEAD. At page 7, SB 571 states the purpose of the advisory board is to establish a definition for low-cost broadband service as required by 47 U.S.C. 1702, which is the BEAD statute. The BEAD statute states that providers receiving BEAD funding, quote, shall not offer less than one low-cost broadband service option as defined by paragraph 5. And paragraph 5 requires Maryland to provide a proposed definition of low-cost broadband service option and consult with the prospective grantees, the providers, before submitting the definition. SB 571 is creating the advisory board of state agencies, broadband providers, and key stakeholders to create the definition as required by BEAD. 2, New York has affordable broadband law, and its final BEAD proposal was approved by the federal government in December of 25. And there's no evidence that providers charge more in New York, where affordable broadband has been in place since 2025, than they do in Maryland. 3, SB 571 is good for the Maryland economy. BEAD funding has been reduced from 267 to 79 million. It will bring needed broadband to 9,000 homes, but 29% of those projects are going to be satellite broadband. In contrast, this bill helps over 700,000 low-income households get access to 100 by 20 megabit service and could help those families earn an additional $75 million in income at no cost to the state because access to affordable broadband plan increases household income by $170 and employment by 9%. Lastly, volunteer participation is not enough. When the Affordable Connectivity Program ACP subsidy ended, only 2 providers continued to offer it. 30% of Maryland households subscribing to broadband are low income. 23% of low income households have to subscribe to an internet plan below the federal minimum speed. Maryland needs access to affordable broadband plans, and for these reasons, we respectfully ask for a favorable report on SB 571. Thank you.
Thank you. So do I have any questions for our panel or our virtual witness? Senator Hershey.
Thank you, Madam Chair. Ms. LeGrand, you were the one that first started talking about BEAD, and you mentioned that many of the broadband providers already provide a low-income customer rates. Is that accurate?
Yeah, Comcast, for instance, offers a plan that's 100 over 20 for $30 a month, and that is aligned with what the NTIA has said is a model of what an affordable plan could look like.
Okay, so Comcast does. How many broadband providers are in the state that would fit this piece of legislation?
I don't know off the top of my head, but Comcast, Verizon, some BEAD funds were awarded to Kuiper, which is the Amazon satellite service. There's a number of smaller ISPs for whom this would not apply. They would get an exemption.
Right. But for the ones that it applies to, how many of them are already not providing a low income customer rate?
I'm sorry, I don't have that information off the top of my head.
Isn't that an important element of this bill? I mean, if it's already being provided, why do we have to have the bill?
Yeah, I think it's just to sort of put in statute that we're investing, millions and millions of dollars in infrastructure for these companies to be able to provide service to more customers, and just sort of saying, like, if you're welcome for the money, and now make sure you provide Marylanders with affordable internet.
Yeah, and that's what it appears that the federal government has done, because broadband is regulated not by the PSC, but by the FCC, correct?
Broadband is not regulated at all.
Or there's oversight of it.
It falls within FCC jurisdiction, but there's no regulation.
But you said that a requirement to accept BEAD funds or program money would be that you have to have a low-income customer rate.
That was in the NTIA statute, or in the statute, the BEAD statute.
Okay, so it seems like, one of the other things that we talked about, going back to what is regulated, energy prices in Maryland are regulated by the Public Service Commission, and those prices are going up and up and up and up and up. What are broadband prices doing?
Broadband prices are generally not going up. I think
they're not.
Mitzi said in New York,
they're going down.
Even after the affordability law was put into place, rates have stayed stable.
Yeah, stable or gone down because there's competition, right?
Competition certainly helps, but there are many areas of our state where there is no competition.
Yeah.
If I could on the.
No, that's okay. All right. I'm good. Thank you, madam. Thank you very much.
Thank you. Senator Owens?
Yeah, thank you, Madam Chair. So to answer Senator Hershey's question, I think Ms. Herrera, she has the data. She's with the government, and she talked about it in her testimony. Could you answer that, Ms. Herrera, as far as what Senator Hershey just asked? And you had your hands up, but unfortunately, we don't recognize that. But I want to give you the opportunity to answer.
I'm trying to remember what the second question was. The first question is, there's probably somewhere between 9 or 13 providers in the state that the bill may apply to. Those are wireline and wireless providers. For those plans, there's a variety of plans offered, but several of those plans do not meet the minimum federal broadband speed of 100 by 20 megabits per second. So even though they offer a plan, they don't offer it at the speed that the federal government says you need at minimum so that you can do homework, have a healthcare visit, etc. The other thing is that on the broadband plans, what you've generally seen is that the wireless plans have become more competitive, but the wireline plans have gone up in price.
Yeah. Thank you, Madam Chair.
Thank you. I don't see any other questions. That ends this panel, and now we're going to go to the unfavorables. Rob Garagiola, Jeremy Crandall, and Megan Stokes. Who would like to start? You again, Rob? Okay.
I'll start again. Sure. Thank you, Madam Chair, and members of the committee. Rob Garagiola with Compass Advocacy on behalf of CTIA. And respectfully, and I also reached out to Senator Ellis, but we're here unfavorable for Senate Bill 571. We certainly appreciate the sponsor's intent and goals with the legislation, but have some concerns about it, and I'd like to make 3 points. Number one, such legislation would likely jeopardize BEAD broadband funding, about $80 million that Maryland could receive from the federal government. And I will say that there was similar legislation in California. California Assemblyperson had introduced some legislation in 2025. They got word about the concerns with federal BEAD funding, and that legislator actually withdrew the legislation, and that legislation did not advance in California because of concerns about losing federal BEAD funding. Number two, competition is fierce among wireless companies. They're keeping the prices low while making significant technological investment, upwards of $10 billion in the state of Maryland. And prices for wireless has gone down. I think Senator Hershey touched on that point, unlike energy, food, and other necessities. And I'll also add that several carriers do have existing programs to help low-income individuals. And then number three, passage of such legislation could lead to higher wireless costs for all of your constituents. It could lead to less investment, including those federal dollars that I mentioned, and slower deployment of wireless in the state. There's substantial investment going on. We want to continue that. And so respectfully, would urge an unfavorable for Senate Bill 571 and would turn it over to Jeremy Crandall with CTIA.
Thanks, Rob. Once more for the record, name is Jeremy Crandall, representing CTIA, the Wireless Industry Trade Association, in opposition to Senate Bill 571. I want to begin by saying our opposition is not about the intent of this bill. It is about what this bill does in practice from a policy perspective. And I would urge you to consider two core elements as it relates to the bill. First, let's be clear about what this bill does. It imposes an artificial price mandate on private companies operating here in Maryland, the same as if the bill before you set the price of a gallon of gas or a carton of eggs. And while we understand the intent, history does show that government-set price controls lead to fewer choices, reduced investments, and higher costs. Now, Senator Hershey, I can't say it any better than you about what wireless prices are doing. They are going down. But I do want, and I will emphasize, what good or service can we say that about right now in terms of what Maryland consumers and businesses pay for? But I do want to focus on one item that was touched on a number of times in the previous testimony. That is this question of BEAD funding. I cannot be more emphatic. Maryland's BEAD funding will be at risk with passage of this bill. And there's one key sentence that was not shared in their testimony. In that BEAD guidance, it says specifically that this low-cost service option, quote, that rate must be set by the grantee themselves, not the state government. And so I really want to emphasize that when we're talking about it. Rob mentioned California. It is also true that a similar bill was withdrawn in California within approximately 3 weeks of that first BEAD guidance coming out from the federal government. And California had approximately $2 billion in funding at risk. And so just to reiterate, these are not theoretical risks that we're emphasizing here. We do have a strong but respectful opposition from a policy perspective, but I'm also happy to speak more about this BEAD vulnerability as well. Thank you.
Good afternoon, Madam Chair and members of the Senate Finance Committee. My name is Megan Stokes, and I am the State Policy Director for the Computer and Communications Industry Association, respectfully opposing Senate Bill 571. We mentioned earlier about my members here, but also our members have strongly supported efforts to close the digital divide and expand affordable broadband for low-income households. It's a concern around the language in the bill, where it is taking an approach where it would apply the state-level retail price controls and operational mandates to these services, and that risks overstepping lawful regulatory boundaries. We've talked earlier about the competition, what it looks like in terms of broadband access now. I mean, just 5 years ago, the low income, the low Earth orbit broadband didn't exist. It speaks to significant capital investment and innovation by the countries, the companies, and so now we have this as a really great option and reasonably priced for consumers here. The proponents did mention that this measure was similar to a New York law. As they did mention, AT&T did end their 5G home internet service, to be specific on what service was pulled out. I do feel that this might lead to fewer provider options for Marylanders. We have some concerns around the requirements that the low-cost broadband offerings include at least 1.2 terabytes of data storage. Data storage is typically a component of wireline broadband service. That bill would impose an obligation on satellite services that they may not provide. Moreover, the concern looks like is that provision appeared intended to extend to email hosting or cloud-based storage, which are products distinct from broadband services that carry them. Worry is that this would then turn SB 571 into even more jurisdictional issues in terms of the fact that information services that are carried by telecoms are regulated differently. So with this, we respectfully oppose.
Thank you. Senator Ellis, you have a question?
Thank you, Madam Chair. Continue on my theme from my testimony. I think, and basically, I respect your profession and you're doing your job, good folks, and I'm doing my job. Okay. I repeatedly hear from the folks who control the resources in the state of Maryland, if we open things up, the sky's going to fall and things will fall apart and we're going to lose everything here. And I've never in 8 years seen any business pull out of Maryland because of legislation we pass here to really control some issues that affect folks, which I described earlier, the lesser of these. And mentioned that funding will go away possibly. But I just want to mention with this administration in Washington, a lot of things are going away. We had the floods in Western Maryland, and they said we will not cover, the Trump administration said we will not cover that emergency management. So that money went away. And so things go away whether we do something or not. I mean, there's nothing we can do in Maryland and throughout the U.S. to stop the bleed. So the question is, what can we do with the companies that are here to help people who desperately need these services, like those who cannot afford these services, right? I'd love to work with you to say, hey, well, how can we get to some amendments to really provide these services to these folks? Because in addition to poor folks who can't afford this historically, we have a lot of educated folks in Maryland who got fired by the Trump administration, especially black women with PhDs, high-level jobs, fired. And there's an article today from the AP on WTOP website talking about how the black unemployment is double that of white unemployment. And it talked about the results of actions coming out of the federal government, which is impacting members in our community. So people who could afford broadband, now they really can't. And so the question is, how can we stand up for these members of our communities to be able to have the service, for the children to do homework, for them to apply for jobs, right, on the internet, because it's no longer mailing in the resume, right? You send it electronically and basically AI sorted and ranked it, all that stuff. For seniors to make a doctor's appointment. So that's what we're looking at right now, how to get to a yes, right? Because we have to get to a yes for this growing population of Maryland citizens in rural areas. And so is it possible, I'm not sure which one, I don't want to pick up anyone who can handle that. Is it possible for us to do the work here in Annapolis to get to a yes, to take care of the lesser of these?
I appreciate the points that you're making, Senator. I really do, and certainly empathetic to the goals and what you're seeking to do with this legislation. I think respectfully, as you heard from Jeremy and even earlier testimony, and the BEAD funding, there is a risk. We're currently getting it in Maryland, federal BEAD funding. And there's a strong belief that if something like this were to move forward, based on what we've seen in other states, that it could be at risk. So I would say that kind of number one is a big concern that we have, and I think a legitimate concern. The second thing I would say, and Senator Hershey touched on it, and Jeremy touched on it, and I touched on it, and I think one of the proponents also touched on it as well. When you're looking at wireless broadband, I mean, the wireless industry as a whole, the costs have come down over a 10-year window, a 5-year window, a 2 to 3 year window. And I say that to say, you know, there are a lot of providers in Maryland that are competing with each other fiercely to try to get the customers, and they're making the investment. And that investment is also in the wireless broadband arena. And we think that those costs are coming down as well to ensure, like you said, you know, that kids can do their homework, that people can do their telemedicine. But in addition to that, I mentioned in my testimony, you know, that many of these providers in Maryland, they do have programs. And I'd be happy to have them sit down with you if there are constituents or groups or whatnot, that we can kind of, you know, help maybe direct those programs to those individuals. I think with the legislation specifically, we have concerns about the federal funding, but we also have concerns that it can have unintended consequences. And in New York, which was mentioned, that bill did pass a couple years ago. It's being implemented. I think it's about a year plus in implementation. I want to say it was January of 2025. AT&T did leave that market. They didn't leave it willingly or wantingly, but they left it because, you know, the law that was on the books, and that's a real concern here as well. We want to ensure a competitive environment.
Thank you for that. I appreciate that.
Thank
So according to the testimony, I think Ms. Herrera from Montgomery County Department of Technology and Enterprise Business said in New York, the AT&T did not leave the state. They pulled one program. I think that was a testimony.
Jeremy might be able to address that specifically as CTIA, if he may.
So, Senator, you said ask Jeremy? Okay, Jeremy?
Yes, Senator. So I respectfully, I don't want to misrepresent what the previous witness said, so I will just go off what I heard. It is a fact that AT&T has a fixed wireless offering that was available in New York State. It is now no longer available in New York State.
One offering.
That's part one. What I heard her say is that they still offer, specifically I heard her say, mobile and cellular. That is different than broadband. Mobile and cellular, Rob, I won't grab your phone again, but mobile and cellular, we are talking about cell phone plans. We are not talking about internet to your home via a fiber cable or fixed wireless. Those are and that distinction is very important.
Yeah, and she also said, Ms. Herrera, that funding has already decreased from her experience at a government agency in Montgomery County, our largest jurisdiction. And so she did say the BEAD fund already decreased with what's coming out of DC. And so basically, you know, we are trying to help those people who have lost funding anyway. So anyway, in the interest of time, I will follow up with you. We always talk. Yeah. And so let's follow up. And you reached out to me in advance with your testimony and stuff like that. So thank you for helping me prepare for you.
At your service.
Very professional. And thank you, Madam Chair.
Thank you.
I just, you know, I'm not as smart as you are, Senator Ellis, but I go to Google a lot. So I Googled and I asked the question about BEAD funding. And the first thing I get is conflict with federal policy. The NTIA has clarified that states receiving BEAD funds cannot impose rate regulations. So that's just what Google says. Thank you, gentlemen, for your testimony.
Thank you, Madam Chair.
That ends the hearing on Senate Bill 571. We're now going to go to Senator Lamb and Senate Bill 504, data privacy. Senator Lamb, your committee is Stephanie Wolf. Your panel, Stephanie Wolf, Laura Moy, Cody Vensick, and Lily Garcia. Did I get that right?
Thanks.
Person here, so I'm going to sit the farthest away from you.
Hey, we haven't. Okay. Sure, thank you. I think we have everyone at the witness table that we need for the sponsor panel. Oh, there we go, one more. All right. So good afternoon, Chair Bidle, members of the Senate Finance Committee. Here to introduce Senate Bill 504, the Data Privacy Act of 2026. For the record, Clarence Lamb Center in District 12. So, to preface this, and I know that we had passed legislation a couple years ago dealing with data privacy as well. Our colleague here in the committee also had addressed things through the Maryland Online Data Privacy Act. I'll reference both of these in the testimony. I think the environment currently is a little bit different given what we've seen take place over the last year or so. There's certainly a lot of concerns with ICE as it continues to act in a seemingly manner that has very little guardrails across the country, and some concerns here in Maryland. And as we saw earlier this session, we did take steps to ban 287G agreements in the state of Maryland. But what we've seen from ICE is continued efforts to try to get data to be able to support its deportation efforts, oftentimes without proper guardrails in place, oftentimes in a very chaotic kind of fashion and manner. In 2021, after it was reported that ICE was using Maryland's MVA database, the driver's license database that the Motor Vehicle Administration has for facial recognition, this body passed the Maryland Driver Privacy Act into law. This new law required that all state agencies deny access to individuals seeking data for the purpose of federal immigration law enforcement without a warrant. This set a baseline level of protection that no Maryland resident would have the federal government accessing their data without a judge's approval. In November, there were 40 members of Congress who wrote to Governor Moore about ICE's continued real-time access to state data through the International Justice and Public Safety Networks, known as NLETS, which is a message switching system, for those who may be technically familiar with that. Although our state agencies are required to prohibit access by ICE to databases in their control, there has been confusion if these, when it comes to NLETs and these message switching systems, whether ICE is able to access them versus directly requesting the data from one of our state agencies directly. Additionally, we have heard reports of ICE using data purchased from third-party data brokers as a way to circumvent data privacy laws. This year's bill would close these current loopholes and also eliminate any gray areas, making the message clear that when it comes to ICE or any other federal immigration enforcement agencies, that it should not be allowed to access Marylanders' personal and private information that has been entrusted to the state in state databases, including things like our unemployment database, tax records, vital records in the health department, and the like. This act prohibits the sale of personal data by any data brokers if the controller of that data, if the department that holds the data knows that the purchasers will use the data for immigration enforcement purposes, and it also requires good faith efforts to ascertain the purposes of data purchases. It also expands the definition of forbidden sales of sensitive data and prohibits message switching systems from allowing access to warrantless immigration enforcement. We have heard from various tech companies and some retailers about certain concerns about how this bill would modify the Maryland Online Data Privacy Act, and we are open to continuing that conversation with them. None of those groups have expressed any opposition to limiting ICE's access to data that they hold, but just want to make sure that they can implement the requirements of this were it to pass. We also have heard from departments within our state who expressed concerned about the bill requiring them to deny access to state-held data when requested by ICE. This is a little bit perplexing and also concerning because that requirement has already been in place since 2021 when we passed the original Maryland Driver Privacy Act. The only real change that applies to various state departments in this bill is language that clarifies that they should make reasonable attempts to identify if a data request is related to immigration enforcement. I have asked various state departments for some more specificity regarding their concerns, but it does not seem like we would be requiring a significant amount of increase in work. I'll highlight another, letter that was brought up by the Maryland Judiciary, again, citing the effort required to be able to implement this. Again, a little bit confusing because the existing statute already requires them to implement many parts of this. In fact, it probably should not add any more effort onto this. So if they're having issues coming into compliance with this proposed legislation, it seems to indicate that they may not even be in compliance with existing law. So happy to continue that conversation with the Maryland Judiciary as well. With ICE's current access to Maryland data, Marylanders continue to be at high risk of privacy violations without even knowing it. This bill protects Marylanders' privacy without hampering legitimate law enforcement collaboration. 5 other states, including Illinois, New York, Massachusetts, Minnesota, and Washington, have already taken steps similar to this bill, and it's important that Maryland joins them. I request a favorable report on SB 504. Happy to pass along other members of the panel to take questions at the end. Thank you.
Senator, who would like to go next? Okay, then we're just going to go right down the aisle. Thank you.
Thank you, Senator Lamb, for your continued commitment to police safety. My name is Lady Garcia, and I serve as Director of Health and Human Services at We Are CASA. For 40 years, CASA has stood alongside working class and immigrant communities in Maryland. Our members are parents who wake up before dawn to work at construction sites, poultry plants, hospitals, and homes. Our members pay taxes and start small businesses. Our members sit in classrooms learning English at night after lunch shifts. Yesterday, many of those families are living in fear because personal information they provided in good faith can be weaponized against them. This is not abstract. Immigration agencies use commercial and government data to locate and target individuals. License plate scan, facial recognition match, state database search. Information collected for a routine lawful purpose can become a roadmap for deportation. In 2020, a longtime CASA member was arrested by ICE agents, used information he had provided to obtain a driver's license. He had lived here for decades, no criminal history. He did exactly what the state requested to do and comply with the law. The same information he submitted in good faith was later used against him. Through our employment, English, legal, health, and tax preparation services, we serve over 1,800 Marylanders every month. We hear the same question again and again. Will my information be shared? Will my information be shared and used against my family and myself? When families fear that seeking a driver's license, healthcare, or stable employment could expose them to enforcement, they withdraw. This bill is not radical. It's necessary. It closes loopholes in current data protections. It ensures that information collected for legitimate state purposes is not utilized to harm our communities. Public safety depends on trust. Thank you.
Hi, good afternoon, Chair Beidel, Vice Chair Hayes, and committee, and thank you, Senator Lamb, for your leadership on this issue. I'm Laura Moy. I'm a proud Marylander, and I'm a professor of law at Georgetown and a scholar of privacy and surveillance law. Over the past 15 years, I've represented and counseled a number of nonprofits on these issues, and I've appeared before federal and state legislatures, courts, and agencies. I'm here today on behalf of CASA. I also worked in law enforcement before I became a lawyer, so I'm intimately familiar with how private companies power surveillance. This has always been a concern, and what we know about ICE surveillance now merely brings this into stark relief. So I'll make 3 brief points. First, ICE has access to incredibly powerful surveillance tools, including car and phone tracking, and vast databases of information. Fear of this surveillance drives people away from work, local businesses, and paying their taxes. Second, this surveillance is provided by a lucrative and politically active industry worth hundreds of billions of dollars. And third, Maryland's privacy laws are quite strong in many ways, thanks in large part to the leadership of multiple people in this room, but we do need to shore them up, which is what SB 504 would do. It would clarify that locations of phone and vehicles are always sensitive and cannot be sold. We think Maryland's privacy law already protects this data, but as you may have seen from some filings here today, some parts of industry disagrees, so clarification is warranted. It would also clarify that when Maryland shares data with brokers for a specific thing, like notifications about car recalls, that they have to comply with any restrictions the state places on that information in order to benefit from an exception to Maryland's privacy law. And it would buttress the Maryland Driver Privacy Act passed a few years ago, as you've just heard about here today. Thank you for permitting me to testify in support of this important bill, and I look forward to your questions.
Thank you. Good afternoon, Madam Chair, members of the committee. The Maryland Office of the Public Defender respectfully requests a favorable report on SB 504, the Data Privacy Act. Fears around data sharing chill engagement with important systems, not only among people who are currently at risk of ICE arrest, but also among legal residents who fear that they could soon join the 1.5 million people who were de-documented in 2025. And among United States citizens who live in mixed status households and fear that DHS could use their data to target their spouses, their children, or their parents. At OPD, our CINA attorneys have seen kinship placements fall through when relatives who are willing to care for a child are afraid to submit their information or that of their household members to the government. Our intake staff sees clients who need and deserve OPD's services, but who are afraid to provide their information to the commissioner to be qualified. Most relevant here, though, are the countless clients that we counsel who have to choose between a driver's license that they need to get to work, to contribute to our economy, to take care of their families, and that the state wants them to have. They have to choose between that and keeping their data safe. We've also seen the opposite. We've seen citizens who do, or Marylanders who do place their trust in our institutions and give up data and then have that data provided in good faith used against them. Like when ICE was targeting one man and put together a packet listing all of his neighbors that they thought might be deportable. DHS cited a Maryland state identification card classified as not for federal identification. In other words, the fact that he had a Maryland non-compliant driver's license as the justification to arrest a neighbor of the person that they were targeting. By addressing the role of message switching systems, this bill strengthens the Driver Privacy Act and will enhance public safety. Thank you.
Madam Chair and members of the committee, thank you for the opportunity to testify in support of SB 504, and thank you to Senator Lum for his leadership in introducing it. I am Cody Vensky. I'm a senior policy counsel with the American Civil Liberties Union, where I lead our policy work on data, privacy, and artificial intelligence. My colleagues have shared the harms from open access to our data and how this bill would protect vulnerable communities. I would like to take this opportunity to stress that this bill will fill crucial gaps in existing laws. In particular, this bill would fill gaps in a key federal law, the Driver Privacy Protection Act. Although on its surface, the DPPA prohibits the disclosure of drivers' personal information, it is defined more by its exceptions than its protections. The DPPA's 14 exceptions are capacious, allowing a wide variety of uses, including by any governmental agency, law enforcement, private businesses, private investigators, insurance brokers, and public safety uses authorized by law. Data brokers have exploited these exceptions for their financial benefit. Data brokers purchase information from state departments of motor vehicles, purportedly for the purposes permitted by the DPPA. In doing so, the data brokers acquire troves of data worth multiple millions of dollars. States and communities nationwide have pushed back against the state subsidization of the sale of our personal information. Moreover, although the DPPA purports to limit further disclosures and redisclosures of drivers' personal information, that protection lacks meaningful teeth. Immigrants' rights advocates have tracked potential pathways for motor vehicles data to ICE, and 40 members of Congress recently urged states to cease sharing motor vehicles data because of the risk of redisclosure and abuse. This bill will help ensure that Marylanders' data is not being released for illicit purposes. It will help supplement federal law by placing guardrails on the redisclosure of Marylanders' data. In this case, by ensuring that the use of our data is for our benefit and the public interest, not private financial gain. Thank you.
Senator Reedy has a question.
Yes, thank you. I just looking over the bill here, looking at page 6, nothing in this subtitle may be construed, this is current law, to constrict a controller or processor's ability to comply with federal, state, or local law regulations, comply with a civil, criminal, or regulatory inquiry, investigation, subpoena, or summons by federal, state, local, or other government authority, except to the extent that an inquiry, investigation, subpoena, yada, 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 pertains solely to immigration enforcement. I guess my question, and I'm still reading through the bill, but can we pass a law that tells a business they may not comply with the federal law? Or a federal order based on federal law?
I'm happy to jump in here if that's helpful. Yes, yeah, because I think, so one of the things that we've been talking about on this is that the goal of this provision is to mirror what is in the Maryland Driver Privacy Act, which is except for, and I recognize that this language is not currently in there, in the event that there is a warrant signed by a judge of a federal or state court, right? Either jurisdiction, federal or state. And as mentioned, that mirrors the language that is currently in the Maryland Driver Privacy Act.
But that's not in here. Is it referred to somewhere in the language? I know I'm just
that is no, that's correct. That is not currently in here, and that has been raised. That was raised a couple days ago in the other hearing, and recognized that, of course, in the event that there is a judicial warrant, then that would make sense here. I think that the concern that this provision is trying to get at is that oftentimes these capacious law enforcement exceptions are used and abused under the inquiry or investigation provision to permit law enforcement to purchase access to information that they would not be able to obtain through judicial warrant.
So is this only about purchasing, or is this bill also about just obtaining?
I think, so this bill is about both, but primarily, especially this provision in MODPA, the Maryland Online Data Privacy Act, that I know this committee did a lot of work on a couple years ago.
Yes, we did.
Is primarily about the purchase of information, again, where law enforcement uses purchase to get around the Fourth Amendment warrant requirements.
And maybe it's you can refresh my memory. So I remember the bill about the driver's license privacy. How is that not a violation of the Supremacy Clause? I know we're saying, is it because we require the judicial warrant in the law?
Yeah, the Maryland Driver Privacy Act from 2021 requires a judicial warrant. So if a judge signs a warrant, then to look for a specific individual or piece of information, then they can go access that information. The state would permit that, but it has to be signed by a judge.
Right, okay, but that deals with the state. So this is getting into an area of telling a business they may not or cannot comply with a federal law. Right? That's piercing a different veil, so to speak, right? Like this is
data that the business or these third-party data brokers are obtaining from the state. So this is our ability to control this data is because the origins of this data are coming from us.
So this bill does not deal with data that a business has, that it's its own data it's obtained legally from consumers.
If big data company wants to scrape the internet for information on their own, they can do that. There's nothing stopping.
But if they've obtained the data from the state somehow?
Correct.
They can't resell it to the federal government?
Because we can control or put requirements or restrictions in place on those who obtain the data from us.
So this bill is only about data that we are selling to data brokers? Or
we are not necessarily selling to data brokers, but they can access that data.
Can you give me an example of the kind of data? Can someone give me an example of the what data? I understand the data broker thing, and I understand the driver's license issue, but what data is this that people are getting from the state? I know the state doesn't sell data to people. At least I don't think so. So what data you can, other than like if you can, we're all entitled, we can go get a voter list, a voter file list, and you have to pay a fee for that, but that you're not allowed to use that for a commercial purpose. So what data are we talking about?
I'm happy to jump in here, Senator.
Please,
the most common example of actual data sales, and it does create millions of dollars of revenue exchange from data brokers to the state, is driver information. And this includes all the information you provide to the MVA in obtaining a driver's license. So if you look at some of the information that is on the face of your ID, including organ donor status, height, weight, address, that is all often readily available. Some of it under federal law is sensitive and slightly more restricted, but it is available for purchase through a web portal from the MVA.
So my personal driver's license information, how much I weigh, or which sometimes fluctuates during these legislative sessions, or how much, what color of hair I have, or if I'm an organ donor is a great example. So so I can go buy, if I'm a data broker, I'm a business that wants to market to people who are organ donors, I can buy that from the state?
Yes, Senator. And the federal law has 14 permissible purposes for which that can be purchased, and you have to indicate that you are not going to use it for other purposes.
Give me an example of purposes.
Some of the purposes include, for example, providing to private investigators in the course of carrying out their duties, providing to private businesses to confirm the identity of individuals, law enforcement purposes, which is often how this makes its way.
But you're not generally, the state is not generally allowed, a state, for example, is not generally allowed to sell information on organ donors from driver's licenses to be marketed to for living wills or something, right? That we don't do, that's not allowed.
Marketing is one of the permissible purposes under federal law, but crucially, it requires consent of the individual, and Maryland explicitly does not get consent.
Right, okay.
So for marketing purposes is not a permissible purpose for Maryland.
Okay, and I apologize for the rabbit trail, but I do think it's important to understand what we're talking about here. And then one other thing here on page 7, there's a part here about a custodian shall take reasonable steps to determine whether a person seeking access to a public record is doing so for the purpose of enforcing immigration law. I mean, what is a reasonable step? How do we define that? I know reasonable is a word we use in law. I mean, how would that be defined? How would that function in this?
Yeah, thank you for the question, Senator. Reasonable does give the state some flexibility in identifying what those would be, but on a practical matter, in most other states, and as I mentioned, under the Driver Privacy Protection Act, the federal bill, there is a process of attestation and declaring the purposes for which the data is being sought, ideally backed by penalty of perjury to ensure that folks aren't trying to mislead the state in acquiring that data, and then as well as an attestation that should not be used further.
Probably similar, so this is a similar requirement to probably what we would consider as law as it relates to people trying to purchase data that we've just discussed, right? The same kind of standard.
From the MVA, correct. And this helps block a key loophole there, which is the law enforcement purpose that's permitted by federal law, where we've seen massive data brokers acquire information from state DMVs or MVAs and sell it forward to other law enforcement agencies, including ICE.
Okay, and then finally, and thank you, Madam Chair, I appreciate it. Finally, so, I mean, I have some concerns about the broader issues, which I know we don't agree on, but is there a way to be sure we can tweak and amend this bill to be sure we're not getting private businesses feeling that they could be in trouble for doing normal course of business data trading or data selling that they're allowed to do? I mean, are there amendments being proffered, or is that, have you been, I'm just getting into this now, so.
We'd, of course, be happy to have discussions about particular concerns that may be involved there. The bill is fairly targeted in the limitations it imposes on businesses, namely, if you get data from the state, you have to follow the conditions that the state imposes on you in receiving that data, and then also sale cannot be for the purposes of immigration enforcement.
And we're not putting, in your view, we're not putting businesses in a situation, and I know they're data brokers, I know we're not talking about, you know, your mom and pop shop on the corner, but this covers probably more than data brokers. So we're not putting a business in the position of having to decide whether they're obeying state law versus obeying federal law?
That is correct. And you'll see that in the provision you pointed out earlier about the amendment regarding federal inquiries and things like that. There's a provision immediately preceding that says MOPA does nothing to interfere with compliance with federal law, and that will be unchanged here.
Okay, okay. Thank you all for your answers. Thank you, Madam Chair.
Thank you. Senator Jackson?
Thank you, Madam Chair. This question is for Liddy.
Yes.
Hi. You have mentioned that you all have close to 2,000 service cases a month. Can you share more about what the community members are sacrificing because they don't know where their data is going?
Thank you, Senator, for your question. We're talking about parents who will apply for Medicaid or healthcare access for the children. We're talking about driving license. We're talking about even SNAP applications or free lunch from schools. We also, unfortunately, even an immigrant myself came here a couple of years ago, fear to maybe my data be shared for other purposes than just the access to the services that I'm trying to obtain. So if we're talking about the specifics on the data, we're talking about everything that I need to use in order to comply with state law. As I mentioned, even parents have been withdrawing applications for Medicaid for the children just because of the fear that their information is going to be shared and misused.
Thank you.
For this panel, so I'm going to call up another panel of favorables. Tanya Moore, Denise Gilmore, Franco Mueller, Charlotte Hoffman, and Charlamar Douglas. Let's see who stayed. I might call some more people.
Madam Chair.
Yes.
Franca Mueller had to leave. She's a BTU teacher and she had to go back to her students.
Okay.
However, she left her testimony. If you,
You can give us testimony, we'll make a copy. I'm going to call three more people, there's room. Julia Fernandez, Austin Ostong, did I say that right? And Eduardo Garcia. That should be everybody, all the favorables.
Madam Chair, Julia and Mr. Fernando and I both make it.
I'm sorry, Julia and
Eduardo.
aren't here.
Correct.
All right, do you want to come up and give the testimony for Charlotte then?
I'm Charlotte.
Oh, you're Charlotte. Okay. Whose testimony do you have?
Franca with the teachers union.
Do you want to come up and give that for Franca since we're several missing? Okay. All right, let's start at your end and let's just go right down the aisle. Thank you.
Alrighty, Chair Beidel, Vice Chair Hayes, and members of the committee, thank you for the opportunity to testify in support of Senate Bill 504. My name is Tanea Moore, and I'm the Director of Policy at the Cash Campaign of Maryland. At the Cash Campaign, we help people with their finances. One of the main ways that we do that is by providing free tax preparation services through the IRS VITA program. Every year, we serve thousands of Marylanders. For the people that we serve, data privacy affects their everyday decisions. It is about whether they feel safe enough to file their taxes and apply for public benefits. Many of our clients file using I-10s. They work hard, they pay taxes, and contribute to our state. Many I-10 filers are taxpayers who are already contributing significantly to federal, state, and local revenues. According to data from the American Immigration Council, and I believe that the comptroller also referenced this in her written testimony, immigrants paid $15.8 billion in federal, state, and local taxes in Maryland in 2023. At the same time, many of these taxpayers are not eligible for the majority of the federal benefits their tax dollars support, including Social Security and Medicare. When people believe that information they give the state, like tax records, could be shared for immigration enforcement, they pull back. We see workers hesitate to file their taxes or claim credits like the EITC, even though those refunds means more money back into their pockets. This bill helps close gaps in the law and strengthens privacy protections. A clear safeguards around personal information help ensure that eligible Marylanders who pay taxes and contribute to our economy can participate fully and confidently in the services available to them. For these reasons, we urge a favorable report. Thank you.
Hi, how are you? Good evening. Denise Gilmore here, Legislative and Political Director for AFSCME Council 3. AFSCME Council 3 is the proud union for nearly 55,000 public service workers across Maryland, including in our state and local agencies, public schools, and higher education institutions. We are here testifying in support of Senate Bill 504. Senate Bill 504 ensures that there are clarity in our laws to help state employees have clear-cut understanding of their role in information sharing processes in our state agencies so that we are protecting the rights and safety of Maryland residents at such a vulnerable time. Marylanders expect that when they provide sensitive personal information to state agencies, that this information will be safeguarded. They expect clear regulations, strong oversight, and transparent procedures to ensure that their privacy is protected. That trust is foundational to an effective, accountable government. I have spoken to several of our members about this bill. They are deeply concerned about the gaps that it addresses. Our state workforce reflects the diversity of Maryland. Many of our members are immigrants themselves, or they come from immigrant families. No state employee should have to worry that routine administrative work could indirectly contribute to harm in their communities. Senate Bill 504 establishes additional privacy protections at a time when mass surveillance and unchecked data sharing pose growing risks to all Marylanders, not just immigrant communities. This bill strengthens public trust, protects workers, and ensures that state government remains a place people turn to for services and support, not a source of fear. For these reasons, I respectfully urge you to issue a favorable report on Senate Bill 504. Thank you.
Good evening, Madam Chair, Vice Chair, members of the committee. My name is Ninfa Madre Hernandez. I'm a policy manager at CASA, and I am here to provide oral testimony on behalf of Ms. Franca Mueller-Paz from the Baltimore Teachers Union, and I am reading her testimony. The Teachers Union, which she represents, supports over 9,000 members and is in favor of SB 504, the Data Privacy Act. I want to share a story, sadly, one of too many, of how my students are being exposed to terror by vulnerabilities in our state's privacy laws that are being exploited by ICE to target vehicles. Just before Thanksgiving, a student contacted me pleading for help. She was given permission to share her message. She has given me permission to share that message. She wrote to me, "My father was on his way to pick me up so we could attend an open house at Micah. He was taking a long time, so I checked his location and I saw that he was on a bridge and hadn't moved for a while. I called my mom because I was getting worried, and she told me, 'Wake up your sister. I think ICE detained your dad.' We rushed out of the house and got to the location where the phone said he was at. When we got there, we saw his work truck, and the window from the passenger seat was completely broken. He wasn't there, only his truck. We searched for his phone and found it in the middle of the road. We checked for his camera roll and saw that he had recorded a video, and in it, we can see ICE clearly smash his window. My dad tried his best to record, but since he was scared, he dropped his phone. But you can still hear the agent mocking my dad and laughing at him. My dad asked, 'Could you give me something? I'm bleeding.' And he said, 'You did this. I'm bleeding. You did this to me.' The agent laughed and he said, 'No, you did this to yourself.' He then grabbed my dad's phone and threw it in the middle of the road. The sheer number of stories of our non-citizen community members being stopped in their cars tells me that license plate data is being used to target and terrorize them, and that is why the Teachers Union exhorts Maryland must not be complicit in this desire to use our personal data to perpetrate violence and supports SB 504.
Thank you. Go ahead.
Good afternoon, Chair Baido, Vice Chair Hayes, and members of the committee. My name is Austin. I'm currently proudly serving in the Maryland Army National Guard. I live in Prince George's County, and I'm glad to be sharing my story today. I came to Maryland in 2020, fleeing persecution from my country, Cameroon, because my life was in danger. I applied for asylum, and I'm grateful that it was granted. I'm also grateful that the rest of my family could join me. Maryland became our home. I joined with CASA the moment I set my foot in this country. But today, my wife and my oldest daughter, to date, do not have a status yet. And despite everything we have built here and my services to the state, we live in fear. I am afraid that every time my daughter goes to school and signs up for new programs, her information could be shared. And I'm afraid that every time my wife fills out a form, even one meant to help her, it could put our whole family at risk. No family deserves to live like this. But this is not just my story. Across Maryland, CASA members and immigrant families are afraid too. We are being asked to trust that our private information will not be weaponized against us. This is especially dangerous because people like me, who came here fleeing their home country, are now or soon going to be undocumented because the Trump administration is canceling so many temporary protected statuses, refugee statuses, and more. It will increase the number of people living without status, not because they committed crimes, but because protections are being taken away. When legal status changes overnight, data privacy is important. We don't want any special treatment. We are asking for one thing. When we give our information to the government for one reason, it should be used purposely for that particular reason. I urge you to vote yes to Data Privacy Act. Thank you.
Thank you, Chair, Vice Chair, members of the committee. Charlotte Persephone Hoffman here on behalf of Trans Maryland today. So first, I want to completely sign on to everything that has been said so far. There have been so many strong statements and personal stories that I think have touched a lot of us in this room today. And so we sign on to everything that's been said so far. I also wanted to hit on, however, some of the other ways that this bill is going to help people from marginalized communities other than immigrants within Maryland. This does strengthen some of the protections, especially at the state data sharing level, for people who fall under one of those categories, protected categories that are statuses that are considered, I'm blanking on the precise term, I'm sorry, but the protected statuses. And one of those is people who are of transgender or non-binary status. Now, over the past half decade, Trans Maryland has helped about 2,000 Marylanders update their identity documents. And what we've seen over the past year is a lot of people coming to us and saying, is it safe to change our names on our driver's license? Is it safe to, update our birth certificates? Is the Trump administration going to take this information and come after us and our family members and our kids and, do all sorts of horrible things to us that, in fact, they are doing in some cases? And we have to tell people there are protections in place. It should be fine. You will be safer with an ID than without one. But we understand their fears. Their fears are reasonable. And this bill will help to alleviate some of those fears, to erase the current policies that are causing some of that concern in the first place. Thank you.
Do I have any questions for this panel? Seeing no questions, that ends the favorable panel. We have an unfavorable, Sarah Sample from Mako. And Kelly, do you mind coming up with your information at the same time? Kelly Locklear, here she is, thank you. And then the rest will be virtual. Thank you, ladies.
Want me to go? Good evening, Madam Chair and honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are signed up informational. We understand the intent of the bill, but after further review have some concerns here. Our original focus, as Senator Lamb mentioned, was to make it abundantly clear that the sale of data would have to be knowingly made. But I do need to point to what Senator Reedy brought up, found on page 6, lines 11 to 13, and that language needs to come out of the bill. By prohibiting private retailers from responding to a valid federal subpoena, the state would be entering an area exclusively governed by federal law. Congress has authorized federal agencies to issue subpoenas, and under the Supremacy Clause, a state cannot override that authority by barring private parties from complying. Doing so creates a direct conflict with federal law. Courts, however, have upheld laws allowing states to decline using their own resources to assist federal enforcement under anti-commandeering principles. However, those protections, and I need to be really clear about this, they apply to state and local governments, not to private businesses. Courts have not extended anti-commandeering doctrine to laws that prohibit private actors from complying with compulsory federal process. Flat out, a retailer facing a valid federal subpoena should not be forced into a no-win choice: violate state law or risk federal penalties. And finally, retailers are just not in a position to assess or second-guess the purpose of a federal investigation. When presented with lawful process, their obligation is to comply, not to speculate about the underlying enforcement objectives. Glad to work with the sponsor and the committee and answer any questions. Thank you.
Thank you.
Thank you, Chair, members of the committee. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we are here in respectful opposition to Senate Bill 504. We have no quarrel or problem with the concept of protecting sensitive information. That is something that we do regularly, and anytime that the General Assembly puts something new into law that we've got to deny or redact, that's every day, and that's not an issue. The two major concerns that our members have brought up on this is one that has to do with denying court-issued warrants. I won't dive too much into some of the conversation that we had around that, but there's definitely a gray area that is of major concern to us, and we've already heard it discussed a little bit today. The second major thing, I think, is at the bottom of page 7 that has also been brought up, is the sort of requirement that you have to have a custodian do what sort of to our attorneys sounded like somewhat of an interrogation to figure out the purpose and the intent of the request, and then potentially deny the information that would be otherwise lawfully available if it's for the purpose of immigration enforcement. And that is something that we're worried it's putting our custodians in a position where they're making a guess and they're personally liable for mistakes that are made. And this is also in a situation where an individual who's making a request could misrepresent who they are, and they could misrepresent the purpose of why the request is coming in. So those are some of our major concerns. We also think that that sort of back and forth interrogation sort of process could create a backlog, and we have to get requests out by a certain time. So those are some of the major concerns that were brought up. And I think one of the things this really comes down to is that the MPIA was really built to be an objective process, and this just inserts a little bit too much subjectivity into it when they have so much personal liability, and the bill doesn't address that or a good faith action. So those are the major things. We have spoken with the advocates. And if there's a way to make this less about the reason the person's requesting the information and more about the information that has to be denied, we can absolutely work with them on that language where we would be totally comfortable with that. Thank you.
Thank you. Senator Mount.
Thank you, Madam Chair. You might not be the right panel to answer this question, and I understand where your input, the angle of your input and how this works, but what is the legitimate reason for the state to sell your MVA information?
I don't know. I was surprised to hear that.
Yeah,
I'm with the counties.
I'll plead ignorance. I had no idea that.
Yeah. We don't know either.
No. Thanks.
Senator Lamb.
Sure. Thank you, Madam Chair. This question is to Ms. Sample. The current law, requires custodians to reject requests that are made specifically for the purpose of immigration-related enforcement. So how do your members comply with that requirement now?
So the way that I understand the law, based on where the bill is adjusting, I think stuff that was passed last year, is that there's the provision that says you have to deny if it's from a federal agency, and I think it's changing it to person this year, and we're taking that to mean that you deny it in this situation without a judicial warrant for the federal agency or agent, but this is making it person, which could be anybody. So now we're having to apply that to every single request, and that was where that scope of concern was coming in.
So right now, if a person requests it, you do not deny that?
If a person requests and says specifically that they're asking for it for the purpose of immigration enforcement, then that would have to be denied, as I understand it. But what I'm getting at is that if they could misrepresent who they are and what their purpose is, and that's where that back and forth, we start to get concerned that they're going to have to be making a guess in a very gray area when they have personal liability.
But how's that different than what folks are doing now? Because they have to kind of gauge denials based on the purpose right now in existing law.
Not for every single request. And I don't think that is how we read what was passed. And that's consistent with how our attorneys read it.
Well, the existing law says a person receiving personal information under subsection D, E, and F may not disclose the personal information to a federal agent or government agency for the purpose of immigration enforcement unless the person is presented with a valid warrant issued by a federal court or court of this state. That's existing statute, right?
Yes.
So this denial is already required based on you're kind of gauging what the request purpose is, right, from this.
Right now, as I understand it, and it's also in the fiscal note from the state agency, from the judiciary, I believe it is, that the way that the law is currently written, and I'm not sure exactly the part of law that you're talking about, I'm referencing specifically what is in the written bill, is that it's not for every single request that they have to do this sort of assessment of what's the intent for the request.
So for one to come from a federal agent right now, how do you tell the purpose of that request?
Well, that would have a back and forth, a discussion about what's the purpose, because that's what the law requires from a federal agency.
So how would that be different if it were a person?
Because it could be, well, one, a federal agent or a federal agent acting on behalf of a federal agency could misrepresent their purpose and their identity. And from what we understand from our attorneys, that they do actually do that. Now this means that it's just a person. And if they don't say that they're from this particular agency, then you're now having to ask this information of everybody who's making a request. And you could have individuals who are making requests that are not with federal agencies that just want to get the information and hand it over. I think that wouldn't be a stretch in context right now.
So you do know how to do it, basically. You're capable of doing the inquiry.
Yeah, I said that in my testimony.
Okay. Thank you. Vice Chair.
Excellent. Are there any additional questions? Seeing none, thank you so very much. We're going to go to virtual testimony from Margaret Durkin. Margaret, you may begin.
Good evening, Vice Chair Hayes and member of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director with TechNet, a tech trade association. Thank you for allowing me the opportunity to speak this evening on Senate Bill 504. TechNet and its member companies understand the sponsor's concern regarding the misuse of personal data in ways that may expose individuals, including immigrant communities, to harm. And we share that concern. We did meet with the sponsor of the Senate bill as well as the House version to go over some of our concerns, which are outlined in my written remarks. Primarily, we have concerns in 3 areas. First is our concern is that a controller or processor receiving lawful process from the government will not know what subject matter is behind the request for info. So in our letter, we suggested a knowledge standard. We're also concerned about how the current bill changes some of the sensitive data in the bill and references sensitive attributes. So we suggested some Colorado language. And then finally, our last focus is on publicly available information. You can find more details in my written remarks, and happy to take any questions. Thank you.
Are there any questions for Margaret? Seeing none, thank you so very much. Next, and I believe last, we will hear from Andrew. Andrew?
Hi, good afternoon, Mr. Vice Chair, Madam Chair, members of the committee. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. We're a multi-sector coalition. Really appreciate the opportunity to testify today, and we appreciate the opportunity to be a constructive partner in addressing the sponsor's legitimate concerns. We are opposing the bill as drafted, but we're hoping that we can work with the sponsors to find a solution, provides a little more clarity while still fulfilling the intent of the bill. I do want to clarify that the provisions that would amend the Maryland privacy law are indeed about the data that businesses collect and process from consumers and not about a business-state relationship. And also just want to make sure that we emphasize that Maryland's privacy law already bans the sale of immigration data and precise geolocation data by controllers. And sale is very broadly defined here to cover virtually any transfer of data. We do have similar concerns to what my colleague just mentioned in terms of the legal process provision. We understand that the sponsor is going to rework some language, so look forward to seeing that. We also wanted to just flag the inclusion of mobile device and automobile in the definition of precise geolocation data. And we just believe that this is not necessary because the bill governs personal data that attaches to an individual consumer. And whether that's through a phone or a car or a fitness wearable or a smartwatch, we don't believe it makes sense to include specific devices in this definition because the bill is about all personal data. And if data falls within the outer bounds of this definition, which is that it can reasonably be linked to an identifiable person, then it's within the scope of the law regardless of the device it's derived from. So again, happy to answer any questions on that. We cover this in our written remarks, and thank you for the opportunity to testify.
Thank you. Are there any questions? Seeing none, this ends the testimony on Senate Bill 504. Back.
Senator Hester here? Is she? Okay. Senator Hester, you want to come to the table and bring your panel? Kara Williams, Matt Schwartz, Maureen Mahoney. This is Senate Bill 616, Business Regulation Data Broker Registry. Last bill of the day, and then we have voting.
Madam Chair, they're all virtual.
All virtual?
They're all virtual, yes.
Okay, I'm sorry. You're right. They're all virtual.
There they are. Thank you very much, Madam Chair, Vice Chair, members of the esteemed committee. For the record, Senator Katie Fry Hester, here to ask for your consideration of Senate Bill 616. This will establish a self-funded data broker registry in the Comptroller's office, requiring data brokers operating in Maryland to register annually and increasing transparency around the collection, sale, and licensing of residents' data. I'd like to point out that Senate President Ferguson is a co-sponsor of this important bill. As this committee well knows, data brokers are companies that collect vast amounts of personal information about individuals, including contact details, current and former addresses, health history, and even social security numbers. They take this information and compile it into detailed profiles to sell to third-party organizations for purposes such as targeted advertising. In most cases, individuals are not told that this data is being collected, who is collecting it, and how it is being used. Now, this committee has already taken powerful action to protect Marylanders' sensitive data, particularly with the passage of the Online Data Privacy Act, which established critical guardrails for how corporations may collect and use personal data. SB 616 builds upon this strong foundation by implementation of both existing and future regulations. Currently, we lack a clear system to identify which entities are brokering and profiting from a resident's data, which limits accountability and creates an obstacle in the state's ability to levy taxes or fees. The Online Data Privacy Act covers direct consumer data collection, but not the downstream uses of this data. And that's the gap that this bill seeks to correct through the creation of the self-funded data broker registry. Under this bill, the brokers would be required to register with the comptroller and to disclose whether they collect especially sensitive information, such as health or precise location data. Brokers would also be required to report whether the consumers have the option to opt out or some of all of the data collection, and the process for doing so if one exists. The registration expense would be covered by the fees assessed by the comptroller, ensuring the program does not unduly burden taxpayers in the state. This approach is not without precedent. Vermont, California, Oregon, and Texas have all successfully implemented data broker registration programs, and several more states have programs in the works. Like Senate Bill 616, these bills all define personal information and data brokering and require the brokers to register annually with the state, disclose the types of data they collect, and pay a fee. Establishing a data broker registry eases the process of implementing the existing privacy protections and ensures that these brokers remain accountable to the state. This registry is an important measure if effectively regulating a powerful and growing industry and sets the stage for Maryland to implement further guardrails when needed. For example, it could be used to levy an appropriate tax on these brokers or restrict their ability to profile Marylanders using artificial intelligence. The data broker registry is a necessary first step. Last year, a similar version of this bill was sent to the Senate Budget and Tax Committee because it included both the data broker registry and a tax to fund enforcement within the Attorney General's office. After thoughtful consideration, we decided to take a more measured, phased approach. This bill focuses on the first and logical step, identifying and registering these data brokers operating in Maryland. You cannot effectively regulate what you cannot see, and establishing a transparent foundation is key to any enforcement work. In future phases, if we determine that the dedicated enforcement funding is necessary, the General Assembly could consider incorporating that support through an adjusted registration fee or a separate funding mechanism, including a potential tax. In closing, colleagues, Senate Bill 616 is the opportunity to build on previous legislation and do the right thing for Marylanders, ensuring they receive the transparency, accountability, and privacy they deserve. If you're concerned about the data privacy of your constituents, I ask you to consider voting for this next modest step of regulation. If Texas can do this, Maryland can as well. I respectfully request a favorable report of Senate Bill 616.
Thank you, Senator. Should we hear from the rest of your panel, and then we'll take questions? Okay.
Please.
So if we can go to Kara Williams, if you can unmute and give us your...
Thank you. Chair Beidel, members of the committee, thank you for the opportunity to testify today in support of SB 616. My name is Kara Williams, and I'm an attorney at the Electronic Privacy Information Center, or EPIC. EPIC is an independent nonprofit founded over 30 years ago to secure the fundamental right to privacy in the digital age. EPIC supports this bill because establishing a data broker registry in Maryland is the first step toward protecting residents from the invasive and harmful practices of the data broker industry. Data brokers are companies that most people have never heard of, yet their entire business model is to profit off of our personal data. These entities have no direct relationship with us, yet they collect, compile, and sell massive amounts of our often sensitive personal data. Requiring the brokers to register with the state will provide some level of transparency to an otherwise completely opaque industry. But to further protect residents from the harms of data brokers, EPIC recommends a couple of key amendments. First, the bill should be amended to add a provision to give Marylanders the ability to use a centralized deletion mechanism to request that data brokers delete their personal data. Right now, Californians have this right because of a measure called the Delete Act. A centralized deletion mechanism became available to Californians on January 1st of this year, and it has already been wildly popular. In just the first month of operation, 215,000 California residents have used the platform to request that data brokers delete their personal information. Maryland residents deserve this same right. Second, EPIC echoes the recommendations of the Attorney General's office that the exemptions in the bill be removed or significantly narrowed to ensure that all entities acting as data brokers are covered. Data brokers are among the worst offenders in terms of entities who abuse our privacy, and they should not be able to remain hidden while exploiting and profiting from our personal data. EPIC urges a favorable report of SB 616 to shine a light on the data broker industry and as a first step toward more protections for Maryland residents. Thank you.
Thank you, Karen. Matt, are you ready?
Yep. Madam Chair, Vice Chair, members of the committee, thank you for inviting me to testify today. My name is Matt Schwartz. I'm a policy analyst with Consumer Reports based in DC. Consumer Reports supports SB 616, which would create a Maryland data broker registry. You've heard plenty about data brokers already today, but to reiterate, data brokers are entities that, without our knowledge, aggregate extensive dossiers about us that include thousands of data points, including extremely granular information about our behavior, as well as those companies' inferences about us based off of that data. By definition, consumers rarely know the identities of such companies, let alone how they collect and use our personal information. SB 616 is a simple bill that would at least allow consumers to understand these basic facts. As you've heard, it mirrors similar laws in Texas, Oregon, Vermont, and California. As Kara mentioned, ideally, this type of registry would also ultimately be paired with a universal deletion mechanism, which would allow consumers to actually delete their information from such data brokers in a single click. California has such a mechanism called the Delete Act, and we'd urge the committee to consider whether Maryland could ultimately adopt a similar approach. As a first step, though, a data broker registry is a great idea. We do believe some minor definitional tweaks may be in order to ensure that only those that collect and sell data about consumers without a direct relationship is considered a data broker. And we'd also align ourselves with the written testimony of the AG's office that argues that there should be much narrower exemptions in the bill. If businesses are engaging in the practice of data brokerage, they should be covered, whether or not they may be subject to unrelated federal laws. Ultimately, this legislation is an important first step in providing consumers with transparency about an industry that traffics in their personal information. We urge you to approve it, and we welcome any questions you may have.
Thank you, Matt. Maureen?
Thank you, Chair, members of the committee, for the opportunity to speak today. My name is Maureen Mahoney. I'm the Deputy Director of Policy and Legislation at the California Privacy Protection Agency. And while we can't take a position on legislation, I'm happy to talk about the California Data Broker Registry and our experiences in implementing the Delete Act that was referred to today. The California Data Broker Registration Law, called AB 1202, it was adopted back in 2019. It went into effect in 2020. And it tasked the California Attorney General with building the Data Broker Registry. And then in 2023, California adopted the Delete Act, which transferred the Data Broker Registry to our agency. In our experience, the build of the public registry was a relatively light lift. Our team built the registry in about 3 months. In terms of metrics, our records show that there were 507 data brokers registered in California as of April 2025. While this was the largest number of registrations compared to the 3 other states that had a registry, we knew it likely fell short of full compliance. So in late 2024, our agency initiated an investigative sweep of data broker registration compliance. And then 2025, we further established a data broker enforcement strike force. And this work has resulted in over a dozen enforcement actions against data brokers for failure to register. And this work has likely incentivized compliance. As of February 2026, there are now over 570 data brokers registered with our agency. And additionally, California's 2019 data broker registration law served as a jumping off point for further data broker regulation. For example, the Delete Act charged our agency with developing a first of its kind mechanism where consumers can submit a single request and have their information deleted by all registered data brokers. This platform, known as Drop, launched in January, and as Ms. William noted, it's been very popular among consumers, which really demonstrates the pent-up demand for tools that make it easier to exercise privacy rights. And it all really started by bringing data brokers out of the shadows with a registry. Thank you for your time.
Thank you. So do I have any questions for the senator or her panel? Seeing no questions, thank you very much.
Thank you very much.
We're going to have Kelly Locklear on just information, Kelly, and then we'll have Margaret Durkin virtually. Thank you.
Good evening again, Madam Chair and honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance with informational testimony. I did reach out to the sponsor. We are glad to work with her and the committee. I just finished the red line while I was sitting here in committee earlier today and sent it over to her office. And actually, kind of like the proponents were touching on, what we're searching for is alignment with other states. So the language that we used and proffered to the sponsor centers around Oregon, and I'm glad to send that to the committee as well. But by aligning definitions, for example, around whether revenue must be primarily from selling data, whether selling includes sharing, whether first-party data is included, whether employee data counts, all of that matters. And with multi-state laws, businesses face inconsistent triggers for regulation, audits, deletion obligations, and disclosure. So alignment ultimately reduces costly legal interpretations and risk of accidental non-compliance. So we look forward to working with the committee and the sponsor. Thank you for your time.
Thank you. Do I have any questions for Kaylee? I don't see any questions. Okay, finally, we have Margaret Durkin, unfavorable. Margaret, you're going to earn that title Dr. No here pretty soon.
I understand. Unfortunately. Good evening, Chair Bidel and members of the committee. Margaret Durkin with TechNet again. Thank you for allowing me the opportunity to speak on Senate Bill 616. We submitted comments to the sponsor as well as the committee. Overall, we believe that Senate Bill 616 is overbroad, and especially the definition of data broker, which includes any business that collects data, which would encompass many businesses. A lot of the terms in the bill do not match with Maryland's underlying privacy law, and similarly to previous speakers, we would suggest the Oregon model, as we believe that that's a better approach. It establishes a registry that is properly calibrated to include the companies that are actually data brokers while ensuring that the rest of the business community is covered by each state's respective underlying data privacy law. It's important to note that TechNet members include both data brokers that do fall under the Oregon law, as well as some of our members that do not apply as data brokers under Oregon law. Thank you for the opportunity to speak tonight and happy to take questions.
Margaret, thank you. Do I have any questions for Margaret? Have a nice evening. Thank you for hanging around. We appreciate it.
Thank you, you too.
So this ends the hearings for today. We're going to give Tammy 5 minutes and then we're going to vote. Thank you.